Here we are, the first day of the sentencing phase. This is day 53 now of the Aurora theater shooting trial. Marshall Zellinger here, Andrew and Anika playing along, Anika on Scribble, Andrew pushing the buttons. What we have today is the first and likely second phase of a three-phase sentencing process in Colorado. The sentencing for either life in prison or for someone facing the death penalty goes through three phases, and if you've been watching over the last couple of days, you've heard the instructions being dealt with and the rules being talked about outside of the presence of the jury. This will be the first time that jurors come back into the courtroom since Thursday, when they all unanimously agreed that the defendant was indeed guilty of 165 different counts, 24 dealing with murder, 140 dealing with attempted murder, although 6 of those counts were changed to, or were given a lesser charge of attempted second-degree murder, and then that one charge dealing with explosives at his apartment. So what's going to happen today? Phase 1 is essentially aggravating circumstances, the aggravation phase. All that has to be proven is one of about 4 different things to prove that crimes were committed that meet the criteria for a person to potentially face the death penalty. One of those criteria is the intentional killing of someone younger than 12 years old, essentially by the jury finding him guilty of murder in the charge dealing with Veronica Mosier Sullivan. It's already been met, but we still have to go through this phase. And talking with David Beller, one of our legal analysts last week, he said the defense could simply stipulate, yes, we agree that the aggravation has been met, let's move on to phase 2, although the jury gets to deliberate after each phase. They get to go back into the deliberation room and figure out, okay, is the evidence there that we can move past phase 1? Let's all vote. And if even one person says no, this process stops and the defendant gets life in prison and no longer faces the death penalty. Phase 2 is the mitigation phase. That's when you're going to hear from people who will defend the defendant and try to essentially pass along to the jury who he is, so that they may not want to sentence him to death. And phase 3 is, we get to phase 3 if the jurors believe that the aggravating factors outweigh the mitigating factors. Again, after phase 2, if the mitigating factors are deemed to be more, that maybe some problems in his life outweigh what he actually did, we would stop there, and again, life in prison would be the sentence. Phase 3 is when the district attorney gets to bring up family members of those killed and injured in the shooting, and ultimately then the jury would decide life or death. The court should be getting underway in about 5 minutes or so. What we want to do, it's kind of like a sneak preview because the jury hasn't seen this yet. You have seen it if you've been watching over the last couple of days. There was at least one person that could not be in court when the defense needed them, assuming we get to phase 2, the mitigation phase. This person was the 5th grade teacher of the defendant. They did a taped deposition. They recorded his testimony to show the jury at a later time. And for all I know, this could be later today if we're in phase 2, or they may save it a few days down the line, because we know they're going to take about 2 weeks to bring witnesses, assuming we do get to phase 2 of this sentencing. But what we want to do is play back for you some of the testimony by this 5th grade teacher. And this is the type of testimony you'll hear given to the jury as to the background of the defendant. What you won't ever hear from a witness on the stand is someone pleading, do kill this person or do not kill this person. They are not allowed to say that on the stand. They're only allowed to talk about the impact of what has happened or the history of the defendant. So here's a sneak preview of some of what you'll see. And of course our Mac wants to play slow right now, and this is probably going to cut me off. It'll probably start playing, but as Anika reminded me, you'll start to hear opening statements by both sides this morning. You get 40 minutes for both sides to tell the jury what to expect during the sentencing phase 1. And then, just like you saw in the closing statements, there'll be a rebuttal as well. I'd like you to look at the second document, D-TR-98.
Now that paper actually represents 2 documents, is that right?
Yes.
And are those the types of sort of cards or notes that you would send back home to your students' parents?
Yes.
Okay, and what was the purpose in doing that?
Well, I used to try to do PR with the parents, positive PR. And so it's good to send a positive note home to parents about kids, because then when you have grief later on, you've kind of gone over the rough part and you have something in your pocket to go for. So this is a positive note to Jimmy's parents. Can I read it? It's short.
Not
No?
yet.
Okay.
Do you recognize your signature?
Oh
on
yeah,
both
these are
of
mine.
those?
Yeah.
Recognize your handwriting?
Yes, absolutely.
Is that also something that you did commonly in the course of
I
your?
still do this.
Do you recognize the stamp on there?
I do.
You still have that stamp?
I do.
Your Honor, we're going to move for admission of D-TR-98.
Any objection?
No objection.
Without objection, it is admitted.
All right. If you could read those one at a time.
Sure.
Okay.
All right, so the one is for parents. It says, Dear Holmes, thanks for letting Jimmy set up my computer with net zero over vacation. So that means we must have had a break, say, I'm going to guess, but I'll bet I'm right. Christmas vacation, he continued to work on it. So this is a thank you for doing that.
Okay. When you say he continued to work on it, what are you talking about?
The computer website.
Okay. Is that what you're referring to when it says net zero?
Yeah, net zero was the provider,
Okay.
and probably it was free back then, so that's why we used net zero then.
Okay. And the second note?
Okay, second one is whenever the kids did a project, I would always give them an assessment, and it's always good to give feedback to the kids and the parents. So I can't remember what the project was, but he did a project. So it says, great project, thorough questions, and interesting. Paul Carr, and I put an A on it, and then and a stamp, and I have my little swirl, because sometimes the kids would forge these. So it's forgery proof this way.
Is that something Jimmy ever did, or Mr. Holmes ever tried to do?
He didn't need to.
Right. You also had talked about
Good morning, everyone. This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes appears with his attorneys, Ms. Brady, Ms. Nelson, Ms. Higgs, Ms. Spengler, and Mr. King, and the prosecution is represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, Ms. Stitch McGuire, and Mr. Edwards. The record should reflect that we are outside the presence of the jury. I have a few things on my list of housekeeping issues. The first thing that I want to do is ask counsel if they received the latest, what should be the final draft of the instructions, which my staff emailed yesterday at about 5 o'clock. Did the people receive them?
We did, Your Honor. We have no objections, additions, deletions, modifications, or suggestions.
Okay, and no additional instructions to tender?
Correct.
Any objections or any additional record you want to make with respect to the verdict forms?
No, Your Honor.
All right. Did the defense receive the instructions and the verdict forms, Ms. Nelson?
We did.
Okay. Any additional record or objections or any additional instructions that you want to tender?
I do have just a few things, Your Honor.
Okay.
I may just have just a moment.
Yes, and for the record, I'm referring right now to the introductory Phase 1 instructions, the final Phase 1 instructions, and the introductory Phase 2 instructions. Those three sets. Those are the sets that my staff emailed the attorneys late yesterday. And for the record, I've made the changes that I said I was going to make. Ms. Nelson, go ahead.
Your Honor, first, I just want to make clear for the record that we continue to object to the language that the court included in the instructions about the merger. We don't believe that the language that the court added solves the issues that we raised to the court's attention yesterday or ameliorates the harm, and we maintain our previous arguments with respect to that issue.
What else?
And then the second thing, we did discuss this, but in reviewing it last night, I have an additional proposal on this issue. It is on page, just one moment. The court's introductory instructions to Phase 1. Let's see here. Pages 8 to 9. the bottom of page 8 into the beginning of page 9. It's this sentence: if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must either, 1, return a unanimous verdict of life imprisonment without the possibility of parole, or 2, notify the court that it is unable to reach a unanimous verdict. I know we objected to this the language distinguishing between a unanimous and a non-unanimous verdict, but as I was looking at it again last night, it also occurred to me, based both on the prosecution's proposed verdict form for phase 2, as well as the verdict form that we intend to propose, which we haven't yet submitted to the court, that either way, whether it's a unanimous verdict for life without parole or a non-unanimous verdict, they'll be able to indicate that on the verdict form, or they should be able to indicate that on the verdict form. It's not that there's no place to indicate a non-unanimous verdict on the verdict form and that therefore they have to notify the court. And so I was wondering, we would like to propose that the court rephrase that just slightly to state as follows: if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must indicate on the verdict form that it has either, 1, reached a unanimous verdict of life imprisonment without the possibility of parole, or 2, that it is unable to reach a unanimous verdict. In either situation, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. And that at least would make it clear to them that in either situation, they can indicate that on the verdict form.
What's the people's position, Mr. Orman?
Your Honor, I think that the instruction that the court distributed adequately conveys to the jury their duties and their options, and I don't see the need for any change.
And I'm not too concerned about it, because even if I end up agreeing with you later, Ms. Nelson, if we get to phase 3, and this would only come into play if there is a phase 3, otherwise it's moot. This is part of the introductory instructions, and it's part of the introductory instructions that talks about phase 3. I can still do the verdict form the way you're asking me to do it, and it would not be inconsistent with this. Either way, they would be notifying me, whether they're notifying me through a note or notifying me through a verdict form. Either way, they would be notifying me that they cannot reach a unanimous verdict if that's the situation. So I'm not too concerned about that, and I think it leaves all of our options open still if there is a phase 3 and you still want to argue that point. And I think it's a point that has some merit, and I'm not saying that I'm going to go that way, but I might. So, and we've already made copies of all these instructions at this point. So I don't think that's a concern that warrants redoing all of the instructions and copying them again. This was in there, by the way, in yesterday's draft, and this particular suggestion was not brought up before we finalized the instructions. Ms. Nelson, is there anything else at this time?
I have one other matter on the final instructions for phase 1. It's the last instruction that begins following the attorney's arguments at the end of phase 1. It's the last sentence of the first paragraph, which currently reads, "Your foreperson will preside over your deliberations and shall sign the part of a sentencing hearing phase 1 verdict form according to the rules that I am about to explain." I think that should read, "Your foreperson will preside over your deliberations and shall complete the sentencing hearing phase 1 verdict forms, plural, according to the rules I am about to explain."
Again, I don't think that's a substantive issue. That point is made clear later in the instruction, so I'm not too concerned about that. By the way, I changed that particular sentence as you suggested yesterday, so it appears now exactly as you asked me to leave it or to have it. So again, the instructions have been copied, and I don't think that particular issue warrants making that change and then copying all the instructions again. Mr. Orman, do the people have a position on that?
I agree with Your Honor.
Okay. Is there anything else, Ms. Nelson?
No, Your Honor. Instructions.
Okay. Since there was an issue that we discussed quite a bit, actually, not only yesterday but Monday with respect to merger, let me make a supplemental record related to that. Because yesterday at the end of the session, I said that I would look at the authority that was cited by Ms. Nelson, and then I would decide how to proceed. And the record will reflect the changes that I made from the draft that we were working with yesterday to the final set of instructions, not only the introductory Phase 1 instructions, but also the final Phase 1 instructions. I read Caldwell versus Mississippi, which is cited at 472 U.S. 320, 105 Supreme Court 2633, 86 Lawyers Edition 2nd 231. That's a 1985 case from the United States Supreme Court. That decision, in my view, is inopposite. In that case, during rebuttal closing argument, the prosecutor argued that defense counsel, that the defense attorneys were attempting to make the jurors believe that the jurors were going to kill the defendant, but that defense counsel knew that the jurors' decision would not be final because their job was reviewable. The trial court overruled the defense's objection to that argument and stated in support of his overruling the objection that it was proper that the jury realize that its decision was reviewable automatically. The prosecutor then added that the jury's decision was automatically reviewable by the Supreme Court. The United States Supreme Court vacated the defendant's death sentence in Caldwell, holding that the need for reliability in the imposition of a death sentence mandated the conclusion that it is constitutionally impermissible to rest a death sentence on a determination made by a sentencer who has been led to believe that the responsibility for determining the appropriateness of the defendant's death rests elsewhere. Relying on Caldwell in People versus Drake, 748 Pacific 2nd, 1237, that's a case from the Colorado Supreme Court from 1988, the defendant asserted on appeal that some of the prosecutor's comments during closing argument so diminished the jury's sense of responsibility that reversal of his death sentence was mandated. And by the way, Drake was another case that was cited by Ms. Nelson yesterday. Although the Colorado Supreme Court in Drake found that the prosecutor's comments were susceptible to several interpretations, it concluded that it was highly likely that they injected an element of confusion for the jury. The court added that without clarification from the trial court, they may well have resulted in a diminution of the jury's sense of responsibility for the ultimate imposition of sentence at the critical stage in the proceedings when consideration of the appropriate punishment was the task immediately at hand. Because the prosecutor had implied that the jury had only an indirect or advisory role rather than the ultimate role in the imposition of the sentence, the Colorado Supreme Court ruled that the comments from the prosecutor were improper. Now, the court in Drake did not find that the improper comments by the prosecutor were dispositive of that appeal. To the contrary, the court specifically said that they were not. However, the court ruled that these comments constituted a factor which, when considered in conjunction with other problematic issues, cast doubt upon the reliability of the defendant's sentence. Unlike the situations in Caldwell and Drake, here, we're not dealing with comments made by a prosecutor during closing argument. More importantly, the draft Phase 1 introductory and final instructions that we worked with yesterday did not in any way cause confusion, much less diminish the jury's sense of responsibility in deciding the defendant's sentence. In any event, however, and in an abundance of caution, I made changes to both sets of instructions after the hearing yesterday to make it completely clear that the jury has the sole responsibility for the defendant's punishment in this case. I left the explanation about the merger issue in the two sets of instructions to address the concerns that were expressed by the defense on Monday in terms of there being some aspect of unfairness or prejudice if I don't tell the jury about merger, and if I allow the jury to have the impression that there are going to be 24 convictions in the end with 24 sentences. So I went ahead and left the discussion in both sets of instructions related to merger, but I made it abundantly clear that the jury has sole responsibility for punishment, and that whatever sentence is imposed in this case, it'll be the jury's sole decision. Additionally, again, in an abundance of caution, I went through both sets of instructions and deleted references to the court imposing the sentence in accordance with the jury's sentencing verdict. I don't think that language is confusing. I don't think that language in any way expressly or impliedly diminishes the jury's understanding of its role in this case, or the jury's role in this case, but in an abundance of caution, I went ahead and took that out as well. Yesterday, the defense made an additional argument with respect to the issue of merger, and in support of its request to have the court merge the counts now and only submit 12 counts to the jury. The case that was cited was United States versus McCullough. That's capital M, small c, capital C, U, L, L, A, H. That is a 10th Circuit Court of Appeals case cited at 76 F 3rd, 1087, a case from 1996. The argument that was advanced is that allowing the jury to deliberate on all 24 counts of murder in the first degree in any phase of the sentencing hearing improperly allows the prosecution to double count its aggravators. I find McCullough in opposite as well. In McCullough, the 10th Circuit Court of Appeals held that the submission of duplicative aggravating factors is constitutional error under the weighing scheme of the federal death penalty statute. But in that case, the trial court allowed the prosecution to submit two sets of aggravating factors that substantially overlapped with one another. Not surprisingly, the court found that such double counting of aggravating factors, and when I say the court found, I'm talking about an appeal. The court found, that the 10th Circuit found, that such double counting of aggravating factors, especially under a weighing scheme, has a tendency to skew the weighing process and creates the risk that the death sentence will be imposed arbitrarily and thus unconstitutionally. In stark contrast to the situation in McCullough, here, there's not an assertion, much less a showing, by the defense that any of the alleged aggravating factors overlaps with another aggravating factor. Therefore, there's no double counting. What the defense really complains about in this case is that there are two counts for each murder that was committed by the defendant. That is a completely different circumstance than what was before the court in McCullough. And I'm not concerned about the circumstance present in this case because I'm instructing the jury that it must treat each count separately. In other words, with respect to each count, the jury is going to have to first decide if the prosecution has proven beyond a reasonable doubt at least one of the alleged aggravating factors. If the prosecution does so, then each juror has to determine with respect to each separate count whether there are any mitigating factors. And if so, each juror, again with respect to each separate independent count, must independently weigh the mitigating factors against the aggravating factors. Only if each juror concludes beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors with respect to a particular count does the hearing move to phase 3 on that count. And then in phase 3, each juror would have to use his or her reason moral judgment to decide what sentence is appropriate with respect to that count. Significantly, the weighing process, again, in this case, must be separate with respect to each count. That is a significant circumstance here, and it is something that I'm telling the jury specifically about, I'm instructing the jury specifically about. So if the prosecution, for example, were to prove 4 aggravators with respect to 1 count of murder, the jury would be limited to those 4 aggravators on that count. If the prosecution were to prove the same 4 aggravators with respect to another count of murder related to the same victim, the jury would still be limited to those 4 aggravators as it relates to that other count. There's no double counting just because there are 2 counts for each murder. Each count requires the jury to go through the sentencing process I have outlined, separate and independent from other counts. Given the instructions that I'm providing the jury, I feel very confident that the jury will not blindly or unthinkingly add up the total number of aggravating factors and weigh that number against the total number of mitigating factors. If the jury were to do that, it would be in violation of my instructions, and the law assumes that the jury follows the court's instructions. In any event, in an abundance of caution, I added to the introductory Phase 2 instructions some language that was specifically suggested by the 10th Circuit Court of Appeals in Davis versus Executive Director of the Department of Corrections. That's cited at 100 F. 3rd 750, 10th Circuit, 1996. Ms. Nelson mentioned this case yesterday in our discussion. In that case, the 10th Circuit Court of Appeals observed that an instruction that the weighing process is not simply a mathematical exercise, but instead requires critical evaluation of the factors can help to countervail any improper influence occasioned by the submission of duplicative aggravators. The mathematical part was already there, as counsel know, that part was already in the instructions, but I added the part about the requirement for a critical evaluation of the aggravating and mitigating factors. The next thing that I have on my housekeeping list is C-TR-92. Yesterday, there was a discussion with respect to this exhibit. I think we had a brief discussion about it on Monday as well. This is the statement from witness JJ, I believe is her name, and the people objected through a motion in limine to her testimony, and I sustained the objection. I had not reviewed the report. I made my ruling based on the offer of proof that was made here in the courtroom, but in an abundance of caution, I wanted to read the report in its entirety. I did that yesterday. My ruling stands. I think that this witness would be able to testify about 2 different things. Number one, she would be able to testify about her own character and her own background, not the defendant's character and background. So that and evidence of her own character and background is inadmissible because it is irrelevant. The second thing that this witness, based on the report that I reviewed, would be able to testify about is some type of reverse victim impact evidence or some type of victim impact type evidence. This is different than execution impact evidence. I ruled in Order P-52 about execution impact evidence being inadmissible. This is more about the impact that the crimes had on the defendant's mother. And again, as real as that impact may be, and I don't question it, she's not a victim in this case under Colorado law any more than the defendant is a victim in this case. So that is not victim impact evidence. I'm not aware of any authority that allows that type of evidence to be introduced. So I wanted to make sure the record showed that I had reviewed that report, and I continue to believe that it is irrelevant and inadmissible. And I think it's a little different than execution impact evidence, which is what Order P-52 dealt with. The next thing on my list had to do with the media question request that the defense had made at the end of the day yesterday. And I had proposed a particular question, and then after I proposed that question, the defense came back with a different request. And I'm not sure that the record was completely clear as to whether the defense would rather not have me ask that question or whether there's a different request. It seems to me what would be appropriate is for me to tell the jurors, and here's what I would propose, for me to tell the jurors that I've been giving them an admonishment throughout the trial, throughout the proceedings, that they are to avoid any exposure to media reports and news reports. And to the extent that despite their best efforts, they have inadvertently been exposed to news reports about the case in the past, or that they ever are in the future, that they need to let one of my bailiffs know about that. And all they have to do is tell my bailiffs that they need to talk to me. That would be one question. The other question would be similar and would be, I have been giving them an admonishment throughout the proceedings that they are to avoid visiting any locations mentioned in the proceedings. And to the extent that even despite their best effort, they have inadvertently visited any location, or to the extent that that happens in the future, they need to let my bailiffs know that they need to talk to me about something, and then we can address it at that time. That way, I don't put them on the spot by asking them the question here in court, and they can have some time to think about it, think about whether either of those circumstances has happened. I think in the discussion we had about this yesterday, the defense referred to some kind of event that took place to mark the third anniversary of the shooting. And I don't know if that took place at one of the locations mentioned in the proceedings, and therefore the second question would take care of that, or if the defense wants me to add a third question along the lines of, to the extent that you've ever been exposed to an event related in any way to this case, or that happens in the future, to the extent it happens in the future, let my bailiffs know that you need to talk to me. So I'm happy to ask either the two first questions, or I'm happy to, it's actually not questions, I'm happy to make the first two advisements, but I'm also happy to make the third advisement if the defense wants me to, in terms of saying event. But I don't want to say event unless the defense wants me to do it. I agree with the defense that we have to be careful not to call more attention to this, and so I can't say the third year anniversary or anything like that. But I think if I say event, then that hopefully covers it, and hopefully it's vague enough and general enough that it is not problematic. But I'll only do that third part if the defense wants me to. So Ms. Nelson, do you, or whoever, or Ms. Brady, do you have a position on that?
Your Honor, we'd prefer you not say event. We would suggest the court tell them that if they've inadvertently seen or received any outside information concerning the case from any source, to let the court know.
Do the people want to be heard on this, Mr. Orman? Okay, I think that's appropriate, Ms. Brady, so I will ask that, or I will say that as well. The last thing I have on my list of things to talk to you about before I bring the jury in is the request that the people had made before deliberations in the guilt phase of the trial for a 3-hour delay or a 3-hour waiting period. I don't think it's necessary at this point, and I would be inclined to do 20 minutes to save time. I think the defense has 4 witnesses that it is attempting to call today to avoid any scheduling issues. And I think people have notice now, if they want to come here and be here, they can get here now, or they can get here around the noon hour if they wish. I don't think we need to wait 3 hours. Do the people agree?
Can I just consult with some of the victims who are present in the courtroom?
Yes, please.
Your Honor, I believe from what the court was saying that would apply to this phase. And we would have a different discussion, I think, at a later phase. Is that correct?
Yes.
That's fine with us, Your Honor.
Okay,
And it's
great.
fine with the victims who are present in the courtroom.
So is 20 minutes okay, or, yeah?
Yeah,
Okay,
that's
well,
fine.
is that okay with the defense, 20 minutes?
Yes.
Does that give your folks enough time to get here?
Yes.
Great, okay, let's do 20 minutes. All right, is there anything else we need to talk about on behalf of the people before I bring the jury in?
Your Honor, one thing occurred to me this morning, that there may be certain items of evidence that were admitted that in their totality have a limited purpose for their admission. And therefore, I wonder whether those items of evidence should go back with the jury for this phase. And what I'm specifically thinking of is the notebook and the discs containing the statements that the defendant made to Dr. Reed. Those are the only exhibits that I remember for which a limiting instruction was given. There were other exhibits that were entered where the witness's testimony had a limiting instruction. However, I don't recall a specific limiting instruction for the exhibits.
I think Dr. Fenton's medical report.
Then hers is that as well, Your Honor. And I don't know if the defense has any other ones that they think should not go back, but those exhibits, I do not believe, have any relevance or use to the jury for phase one of the capital proceeding. And it's an unusual circumstance, Your Honor, but I think because of that, they should not go back with the jury when they deliberate in phase one.
The only other thing I can think of was Dr. Metzner's CV, I think, was admitted, but I don't think that makes a whole lot of difference. That's just the CV. I know that the instruction was given without objection with respect to other evidence. For example, I remember the DVD of the defendant before he was brought into the courtroom in September of 2012. I gave the limiting instruction with respect to that DVD as well.
I think that should be included then in any list of items that don't go back with the jury. I can't think of any others at this point, but and I don't there was the jail writings, the galactic colonization writings. I don't think that they would have any relevance to this proceeding, but I don't recall whether either party requested a limiting instruction for that one. But if the defense would like those not to go back to the jury for this phase, I certainly would agree with that.
All right, who wants to address the court on this issue? Do you have any, first of all, do you have any objection to these items that we have identified, Ms. Brady, not going back to the jury room for deliberations?
No, sir.
All right, and do you have any additional items that you would like me to exclude from deliberations?
No, sir.
Okay, great, thank you. All right, we will not send back the notebook, the discs containing the statements to Dr. Reed, Dr. Fenton's medical report or medical notes. I should say medical notes, I think that's easier, or that's more accurate. And then the DVD of the defendant before he was brought into the courtroom in September of 2012 while being held in one of the holding cells here in the courthouse. That one should not go back to the jury room for deliberations either. Is there anything else on behalf of the people, Mr. Orman? No. All right, is there anything on behalf of the defense, Ms. Brady?
Yes, sir. Your Honor, I gave your clerk a copy of a PowerPoint presentation that was provided to us by Mr. Orman. It's a 129-slide PowerPoint presentation. It was provided to us at approximately 5:51 last night. I would note that this is the second time a lengthy PowerPoint presentation has been given to us on the eve of an argument. We would object to the PowerPoint in total. I would object to the color, content, the size of the writing, the choice of the words, the pictures, the entire content of the PowerPoint presentation. As the court is aware, having heard the trial and the merits in this case, none of the evidence in aggravation is disputed. Not a single item of evidence supporting their aggravation is disputed. So I think that having a dramatic PowerPoint like this is unduly inflammatory, irrelevant, and unnecessary, particularly given the heightened reliability of a capital sentencing proceeding. I do have specific objections to specific slides if the court wants me to go through those at this point.
Please.
Slides number 8 through 33. So slide number 8, Your Honor, is the one that says 1 Jonathan Blunk,
Yes.
and goes through slide number 33. Those are slides that have the victims' names and their photograph followed at the end by a compilation or a collection of all of the photographs together, thereby repeating all of the photographs again. We would object that this is an improper use of photographs to evoke emotion and sympathy from jurors. It's improper victim impact injected into phase 1 of the capital sentencing. We litigated the scope and propriety of all victim impact evidence already, and is only to be introduced at phase 3 if we get there. In addition, there's no need for photographs to be published twice to the jury, so we would object if they're admitted at all. We would object to them being shown twice. We would cite the court to Colorado Rule of Evidence 401 and 403. Although these photographs have already been admitted into evidence, we would object to this particular use of the evidence, and also cite the court to People versus McBride, McBride, 228 Pacific 3rd, 216, a Colorado appellate case from 2009, dealing with prosecutors may not pressure jurors by suggesting that guilty verdicts are necessary to do justice for a sympathetic victim. Next, I'll move to slide number 36.
Okay.
This specifically is the repetitive showing of the picture of Veronica Mosier Sullivan. I think it's shown 4 times in total by itself or in a collection. So we would object to the repeating of that photograph. Also, it's not, these photographs, and in particularly this one, is not needed to prove the aggravator. Again, improper victim impact, cumulative, and the probative value is substantially outweighed by the risk of undue prejudice as regarding their closing argument. We would again cite 401 and 403. Slide 38. That's the slide that states, the evidence shows you that the defendant had the conscious objective to kill every living soul in that theater, man, woman, and child alike. We would object to the phrase living soul, for living soul is not an element of the aggravation, not something that they have to prove as part of aggravation. It's improper inflammatory language. It's also not an argument that's based on the evidence. We believe it misstates the law. In order for the jury to find the existence of this aggravator that this slide deals with, the prosecution has to prove that it was Mr. Holmes's conscious objective to kill a child under 12, that he specifically intended to kill a child. And the aggravator cannot be satisfied by finding that he intended to kill anyone or everyone and just ended up killing a child. There has to be the intent to kill a child specifically. And sentencing is about personal moral culpability. The aggravator doesn't satisfy the Eighth Amendment's narrowing function if it just applies to someone who has the intention to kill everyone, but then just happens to kill a child. Aggravators in general are premised on the notion that it is a fact or circumstance about the crime that makes the defendant more culpable. So in order for this aggravator to be satisfied, Mr. Holmes would have to have actually intended to kill a child, not just happened to kill a child. So we would object to that slide, citing Rule of Evidence 401, 403. Regarding case law on the purpose of aggravation, we would cite the court to Lowenfield, Lowenfield versus Phelps, Phelps, 484 U.S. 231, quoting Zant, Z-A-N-T, versus Stevens, S-T-E-P-H-E-N-S, 462 U.S. 862, and People versus Davis, a Colorado case, 794 Pacific 2nd, 159. Case law regarding inflammatory language, Harris versus People, 888 Pacific 2nd, 259, Colorado, 1995, and People versus Walters, 148 Pacific 3rd, 331, Colorado appellate case from 2006. Moving to slide 39. Again, Your Honor, I think I mentioned that. That's another photograph of Veronica Mosier-Sullivan. Slide 42. As in the merits case where we objected to any sort of doctoring or marking on an exhibit, we would again object to the marking on this exhibit. It's an arrow pointing to something on a picture of Mr. Holmes with the gear on. So we would object under those same arguments. We also object because I think this photograph is confusing to the jury. The jury knows that this photograph was taken at Mr. Holmes's apartment, that it dealt with all of the incendiary devices and equipment that was contained at the apartment. As the court knows, that scene, that count is not relevant to the aggravating factors, and I think it would confuse the jury, and we would object under those grounds. Next slide, number 43. Photograph of a gun laying in with blood spattered around and the flip-flops that have been testified to. We think that this slide is an improper use of the evidence to evoke sympathy and emotion from the jurors, and we would object under those grounds. Slide 49. That's the slide that says at least 76 shots. We would argue that that's a misstatement of the evidence. Particularly the second sentence that says at least 670 individual projectiles. I don't recall that being testified to in evidence, not sure where that figure came from, if they took all of the different fragments located and added all those up. I don't know if that comes up to 670, but we do not know where that figure came from, so we would object that it's a misstatement of the evidence and misleading based on the trajectory testimony that was given by their witnesses in the merits phase. Slides 66 to 91. Your Honor, these are some of the injured victims and pictures of some of their injuries. It's some of the more gory photographs that were admitted to the jury. Again, I would reiterate that none of those injuries were disputed. None of those victims were cross-examined concerning their injuries, in closing argument and opening statement. At no point did we dispute the injuries or in any way put any evidence on to try and contradict any of that. And simply displaying these photographs, again, photographs that, granted, Your Honor, the jury has in evidence and will have with them, but there's no need to display them during the prosecution's closing statement in this capital sentencing. We argue that their use is simply to evoke emotion and sympathy from the jury. It's not needed to prove the grave risk of death aggravator. Again, it's improper victim impact injected into phase one. It's improper victim impact for injured victims. As the court knows, the victim impact at the sentencing hearing will be limited to the deceased victims. And so evoking sympathy and emotion related to these injured victims is improper. We believe that there's a risk that the jury's going to make their sentencing decision based on the injured victims instead of on how they're instructed by the court concerning the first-degree murder counts. For this, we'd cite, again, Rule 401 and 403, that the use of this evidence has a different purpose at sentencing, and we would object to the way it's being used in phase one of this capital sentencing. Slide number 99. And that begins with, consider the defendant modified the environment of his killing zone by deploying tear gas. Is the court there?
Yeah.
Okay. Your Honor, we would object to this slide. We would object to the phrase killing zone. That's an improper inflammatory term, not based on the evidence presented by witnesses or evidence at the trial. We would again cite Rule 401 and 403, Harris versus People, 888 Pacific 2nd, 259, People versus Walters, 148 Pacific 3rd, 331. Slide 101. This means victims would experience extreme discomfort from the tear gas in addition to being shot. We object to this slide. It expresses an improper personal opinion of the prosecution. It's not relevant to any alleged aggravator. It's not the logical inference from the evidence. We would cite the court to Domingo, D-O-M-I-N-G-O, hyphen Gomez, G-O-M-E-Z, versus People, 125 Pacific 3rd, 1043, Colorado case from 2005, concerning prosecution's remarks during closing argument expressing personal opinion are improper. Slide 103, the defendant killed his victims in a crowded movie theater. Same objections as to slide 101. It's a personal opinion by the prosecution, inflammatory, and particularly inflammatory is the use of his victims, framing it in the possessive way that it's framed. We would object to that slide under the same authorities that I cited for slide 101. Slide 104, the victims were trapped by design. This is argument based exclusively on evidence that has been excluded from the jury's consideration at this stage of the sentencing hearing. And namely, it seems to be based on the notebook and statements made by Mr. Holmes to Doctors Reed and Metzner as to why he chose the movie theater. The court's instructing the jury they may not consider that evidence at phase one, and we believe that this slide and the slides through 108 are based on this excluded evidence. We would cite Colorado Revised Statute Section 16-8-107, the right against self-incrimination under the Fifth Amendment, and Article 2, Section 18 of the Colorado Constitution, as well as due process, right to fair and impartial jury, right to a fair and reliable sentencing hearing, Fifth, Sixth, Eighth, 14th Amendments to the U.S. Constitution and Colorado Constitution, Article 2, Sections 16, 20, 23, 25. Three cases we would like to cite: Estelle, E-S-T-E-L-L-E, versus Smith, 451 U.S. 454 from 1981. Powell, P-O-W-E-L-L, versus Texas, 492 U.S. 680 from 1989. Satterwhite, S-A-T-T-E-R-W-H-I-T-E, versus Texas, 486 U.S. 249 from 1988. Slide 105, they were unable to flee. We would object to this slide being inflammatory and not based on the evidence presented. Slides 106 through 108. Knowing that every breath could be their last in the darkness and that there was nothing they could do about it. We would object that this series of slides injects personal opinion of the prosecution and hypothesizes about the victim's mental state, a mental state that's not properly in evidence from the first trial. We would object that it's inflammatory and improper appeal to the jurors' emotions and is tantamount to asking the jurors to put themselves in the victim's shoes, and we would object to such an argument. Slide 110. The defendant killed his victims so that it begins.
Yes.
We would object that this is not a fair inference to argue from the evidence, that they cannot attribute intent and purpose to Mr. Holmes. To do so is to use the statements that he made during the sanity evaluations in an improper manner, as the court has instructed the jury. They are not allowed to consider, and so we would object again under the same authorities that I cited for slide number 104, his right against self-incrimination, and the Estelle and Powell cases that I cited earlier. I would object to the, I think it's the next slide, but all of the slides that repeat the word torturous again and again, we would object to that. Slide 112, the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish. We would object that this is improper opinion testimony by the prosecution, improper inference from the evidence as to what was Mr. Holmes's intent and purpose. Again, to the extent that it is a valid inference, it's based on evidence that the jury is being instructed not to consider, specifically Mr. Holmes's notebook and statements made to experts during the sanity examination. I would cite to the same authorities I cited to earlier concerning the Fifth Amendment and the Estelle, Powell, and Satterwhite cases that I cited earlier. Slide 117 through 120. Consider the victims were unaware of any danger watching a movie, helpless. The defendant was in a place of concealment. That series of slides we would object as improper opinion, argument, and comment on the evidence, repeating the argument that any inference that comes from this based on Mr. Holmes' statement during the sanity examination should be excluded. They should not be allowed to argue based on information that came from those statements by Mr. Holmes. Slide 123, the victims had no way to know that danger lurked right outside. We would object to this slide using inflammatory language, improper appeal to jurors' emotions, and for the term lurked, we would cite the court to People versus Walters, 148 Pacific 3rd, 331, a Colorado Court of Appeals case from 2006. Those are the specific slides in addition to the general objection to the entire PowerPoint. All of my objections are pursuant to Mr. Holmes' right to due process, right to a fair and impartial jury, right to a reliable sentencing hearing, the 5th, 6th, 8th, 14th Amendment to the United States Constitution, Colorado Constitution, Article 2, Sections 16, 20, 23, 25. Also, I found some state cases. We might have cited one of these during the merits PowerPoint objection, but I would cite the court to a couple state cases that talk about use of PowerPoint or misuse of PowerPoint presentations by the prosecution. State versus Reineke, R-E-I-N-E-K-E, at 337 Pacific 3rd, 941. It's an Oregon case. And State versus Hecht, H-E-C-H-T, 319 Pacific 3rd, 836, a Washington case. Can I have just a moment?
Yes.
And one more case, Your Honor, in the matter of Edward Glassman, G-L-A-S-M-A-N-N, 286 Pacific 3rd, 673, a Washington case. Thank you.
All right, thank you. All right, new rule, folks. From now on, if you want to use a PowerPoint presentation, you have to tender it to the other side 2 days in advance. And if you want to object, you have to make the objections a day later. Got it? We can't be doing this. I mean, the jury's waiting. This is unfair for the jury. I've encouraged you folks to share information with each other in a timely fashion, and you folks insist on waiting till the last minute to do it, and you're both doing it. And now, you want me to rule on about 50 objections while the jury's waiting to come in here. It's not fair to the jury. It's not fair to the court. It's not the way things should work. This is not the way things should work. So, who wants to respond from the people?
Your Honor, I understand the court's statements. However, I would note, I gave this to the defense as soon as I'd finished it, and I know Your Honor was a trial attorney for a long time and knows that the preparation for an argument happens up until the argument.
But we're going to have to delay things then. What's going to happen is we're going to end evidence in a particular phase, and before we can have argument, we'll wait 2 days. so that you can prepare your PowerPoint presentation, and then the other side can object. That's how it's gonna go. I mean, we just can't keep doing this. And you're both doing it. You're both using PowerPoint presentations. I find it interesting that the defense is making global objections to PowerPoint presentations when they themselves have been using them. That's inconsistent. I mean, the defense, hold on, I heard you, now hear me out. The defense used a PowerPoint presentation in closing arguments as well. And I hadn't seen the defense's PowerPoint slides in closing when I ruled on some of the objections to the people's PowerPoint presentations or PowerPoint presentation slides. And what I realized as I was listening to the defense's closing argument is that some of the same issues that the defense was complaining about were things that were included in the slides that the defense used. Not all of them, but some of them. Some of the very complaints that the defense made about the people's slides were present in the defense's slides. So, you know, you're both using PowerPoint presentations, and we can't do this where we wait until the last minute and then there are objections, and then there's going to be a response, and now I have to rule on a bunch of objections, and there has been extensive authority cited, all while we're waiting for the jury to get in here. All with the understanding also that there's time pressure because there are witnesses the defense wishes to call today who may not be available after today or may have some scheduling conflict. So it is unfair to the court. It is unfair to put the court in that type of position. And the only way that I see around this is to put time limitations on you. So if you want to use PowerPoint presentations, do it 2 days before you have to do them. In other words, you have to serve it on the other side 2 days in advance. And then if you want to object, you have to make the objections the next day so that I can have time to look through the PowerPoints, think about the objections, look up any authority that I need to look up, and then make rulings. All right, Ms. Brady, I'll get back to you. Let's let Mr. Orman finish. Mr. Orman, go ahead.
Well, Your Honor, thank you. I appreciate the court's ruling. I didn't know if the court was saying that I did something wrong by providing it to Ms. Brady last night. I was just trying to explain why that happened. The use of PowerPoints is accepted in courts in the United States. Used to be attorneys would get up and write things on boards. And if I can write it on a board, I can put it in a PowerPoint. This is just a more effective way to do that. I don't think I need to say anything else under the general concept of me using a PowerPoint. And I know the defendant objects to me apparently arguing for the existence of aggravating factors, arguing to the jury that they should find beyond a reasonable doubt that we have proven the existence of aggravating factors, because that's what we have to do. Ms. Brady talked about things being non-contested. Well, if they don't want to contest anything, they can stipulate to the existence of these aggravating factors. Otherwise, I've got to ask the jury to find that we have proven these aggravating factors beyond a reasonable doubt, which, as far as I know, is the highest burden that anybody has in the law in the United States, in any court, anywhere. So I've got to ask them to find these beyond a reasonable doubt. And I'm using the evidence that was admitted in the trial and reasonable arguments based on inferences from that evidence for them to do so. The first aggravating factor, that he killed more than 2 people in the course of the same criminal episode, yeah, I'm using their names. Those are the people he killed. I'm using their pictures. Yeah, I'm using their pictures, Judge. Those are the people he killed. That is the evidence in support of that aggravating factor. I have to ask the jury to do it beyond a reasonable doubt. And at the end of that sequence, yeah, I would put them all together again to show the number of people he killed. That's an aggravating factor that we have to prove. There's an objection to the term living soul. And frankly, to that argument, well, Your Honor, we've had evidence. We had a woman named Chi-Chi Sproul who came in here who said she had never seen so many children in a movie theater in her entire life. And she didn't want to sit next to children, but it was hard for her to even find a place away from children in that movie theater. And the evidence shows with the amount of ammunition that this defendant took to that theater, with the number of rounds he had on his person, with the weaponry he had, it was his intention to kill everyone in that theater. And the term living soul, Your Honor, I think is just a colloquial term for everyone in that theater. It is not unduly prejudicial to the defendant. It is reasonable argument for me to make that argument and for me to use that term. He saw children in that theater. We had Corbin Dates testify that there was a baby in the same row as the defendant. He intended to kill everyone in that theater, and it is a proper argument for me to make that therefore he intended to kill a child under 12 and did so. That is the nature of my argument. And I would also note, counsel makes objections to these as if they are the totality of my argument. The purpose of these slides is to illustrate some points I am making, but by no means is this all the argument I would make. It accompanies my argument. Your Honor, regarding their objection to the slide that shows the defendant with the rifle strapped to his chest.
Before you get to the rifle picture, there was an argument right after the argument related to the every living soul. And the argument is that one of the aggravators requires you to prove beyond a reasonable doubt that the defendant intended to kill a child. And it can't be the type of situation where he just happened to kill a child without intending to kill that specific child. Your response to that is what?
My response to that, Your Honor, is, well, first of all, I don't know that he has to intend to kill that specific child. I think he has to intend to kill a child under 12 and do so. And here we have both. Because he was in a crowded theater. We have had people, it's not my fantasy that it was crowded, as Ms. Brady would somehow argue to the court, where there was evidence from multiple witnesses that this theater was packed. We have evidence from multiple witnesses that there were many young children, including a baby, in this theater. We have evidence that the defendant went into this theater with enough ammunition to kill everybody in there. And we have evidence that the gun jammed, and that's why he didn't. So he went in there with the intent to kill everyone in that theater. He knew that there were young children in that theater. It is a reasonable inference from the evidence that therefore he went in with the specific intent and acted with the specific intent to kill a child under 12. The evidence supports that aggravating factor. The evidence supports that argument. And additionally, Your Honor, he shot Veronica Mosher Sullivan 4 times. It's hard enough to shoot a person once. He shot a person 4 times. He shot that little girl 4 times. I think that shows the nature of his intent. So that's my response to that, Your Honor.
There was a picture before the picture that you were about to talk about when I interjected, and that is the picture you were about to talk about has to do with the firearm and some blood and a sandal. The picture right before that, slide number 42, has an arrow pointing to some gear, apparently. What's your response to that objection?
Well, Your Honor, I recall the Glassman case that counsel cited, and it was cited in the argument that was made in the first phase of the trial. And that argument was that, well, first of all, this picture shows the intent, the defendant with the gun he used to kill the people, on his chest. You can see it right there. And the aggravator here is that he knowingly created a grave risk of death. Well, this is evidence that shows what he knew what he was doing, and he knew what this was. The objection to the arrow, Your Honor, my understanding of the objection based on Glassman, and frankly, Your Honor, I think that there's nothing wrong with us putting an arrow on top of an exhibit to point something out. If I can go up and put my finger up to it on the monitor, there's no reason I can't put an arrow there to make that point. But I haven't done that here because of the court's ruling in the previous phase. I put that arrow completely outside the photograph. That arrow does not in any way modify that exhibit. It is next to the photograph, pointing to the side of the photograph where that gun is. So I have not modified that exhibit in any way, shape, or form. I'm just pointing out something on it.
Okay, the next one is 43.
The next one is 43. That's a picture of the gun that he used that was found at the scene. It's the same gun that he's shown in his photograph holding right at his chest, strapped to his chest. It is the weapon he used that shows he knowingly created that grave risk of death. Same is true with the other weapons. The same is true with the photograph showing all three of them together.
I think the objection, if I remember correctly, to the picture of the firearm and the sandal is that under 403, it's unduly prejudicial and unnecessarily inflammatory for purposes of this phase one because it shows blood and it shows a sandal, and that's not relevant to what you're trying to prove in this particular phase.
Well, I beg to differ with that argument, Your Honor. He created a grave risk of death by shooting folks. And this is blood by one or more of those people that he shot. That shows that it is evidence of their injuries, it is evidence of the grave risk of death that he created. So I beg to differ with that argument.
The next one is slide number 49, and the objection, as I remember it, is that it misstates the evidence. That's the one that says at least 76 shots, at least 670 individual projectiles.
Well, Your Honor, if you look at my previous slide, I have there the rounds that were found in the theater, and counsel didn't argue that was inaccurate. I believe that's accurate. That is 65 .223 rounds. Each of those is a projectile. That is 5 .40 caliber rounds. Each of those is a projectile. And then you have 6 shotgun rounds, each with 100 pellets. Each of those pellets is a separate projectile. We've heard from people that we've seen the images of how those rounds created those patterns of all those holes. Each of those is a projectile. And my math is that adds up to 670 individual projectiles and 76 shots. That is a reasonable inference based on the evidence. And the reason I say at least is that's just what was found. Who knows if some shell or something got kicked into a little area where no one was able to find it.
Okay, the next objection I have is to slide 66 to 91, which show injuries to the surviving victims or some of the surviving victims. What's your response to those objections?
Your Honor, I think I could have shown, and I would have been reasonable in doing so, photographs of every injured victim in that theater, because the defendant created a grave risk of death to all of them. And not only all of them, everybody in Theater 9 and everybody in Theater 8, the defendant created a grave risk of death to each and every one. And I am taking a few of them out here to demonstrate to the jury the nature of the defendant's conduct and how he created a grave risk of death, and showing some of the injuries that he caused by his actions, creating a grave risk of death to these people. So there is no improper inference or improper argument related to any of these photographs or the mention of any of these people.
The next one I have is slide number 99, and I believe the objection is specifically to the use of the term killing zone.
Well, the defendant's been convicted of killing 12 people in that theater. The jury's found he killed them. So the term killing, I don't see how that's objectionable or inflammatory. He did it. They found he did it. The zone is, he killed him in this zone, the theater. I don't think the term killing zone is some type of term that is unnecessarily inflammatory. It's just a descriptor of what he did and the area that he did it in.
The next one is slide number 101, which deals with, I think, an argument that this means the victims would experience extreme discomfort from the tear gas in addition to being shot.
Right. So
and the objection, I believe, is that it is opinion, not a logical inference from the evidence.
Well, Your Honor, it's not only not that. It is direct. There's direct evidence of this, not even circumstantial evidence. We have direct evidence from numerous people who described what the tear gas did to them and what they went through because of the tear gas this guy chose to deploy in the theater. So it's a reasonable inference based on that anybody else in that theater is going to experience similar discomfort. That's not just me making that up, as Ms. Brady might try to allege.
The next one I have is 103. The defendant killed his victims in a crowded movie theater, and I think the objection was to the use of the word his.
Your Honor, he killed them. He's been convicted of killing them. They're the victims. They're his victims. I don't even understand what the argument is there.
The next one I have is to slide number 104. The victims were trapped by design, and The objection is that this is an argument based on evidence that has been excluded from this phase of the proceedings because it's based on the defendant's statements during one of the court order sanity examinations.
Well, Your Honor, it's not. And, this is one of those circumstances where this is to accompany an argument that I am making. The design I am talking about is him going in with the tear gas, deploying that, him going into a place where it's really crowded and nobody would be able to get out of there easily because of the situation he is creating. The design that he's going into a dark place where there's a lot of noise from the movie and so forth. All of that demonstrates his design. It is not in any way connected to the statements that the defendant made to anybody in the course of a mental status examination. I would make this argument if we didn't have that information because it's obvious from the evidence that the jury has that they are allowed to consider in this phase.
The next slide is 105, or the next objection is to slide number 105, which I think talks about the victims being unable to flee. And I think the objection is that it was inflammatory and not based on evidence.
Your Honor, I don't even know what to say to that. We've heard the testimony of what was going on in that theater from so many people. There was gunfire. People had to hide from that or attempt to protect themselves. They couldn't flee. There were so many people there that you couldn't get over other people. It was a small, dark space filled with panicking people that was intentionally created by the defendant. So I don't really even understand what the argument is there. It's such an obvious fact.
The next objection is to slides 106 to 108, knowing that every breath could be their last. I think the objection to that is that it's a personal opinion. That's what I wrote down. There may be other statements in there, but what I wrote down is that particular quote.
Well, Your Honor, it is a reasonable inference based on the evidence that we have heard what people were going through in that theater, what the situation was. Even if we hadn't heard from people in the theater as to what was going on in there, with the situation that the defendant intentionally created by going in there and shooting people in the crowded theater, the jury can make a reasonable inference that anybody in that situation would think that every breath could be their last, that they were in the darkness and that they knew that there was nothing they could do about it. That was a reasonable argument based on the admissible evidence in this phase.
And what's the relevance of that?
Well, the relevance of that, Your Honor, is the proof that we have to prove that this is unnecessarily torturous. It's not like the defendant went up to someone, shot them in the back of the head, and they didn't know anything was coming and they didn't feel any pain. The defendant created a situation intentionally where these people would be in fear of their lives. And really, what's worse than that? Oh my God, I might get killed. You're cowering in the darkness. You know you're going to get killed. That is intentionally creating mental anguish in these victims and intentionally creating a torturous situation for them.
The next one is slide number 110, and I don't have a whole lot of information on 110. Maybe you wrote down more notes than I did. Let me find it.
Your Honor, I think that's the one that starts with the defendant killed his victims so that at the moments of their deaths.
Yes.
Well,
It says the defendant killed his victims in a manner so that the victims would. Oh, wait, no, that's not it.
I think it's two before that.
Yeah, the defendant killed his victims so that at the moment of their death, they would not only be in fear of their own lives, but in fear for the lives of their friends and family and loved ones.
Yes. Well, Your Honor, that is not my opinion. That is a reasonable inference based on the evidence. It goes to the unnecessarily torturous language that is in the instruction provided by the court, which is based on a precedent from the United States Supreme Court. The fact that he did this, he was in that theater. The evidence is he would have been in that crowded theater, seeing people surrounded by their friends and family and people that they came with. And, Your Honor, it's not like you go to a theater and everybody comes alone. You see people talking. The jury can make a reasonable inference about what's going on in that theater and what the defendant saw. So he would have seen that people are surrounded by their families and then killed them in a manner so that when he was shooting his gun, everybody in there would not only be concerned about their own life, that's pretty bad, but even worse probably, concerned about the lives of the people they're with and being helpless to do anything about it. It's like taking a mother and her child into a room and saying, oh, I'm going to kill you, but first let me tell you, I'm going to kill your child, and pointing a gun at the child's head.
The next objection is to the use of the word torturous.
It's in the instruction, Your Honor, and I do repeat it because I go back to the instruction, and it's language I've taken directly from the instruction so that I can demonstrate to the jury this is related to that factor that you need to consider, unnecessarily torturous, so that I can argue to the jury it meets that factor.
The next one is to slide number 112, and that was slide 111, by the way. 112 is an objection to the slide that says the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish.
Correct. Well, I think that the fact that that is the case is not just an opinion on my part. I think that is a reasonable inference based on the evidence. It is, again, the nature of the deaths that he created, that they were surrounded by this horror as it was going on, is an unnecessarily torturous way to commit murder.
The next one, the next objection has to do with the set of slides that starts at number 117 and it goes through 120, and it has to do with consider the victims were unaware of any danger. Consider the victims were unaware of any danger watching a movie. Consider victims unaware of any danger watching a movie helpless. Victims unaware of any danger watching a movie helpless. The defendant was in a place of concealment.
Well, Your Honor, one thing I want to mention is in this presentation, I really didn't use animations. I wanted to have a record as to what each thing looked like. So I could have just done this as one slide with an animation, but it's just going to be these sort of things appearing in that list. So that's why it appears that way. This is my argument as to why this is lying in wait and from an ambush. I think all these factors relate to aggravating factor number 5, lying in wait and ambush. And they show that he did this, he committed these murders, he killed these people where they were unaware of what was coming, and he did it from a place of concealment. And to me, that is the definition of lying in wait and ambush, and this is proper argument based on the evidence.
The last one is to number 123. Consider the victims had no way to know that danger lurked right outside.
Correct, Your Honor. I understand the nature of the term lurked, and I know the case that counsel cited on that. However, that case did not deal with a murder case involving a statutory aggravating factor of lying in wait and ambush. It's a different circumstance. Lying in wait and ambush is not something you would normally have in a murder case. And I think it's proper to describe it that way. However, Your Honor, I can take that out and I can put stood instead of lurked, and I don't think that would really diminish my argument.
All right, anything else from you, Mr. Orman?
No, Your Honor, thank you.
All right, Ms. Brady, I'll give you the last word since it's your set of objections.
Your Honor, I'm not saying Mr. Orman can't argue. I'm saying he shouldn't be allowed to argue with giant PowerPoint slides in big black and white letters up on a big screen TV at a phase 1 of a capital sentencing hearing. He just proved he can very dramatically argue without any slides up on the screen. He could do this entire closing argument in minutes with no slides to the same effect as if he puts up gory photographs and prejudicial slides that are unnecessary to his argument. He simply puts them up there to evoke the sympathy and the emotion of the jury. That's the only reason for those slides. Those jurors have seen the pictures. They're probably seared in their memory. And putting them up again and again during his argument is unnecessary. I would ask that the PowerPoint that the court has be marked as a court exhibit. We'd also ask that Mr. Orman provide a digital copy of the PowerPoint presentation to the court to also be marked as an exhibit. We, I think, previously asked that Mr. Brockler's PowerPoint presentation for his merits closing be submitted to the court, and I don't think that's been done. I know that Mr. King's PowerPoint was submitted to the court. So I just want to make sure that all of those get marked as a court exhibit and put into evidence.
Any objection to that, Mr. Orman?
Your Honor, I think regarding Mr. Brockler's exhibit, I know I talked to one of our paralegals yesterday. They were working on getting that together. I don't know what the current status of that is. For mine this morning, I have it on a disk.
Okay, you don't have any objection to marking it?
Oh, no, not at all. That's why I did it.
Okay.
I mean, and I don't have objection to the one, the printout.
Well, if we're gonna mark the disc, I don't know that we need the printout. Ms. Brady, do we need the printout as well if we have the disc?
I would like both to be, we can,
Is this an extra copy that you gave me?
yes, sir.
All right, then we can mark both. So what's the next number, court trial exhibit? So you can mark the disc 94, and then we'll mark the paper copy 95, C-TR-94 and C-TR-95.
So is it okay if I just write it on there, Your Honor?
It's okay.
Okay, I've got it right here.
Great, thank you. You can just tender it to my staff. All right, Ms. Brady, anything else?
Just a couple brief comments. Mr. Orman's argument that Mr. Holmes intentionally created this torturous situation, I think proves our point that that is based on statements that Mr. Holmes made in the notebook and made to Dr. Reed. If you remove Mr. Holmes's statement, there is no evidence of why he created a situation or what situation he was trying to create. But for his statements, the situation is what it is, but ascribing intent to him for specific things come from his statements. So we would again object to that. The court has in the jury instructions in front of it the definition of torturous. What Mr. Orman is arguing to be torturous, I do not believe fits the definition the court's going to read to the jury. His argument that Mr. Holmes knew that there would be young children at the movie theater is unsupported by the evidence, so we would continue to object to that. And I would just remind the court that this is different than the first trial, and I know that the court knows that, but I'm going to keep saying it over and over. So if something happened at the first trial, that doesn't mean it's okay at the second trial, because the court knows that there's heightened reliability when someone's life is on the line, and so if something happens at the first trial, it doesn't make it acceptable or admissible at the second trial, so we're going to continue to object to these things. I'll also put the prosecution on notice anytime they refer to Mr. Holmes as this guy or that guy in the sneering tone that they have been doing throughout this trial, I am going to make an objection in front of the jury and make a record every time they do it. He can be referred to as Mr. Holmes. He can be referred to as the defendant. But this guy is not going to happen at the sentencing, not without an objection from the defense. Thank
Okay.
you.
All right. Well, there has been no objection to that before that I remember, so the people are on notice now that there will be an objection, so they can proceed how they wish. If there's an objection, then I'll hear a response and I'll rule on the objection. All right? I need to take a recess now because we've been at this now for about an hour and 10 minutes, and actually more than that, an hour and a half. And I need to give my court reporter a break. I need to give my staff a break. And I also need to think about some of the arguments that the lawyers have made. In terms of what Ms. Brady was saying about this being different in the first proceedings, she's right, and I'm aware of that. My point simply was, you know, as a lawyer, when you get up and complain about PowerPoint presentations globally in general, and then you get up and use a PowerPoint presentation yourself, then the court's going to take notice of that. And that was my point. I took notice, I noticed that, and I made a mental note of that at the time because there was a global objection to the people using a PowerPoint presentation in closing argument, and then Mr. King got up and used a PowerPoint presentation in his closing argument. And it just seems to me you can't have it both ways. The rules apply to both sides, whether it's the trial or whether it's the sentencing hearing. There are rules that I have to apply, and I'm going to apply them based on a way that gives both sides a fair trial, and based on the way that the law tells me I need to apply them. So that was my point. My point was not to imply that this is no different than the first part of the proceedings. Of course it is. My point simply was that not only was there a global objection to PowerPoint slides by the prosecution, but there were specific objections to those slides. And then some of those concerns that were raised by the defense in terms of the people's slides were present in the defense's slides. The people didn't object to them, but they were present, and I noticed them for the first time when they were used in the defense's closing arguments, and it caught my attention. That's all I'm saying. All right, I'm going to take a break, and then I'll give you my rulings on all these objections after the break. The court will be in recess. Thank you.
Well, we don't know too much more than we did an hour and 30 minutes ago when we started everything in court, and I might be a little too short right now, sorry about that. Going over stuff, listening to the testimony, going over what's being talked about, looking through the statute on the death penalty. Here's what we know, that the prosecution has planned a PowerPoint presentation similar to what they've done for the opening statements and similar to what they did for closing statements as well. And we saw in closing statements there was objections to certain slides, and a good chunk of them were sustained by the judge, and the prosecutor, District Attorney George Brockler, had to go back and change some of the slides prior to doing the PowerPoint presentation in front of the jury. And I think they counted like 800 and I want to say 892, 860. It was almost 900 slides in the closing arguments by the prosecution. Now what we're seeing is another objection by the defense saying, at 5 o'clock last night, we got this PowerPoint presentation sent to us by the prosecution. In this case, it looks like it's going to be Rich Orman doing the arguing and making the statement in front of the jury, and saying there are certain things we don't think the jury should see because they don't belong. And she listed off upwards of 50 different objections, Tamara Brady did, including the very first instances of seeing the photos and names of those killed. And you could hear how incredulous Rich Orman thought that was, because they were victims of the crime. And yeah, they're going to be victims, but they're going to have to show their faces as well. The argument by Tamara Brady is that it would invoke emotion, and that's still not allowed. As we've talked with the legal analysts over the course of this trial, you cannot appeal to the emotion of the jury. You can basically only deal with fact. But I mean, we all know that what they're doing, and by bringing all the witnesses and the victims and the survivors to the stand, does evoke emotion. And the way you make placements in the PowerPoint presentation that we've seen in both opening statements and closing arguments will invoke emotion, but then the judge will advise the jury not to take that into account, that basically it has to be fact-based and that your emotion can't guide you, don't make decisions right now. However, in the sentencing phase, emotion may guide the jury, because you heard, I think it was Tamara Brady even making the statement that they want to appeal to their person, to let their experience guide them in the decision of whether or not they would put someone to death. So for an hour and a half, the jury has been waiting to come into the courtroom for the first time since announcing that their verdict was guilty. We've not seen the jury yet. This is all taking place outside their presence. And the judge scolded both sides, even though Tamara Brady probably had a point by saying, these are objections that we have. I'm sorry I didn't get these to you earlier. We just got this last night. The judge said to both sides, you've both used PowerPoint presentations, you've both done this to each other, and I'm going to scold you. New rules. If you're ever going to use a PowerPoint presentation again, you're going to submit it to the other side 2 days before it's used, so that I can hear these objections 1 day before it's used, versus what's happening now. Right now, we should probably be seeing this PowerPoint presentation by Rich Orman, but instead, Tamara Brady made the objections, and the judge had to listen to both sides, hear the objection, hear the response, hear a rebuttal, and now take into account all those objections and figure out what he's going to do next, what he's going to allow, what he's not going to allow. And if we learned anything from the closing argument objections, he will likely sustain some of these objections that Tamara Brady made, whether you agree with them or not. I'm sure they're sound in law in terms of why they may not be allowed, though Rich Orman made some compelling emotional arguments as to why everything he included in this PowerPoint presentation will be used. One thing I noticed, you'll remember, April 1st, 2013, new District Attorney George Brockler at the time had just been sworn in maybe 2.5 months earlier. Up in the air was this going to be a death penalty case? And on April 1st, he stood in front of the judge. At the time, I believe it was Judge Sylvester, and he said, justice is death, as he talked about the defendant. Well, here we are, the first step of the death penalty phase, and it turns out that it's Rich Orman and not the district attorney who is going to be doing at least the opening statement, if not some of the arguing. So I found that interesting, and we can talk to our legal analysts about that, because as you heard from all of our legal analysts, they were surprised about how involved in the actual trial portion of the case George Brockler was. And now here, step one of the sentencing phase, it appears he's taken at least a step back for Rich Orman. What we're going to do here, why not show you the part where the judge gets upset with both sides? It's when he points out that this is ridiculous, the jury is waiting, and here we are having to listen to arguments that should have been taken care of in advance. They had 2 days where the jury wasn't involved over the last 2 days where court was in session. But here is that portion from just a little bit ago where the judge is telling both sides, if you're going to do this, there are new rules involved. We're going to let it play out. No idea how long this break is going to be. It's not going to be 20 minutes because the courtroom needs a break and the judge needs to go over these objections. So if we end this clip, we've got some other clips we want to get ready for you so that we can show you what's likely to happen in the sentencing phase. But here is what just went down with the judge getting upset and why he was upset with both sides.
All right, new rule, folks. From now on, if you want to use a PowerPoint presentation, you have to tender it to the other side 2 days in advance. And if you want to object, you have to make the objections a day later. Got it? We can't be doing this. I mean, the jury's waiting. This is unfair for the jury. I've encouraged you folks to share information with each other in a timely fashion, and you folks insist on waiting till the last minute to do it, and you're both doing it. And now, you want me to rule on about 50 objections while the jury's waiting to come in here. It's not fair to the jury. It's not fair to the court. It's not the way things should work. This is not the way things should work. So, who wants to respond from the people?
Your Honor, I understand the court's statements. However, I would note, I gave this to the defense as soon as I finished it, and I know Your Honor was a trial attorney for a long time and knows that the preparation for an argument happens up until the argument.
We're going to have to delay things then. What's going to happen is we're going to end evidence in a particular phase, and before we can have argument, we'll wait 2 days so that you can prepare your PowerPoint presentation, and then the other side can object. That's how it's going to go. I mean, we just can't keep doing this. And you're both doing it. You're both using PowerPoint presentations. I find it interesting that the defense is making global objections to PowerPoint presentations when they themselves have been using them. That's inconsistent. I mean, the defense, hold on, I heard you, now hear me out. The defense used a PowerPoint presentation in closing arguments as well. And I hadn't seen the defense's PowerPoint slides in closing when I ruled on some of the objections to the people's PowerPoint presentations or PowerPoint presentation slides. And what I realized as I was listening to the defense's closing argument is that some of the same issues that the defense was complaining about were things that were included in the slides that the defense used. Not all of them, but some of them. Some of the very complaints that the defense made about the people's slides were present in the defense's slides. So, you're both using PowerPoint presentations, and we can't do this where we wait until the last minute and then there are objections, and then there's going to be a response, and now I have to rule on a bunch of objections, and there has been extensive authority cited, all while we're waiting for the jury to get in here. All with the understanding also that there's time pressure because there are witnesses the defense wishes to call today who may not be available after today or may have some scheduling conflict. So it is unfair to the court. It is unfair to put the court in that type of position. And the only way that I see around this is to put time limitations on you. So if you want to use PowerPoint presentations, do it 2 days before you have to do them. In other words, you have to serve it on the other side 2 days in advance. And then if you want to object, you have to make the objections the next day so that I can have time to look through the PowerPoints, think about the objections, look up any authority that I need to look up, and then make rulings. All right, Ms. Brady, I'll get back to you. Let's let Mr. Orman finish. Mr. Orman, go ahead.
Well, Your Honor, thank you. I appreciate the court's ruling. I was just, I didn't know if the court was saying that I did something wrong by providing it to Ms. Brady last night. I was just trying to explain why that happened. The use of PowerPoints is accepted in courts in the United States. Used to be attorneys would get up and write things on boards. And if I can write it on a board, I can put it in a PowerPoint. This is just a more effective way to do that. I don't think I need to say anything else under the general concept of me using a PowerPoint. And I know the defendant objects to me apparently arguing for the existence of aggravating factors, arguing to the jury that they should find beyond a reasonable doubt that we have proven the existence of aggravating factors, because that's what we have to do. Ms. Brady talked about things being non-contested. Well, if they don't want to contest anything, they can stipulate to the existence of these aggravating factors. Otherwise, I've got to ask the jury to find that we have proven these aggravating factors beyond a reasonable doubt, which as far as I know is the highest burden that anybody has in the law in the United States in any court anywhere. So I've got to ask them to find these beyond a reasonable doubt. And I'm using the evidence that was admitted in the trial and reasonable arguments based on inferences from that evidence for them to do so. The first aggravating factor, that he killed more than 2 people in the course of the same criminal episode, yeah, I'm using their names. Those are the people he killed. I'm using their pictures. Yeah, I'm using their pictures, Judge. Those are the people he killed. That is the evidence in support of that aggravating factor. I have to ask the jury to do it beyond a reasonable doubt. And at the end of that sequence, yeah, I would put them all together again to show the number of people he killed. That's an aggravating factor that we have to prove. There's an objection to the term living soul. And frankly, to that argument, well, Your Honor, we've had evidence. We had a woman named Chi-Chi Sproul who came in here who said she had never seen so many children in a movie theater in her entire life. And she didn't want to sit next to children, but it was hard for her to even find a place away from children in that movie theater. And the evidence shows with the amount of ammunition that this defendant took to that theater, with the number of rounds he had on his person, with the weaponry he had, it was his intention to kill everyone in that theater. And the term living soul, Your Honor, I think is just a colloquial term for everyone in that theater. It is not unduly prejudicial to the defendant. It is reasonable argument for me to make that argument and for me to use that term. Saw children in that theater. We had Corbin Dates testify that there was a baby in the same row as the defendant. He intended to kill everyone in that theater, and it is a proper argument for me to make that therefore he intended to kill a child under 12, and did so. That is the nature of my argument. And I would also note, counsel makes objections to these as if they are the totality of my argument. The purpose of these slides is to illustrate some points I am making, but by no means is this all the argument I would make. It accompanies my argument. Your Honor, regarding their objection to the slide that shows the defendant with the rifle strapped to his chest.
Before you get to the rifle picture, there was an argument right after the argument related to the every living soul. And the argument is that one of the aggravators requires you to prove beyond a reasonable doubt that the defendant intended to kill a child. And it can't be the type of situation where he just happened to kill a child, without intending to kill that specific child. Your response to that is what?
My response to that, Your Honor, is, well, first of all, I don't know that he has to intend to kill that specific child. I think he has to intend to kill a child under 12 and do so. And here we have both. Because he was in a crowded theater. We have had people, it's not my fantasy that it was crowded, as Ms. Brady would somehow argue to the court, where there was evidence from multiple witnesses that this theater was packed. We have evidence from multiple witnesses that there were many young children, including a baby, in this theater. We have evidence that the defendant went into this theater with enough ammunition to kill everybody in there. And we have evidence that the gun jammed, and that's why he didn't. So he went in there with the intent to kill everyone in that theater. He knew that there were young children in that theater. It is a reasonable inference from the evidence that therefore he went in with the specific intent and acted with the specific intent to kill a child under 12. The evidence supports that aggravating factor. The evidence supports that argument. And additionally, Your Honor, he shot Veronica Mosher Sullivan 4 times. It's hard enough to shoot a person once. He shot a person 4 times. He shot that little girl 4 times. I think that shows the nature of his intent. So that's my response to that, Your Honor.
There was a picture before the picture that you were about to talk about when I interjected, and that is the picture you were about to talk about has to do with the firearm and some blood and a sandal. The picture right before that, slide number 42, has an arrow pointing to some gear, apparently. What's your response to that objection?
Well, Your Honor, I recall the Glassman case that counsel cited, and it was cited in the argument that was made in the first phase of the trial. And that argument was that, well, first of all, this picture shows the intent, the defendant with the gun he used to kill the people, on his chest. You can see it right there. And the aggravator here is that he knowingly created a grave risk of death. Well, this is evidence that shows what he knew what he was doing, and he knew what this was. The objection to the arrow, Your Honor, my understanding of the objection based on Glassman, and frankly, Your Honor, I think that there's nothing wrong with us putting an arrow on top of an exhibit to point something out. If I can go up and put my finger up to it on the monitor, there's no reason I can't put an arrow there to make that point. But I haven't done that here. Because of the court's ruling in the previous phase, I put that arrow completely outside the photograph. That arrow does not in any way modify that exhibit. It is next to the photograph, pointing to the side of the photograph where that gun is. So I have not modified that exhibit in any way, shape, or form. I'm just pointing out something on it.
Okay, the next one is 43.
The next one is 43. That's a picture of the gun that he used that was found at the scene. It's the same gun that he's shown in his photograph, holding right at his chest, strapped to his chest. It is the weapon he used that shows he knowingly created that grave risk of death. Same is true with the other weapons. The same is true with the photograph showing all 3 of them together.
I think the objection, if I remember correctly, to the picture of the firearm and the sandal is that under 403, it's unduly prejudicial and unnecessarily inflammatory for purposes of this phase 1 because it shows blood and it shows a sandal, and that's not relevant to what you're trying to prove in this particular phase.
Well, I beg to differ with that argument, Your Honor. He created a grave risk of death by shooting folks. And this is blood by one or more of those people that he shot. That shows that it is evidence of their injuries. It is evidence of the grave risk of death that he created. So I beg to differ with that argument.
The next one is slide number 49, and the objection, as I remember it, is that it misstates the evidence. That's the one that says at least 76 shots, at least 670 individual projectiles.
Well, Your Honor, if you look at my previous slide, I have there the rounds that were found in the theater, and counsel didn't argue that was inaccurate. I believe that's accurate. That is 65 .223 rounds. Each of those is a projectile. That is 5 .40 caliber rounds. Each of those is a projectile. And then you have 6 shotgun rounds, each with 100 pellets. Each of those pellets is a separate projectile. We've heard from people that we've seen the images of how those rounds created those patterns of all those holes. Each of those is a projectile. And my math is that adds up to 670. individual projectiles and 76 shots. That is a reasonable inference based on the evidence. And the reason I say at least is that's just what was found. Who knows if some shell or something got kicked into a little area where no one was able to find it.
Okay, the next objection I have is to slide 66 to 91, which show injuries to the surviving victims or some of the surviving victims. What's your response to those objections?
Your Honor, I think I could have shown, and I would have been reasonable in doing so, photographs of every injured victim in that theater, because the defendant created a grave risk of death to all of them. And not only all of them, everybody in Theater 9 and everybody in Theater 8, the defendant created a grave risk of death to each and every one. And I am taking a few of them out here to demonstrate to the jury the nature of the defendant's conduct and how he created a grave risk of death, and showing some of the injuries that he caused by his actions, creating a grave risk of death to these people. So there is no improper inference or improper argument related to any of these photographs or the mention of any of these people.
The next one I have is slide number 99, and I believe the objection is specifically to the use of the term killing zone.
Well, the defendant's been convicted of killing 12 people in that theater. The jury's found he killed them. So the term killing, I don't see how that's objectionable or inflammatory. He did it. They found he did it. The zone is, he killed him in this zone, the theater. I don't think the term killing zone is some type of term that is unnecessarily inflammatory. It's just a descriptor of what he did and the area that he did it in.
The next one is slide number 101, which deals with, I think, an argument that this means the victims would experience extreme discomfort from the tear gas in addition to being shot.
Right. So
And the objection, I believe, is that it is opinion, not a logical inference from the evidence.
Well, Your Honor, it's not only not that. It is direct. There's direct evidence of this, not even circumstantial evidence. We have direct evidence from numerous people who described what the tear gas did to them and what they went through because of the tear gas this guy chose to deploy in the theater. So it's a reasonable inference based on that anybody else in that theater is going to experience similar discomfort. That's not just me making that up, as Ms. Brady might try to allege.
The next one I have is 103. The defendant killed his victims in a crowded movie theater, and I think the objection was to the use of the word his.
Your Honor, he killed them. He's been convicted of killing them. They're the victims. They're his victims. I don't even understand what the argument is there.
The next one I have is to slide number 104. The victims were trapped by design, and the objection is that this is an argument based on evidence that has been excluded from this phase of the proceedings because it's based on the defendant's statements during one of the court order sanity examinations.
Well, Your Honor, it's not. And, this is one of those circumstances where this is to accompany an argument that I am making. The design I am talking about is him going in with the tear gas, deploying that, him going into a place where it's really crowded and nobody would be able to get out of there easily because of the situation he is creating, the design that he's going into a dark place where there's a lot of noise from the movie and so forth. All of that demonstrates his design. It is not in any way connected to the statements that the defendant made to anybody in the course of a mental status examination. I would make this argument if we didn't have that information because it's obvious from the evidence that the jury has that they are allowed to consider in this phase.
The next slide is 105, or the next objection is to slide number 105, which I think talks about the victims being unable to flee. And I think the objection is that it was inflammatory and not based on evidence.
Your Honor, I don't even know what to say to that. We've heard the testimony of what was going on in that theater from so many people. There was gunfire. People had to hide from that or attempt to protect themselves. They couldn't flee. There were so many people there that you couldn't get over other people. It was a small, dark space filled with panicking people that was intentionally created by the defendant. So I don't really even understand what the argument is there. It's such an obvious fact.
The next objection is to slides 106 to 108. Knowing that every breath could be their last. I think the objection to that is that it's a personal opinion. That's what I wrote down. There may be other statements in there, but what I wrote down is that particular quote.
Well, Your Honor, it is a reasonable inference based on the evidence that we have heard what people were going through in that theater, what the situation was. Even if we hadn't heard from people in the theater as to what was going on in there, with the situation that the defendant intentionally created by going in there and shooting people in the crowded theater, the jury can make a reasonable inference that anybody in that situation would think that every breath could be their last, that they were in the darkness and that they knew that there was nothing they could do about it. That was a reasonable argument based on the admissible evidence in this case.
And what's the relevance of that?
Well, the relevance of that, Your Honor, is the proof that we have to prove that this is unnecessarily torturous. You know, it's not like the defendant went up to someone, shot them in the back of the head, and they didn't know anything was coming and they didn't feel any pain. The defendant created a situation intentionally where these people would be in fear of their lives. And really, what's worse than that? You know, oh my God, I might get killed. You're cowering in the darkness. You know you're going to get killed. That is intentionally creating mental anguish in these victims and intentionally creating a torturous situation for them.
The next one is slide number 110, and I don't have a whole lot of information on 110. Maybe you wrote down more notes than I did. Let me find it.
Your Honor, I think that's the one that starts with the defendant killed his victims so that at the moments of their deaths.
Yes.
Well,
It says the defendant killed his victims in a manner so that the victims would. Oh, wait, no, that's not it.
I think it's two before that.
Yeah, the defendant killed his victims so that at the moment of their death, they would not only be in fear of their own life, but in fear for the lives of their friends and family and loved ones.
Yes. Well, Your Honor, that is not my opinion. That is a reasonable inference based on the evidence. It goes to the unnecessarily torturous language that is in the instruction provided by the court, which is based on a precedent from the United States Supreme Court. The fact that he did this, he was in that theater. The evidence is he would have been in that crowded theater, seeing people surrounded by their friends and family and people that they came with. And, you know, Your Honor, it's not like you go to a theater and everybody comes alone. You see people talking. The jury can make a reasonable inference about what's going on in that theater and what the defendant saw. So he would have seen that people are surrounded by their families and then killed them in a manner so that when he was shooting his gun, everybody in there would not only be concerned about their own life, that's pretty bad, but even worse probably, concerned about the lives of the people they're with. Being helpless to do anything about it. It's like taking a mother and her child into a room and saying, oh, I'm going to kill you, but first, let me tell you, I'm going to kill your child, and pointing a gun at the child's head.
The next objection is to the use of the word torturous.
It's in the instruction, Your Honor, and I do repeat it because I go back to the instruction, and it's language I've taken directly from the instruction, so that I can demonstrate to the jury this is related to that factor that you need to consider, unnecessarily torturous, so that I can argue to the jury it meets that factor.
The next one is to slide number 112, and that was slide 111, by the way. 112 is an objection to the slide that says the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish.
Correct. Well, I think that the fact that that is the case is not just an opinion on my part. I think that is a reasonable inference based on the evidence. It is, again, the nature of the deaths that he created, that they were surrounded by this horror as it was going on, is an unnecessarily torturous way to commit murder.
The next one, the next objection has to do with the set of slides that starts at number 117 and it goes through 120. And it has to do with consider the victims were unaware of any danger. Consider the victims were unaware of any danger watching a movie. Consider victims unaware of any danger watching a movie helpless. Victims unaware of any danger watching a movie helpless. The defendant was in a place of concealment.
Well, Your Honor, one thing I want to mention is, in this presentation, I really didn't use animations. I wanted to have a record as to what each thing looked like, so I could have just done this as one slide with an animation, but it's just going to be me, these sort of things appearing in that list. So that's why it appears that way. This is my argument as to why this is lying in wait and from an ambush. I think all these factors relate to aggravating factor number 5, lying in wait and ambush. And they show that he did this, he committed these murders, he killed these people where they were unaware of what was coming, and he did it from a place of concealment. And to me, that is the definition of lying in wait and ambush, and this is proper argument based on the evidence.
The last one is to number 123. Consider the victims had no way to know that danger lurked right outside.
Correct, Your Honor. I understand the nature of the term lurked, and I know the case that counsel cited on that. However, that case did not deal with a murder case involving a statutory aggravating factor of lying in wait and ambush. It's a different circumstance. Lying in wait and ambush is not something you would normally have in a murder case. And I think it's proper to describe it that way. However, Your Honor, I can take that out and I can put stood instead of lurked, and I don't think that would really diminish my argument.
All right, anything else from you, Mr. Orman?
No, Your Honor, thank you.
Brady, I'll give you the last word since it's your set of objections.
Your Honor, I'm not saying Mr. Orman can't argue. I'm saying he shouldn't be allowed to argue with giant PowerPoint slides in big black and white letters up on a big screen TV at a phase 1 of a capital sentencing hearing. He just proved he can very dramatically argue without any slides up on the screen. He could do this entire closing argument in minutes with no slides to the same effect as if he puts up gory photographs and prejudicial slides that are unnecessary to his argument. He simply puts them up there to evoke the sympathy and the emotion of the jury. That's the only reason for those slides. Those jurors have seen the pictures. They're probably seared in their memory. And putting them up again and again during his argument is unnecessary. I would ask that the PowerPoint that the court has be marked as a court exhibit. We'd also ask that Mr. Orman provide a digital copy of the PowerPoint presentation to the court to also be marked as an exhibit. We, I think, previously asked that Mr. Brockler's PowerPoint presentation for his merits closing be submitted to the court, and I don't think that's been done. I know that Mr. King's PowerPoint was submitted to the court. So I just want to make sure that all of those get marked as a court exhibit and put into evidence.
Any objection to that, Mr. Orman?
Your Honor, I think regarding Mr. Brockler's exhibit, I know I talked to one of our paralegals yesterday. They were working on getting that together. I don't know what the current status of that is. For mine this morning, I have it on a disc.
Okay, you don't have any objection to marking it?
Oh, no, not at all. That's why I did it.
Okay.
I mean, and I don't have objection to the one, the printout.
Well, if we're gonna mark the disc, I don't know that we need the printout. Ms. Brady, do we need the printout as well if we have the disc?
I would like both to be, we can,
Is this an extra copy that you gave me?
yes, sir.
All right, then we can mark both. So what's the next number, court trial exhibit? So you can mark the disc 94, and then we'll mark the paper copy 95, C-TR-94 and C-TR-95.
So is it okay if I just write it on there, Your Honor?
It's okay.
Okay, I've got it right here.
Great, thank you. You can just tender it to my staff. All right, Ms. Brady, anything else?
Just a couple brief comments. Mr. Orman's argument that Mr. Holmes intentionally created this torturous situation, I think proves our point that is based on statements that Mr. Holmes made in the notebook and made to Dr. Reed. If you remove Mr. Holmes's statement, there is no evidence of why he created a situation or what.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. During the break, I had an opportunity to quickly review the people's slides and to consider the objections to the slides and the responses to the objections. I want the record to reflect again that this was brought up at the last minute, and as the jury has been waiting all morning, I'm doing the best I can, given the little time that the attorneys have allowed the court for these objections and responses. In terms of the global objections, all of the global objections are overruled. Slides are visual aids that the attorneys can use. Both sides have used slides in this trial. Both sides have used them, for example, in closing argument, and I believe that both sides used them as well with respect to witnesses. So the global objection to the use of slides, in my view, lacks merit. There were some global objections that were more detailed than that, and it had to do with the color of the slides. I actually like the color. I like that they're black and white. I think that's as neutral as it gets. I think where the case law sometimes has issues is when attorneys use red, which is the color of blood, or perhaps some other color that may be improper in some way. For the most part, these are black and white. I think there's some yellow in some of the font. None of that color bothers me. And I actually like that the people made them black and white because I think that's the most neutral, those are the most neutral colors. In terms of the size of the font, as you attorneys know by now, I like large font. I don't use 12 font as you do in all your pleadings. I use 14 font. My eyes get tired when I'm reading small font. But secondly, I just think it makes it easier to read and to understand things. In this case, the font is appropriate because the screens in the courtroom are far away from the jury. And we have all observed throughout the trial, at times the jury is squinting to try to see what is being shown on a particular screen. And that's because the font of some exhibits is small. And both sides have used a method to call out particular portions of writing in exhibits that have been admitted and shown to the jury so that the jury can actually see what's on the screen. So the large font doesn't bother me. And in terms of the content and the picture and the choice of words, I'm going to address those specifically with respect to the objections identified by Ms. Brady. And so let me go through those now. By the way, before I proceed with the specific objections, let me just state that I am mindful that in this phase of the proceedings, the prosecution is the only party that has the burden of proof. And the prosecution's burden of proof is high. It's the highest burden of proof available under the law, as Mr. Orman indicated. The people have to prove beyond a reasonable doubt each and every element of at least one of the aggravating factors it has alleged with respect to each count in this case, each count in this sentencing hearing. And as the attorneys know, there are 24 counts. Now, in terms of the specific objections, first, there's an objection to the slides that show the victims' names and the victims' photos, the deceased victims' names and the deceased victims' photos. That objection is overruled. The people have to prove beyond a reasonable doubt as an element of at least one of the aggravating factors that has been alleged that a particular one, that each of these victims was murdered. And so I think it's fair for them to show the name. I think it's fair for them to show a picture. The compilation of all the photographs of the deceased victims is, I think, fair, given that one of these aggravators alleges that more than two or more people were killed. So I think it's appropriate for them to show a compilation of all the photographs. So the objection under Rule 401 and 403 is overruled. These photographs and these names are relevant. They have probative value, and the probative value is not substantially outweighed by any danger of unfair prejudice. By the way, these are all photographs that the jury has seen before. This is not going to be anything new to the jury. And in this phase of the proceedings, as I said, the people have to prove beyond a reasonable doubt certain elements with respect to each, or at least one aggravator alleged with respect to each particular count. And each particular count refers to a particular victim. Actually, there are 2 counts for every deceased victim. I will sustain the objection, however, to the repetitive showing of the photograph of Veronica Mosher Sullivan. I know that there are 2 particular counts, or 2 particular, actually there's a particular aggravator that applies only to 2 counts, and that is the intentional killing of a child under 12. But the people don't need to keep showing the photograph over and over in their presentation. I think it's enough if they show it one time, and so the objection to the additional photographs of Veronica Mosher Sullivan is sustained, and I'll give the people an opportunity to modify their slides, so that they can make that change.
I just did that, Your Honor.
Okay, thank you. Slide number 38, the objection is to the use of every living soul. I do agree with Mr. Orman that this is a colloquial term, but I don't know how a juror might perceive it or what a juror might infer from it. And the people don't need to say soul. They can say every living person, and it conveys the same message. So I'll sustain the objection to the word soul, but the people can put person or individual or something along those lines. So that objection is sustained. In terms of the argument related to the people not being able to prove beyond a reasonable doubt that the defendant intended to kill a child, this will be a decision for the jury to make. It's not a decision for me to make. There is certainly enough evidence here for the jury to draw reasonable inferences to prove this count. For example, there is evidence that there were children present. There is evidence that, and there's evidence from which the jury could infer that the defendant was aware of that. There's evidence from which the jury could infer that the defendant, being aware that there were children present in the theater, intentionally shot Veronica Mosher Sullivan. And actually, the people don't have to prove specifically that he intended to shoot Veronica Mosher Sullivan, but they have to prove beyond a reasonable doubt that he intended to kill a child under 12. And I think there is enough circumstantial evidence here for that the people can proceed on that aggravator. Mr. Orman mentioned that there was a baby on the same row where the defendant was seated. That's part of the evidence that he was referring to, and I agree that based on all the evidence that has been admitted, there is sufficient evidence for the jury to infer that the defendant knowing that there were children present in the theater, proceeded with his actions, and that therefore he intended to kill a child under the age of 12. There's an objection to slide number 42 because it has an arrow pointing to the picture. Initially, I was inclined to order the people to modify this exhibit, but Mr. Orman is right. He was careful not to distort the exhibit in any way, and the arrow is actually outside the photograph. And so with the arrow outside the photograph, I am comfortable that the people can proceed. There is no difference, as Mr. Orman said, between him putting his finger there or putting an arrow there or putting a stick on that and pointing to it, or using a laser point and pointing to it. I don't see a difference between any of those methods, and I think all of those methods are appropriate. By the way, The arrow in this particular case doesn't have any color. It's a white arrow, so it's a very neutral color. And so I don't have any concerns about that either. And so the objection with respect to that slide is overruled. The objection as to that slide that it will be confusing to the jury because that photograph dealt with the incendiary devices, which is not relevant to the sentencing hearing, is overruled. The photograph may have dealt with the incendiary devices because it was taken in the apartment, but certainly the photograph shows the defendant dressed up with the armor and the other equipment that he wore to the shooting. So it is also related to the shooting, and it is also relevant to these proceedings, the sentencing hearing. And under Rule 401, it is therefore admissible, and its probative value is not substantially outweighed by any of the dangers listed in Rule 403. The objection to slide 43, this is the slide that shows one of the firearms used, and it shows blood on the ground and a sandal. There is a picture of each firearm that was used in the shooting. I think the objection to this slide is that it shows blood in the sandal, and that therefore the probative value of the evidence is substantially outweighed by the danger for unfair prejudice. I disagree with the objection. Number one, this is a picture the jury has previously seen. Number two, this is a firearm that the defendant used in the shooting. And number three, this is where the firearm was found. This was the location of the firearm. It was found on the floor outside the theater. And number four, the people have to prove beyond a reasonable doubt that the defendant created a grave risk of death. For all those reasons, the picture has probative value, and I find that the probative value of the photograph is not substantially outweighed by the danger for unfair prejudice or any of the other concerns listed in Rule 403. The objections to the slides that are 66 through 91, and these are the pictures of the injuries of the victims. Ms. Brady said that this is undisputed. I disagree. I mean, the injuries may be undisputed, but the injuries go to an issue that's very much in dispute, and that is that the defendant created a grave risk of death. This is a similar argument that has been advanced before that I have rejected, where the defense will say, well, this particular point is undisputed. Well, maybe the immediate point is undisputed, but the larger point is not, and that is the point about whether the defendant created a grave risk of death to people who are not victims of the murder counts. And so given that the people have to prove that beyond a reasonable doubt, the pictures are relevant to that issue. They have probative value, and the probative value is not substantially outweighed by the danger for unfair prejudice or any of the other concerns listed in Rule 403. Again, these are all photographs that the jury has seen before. They have been admitted into evidence, and the jury has them available to them, just like the picture of the firearm that I spoke about, slide number 43. Ms. Brady said that the people don't need these photographs to prove the grave risk of death. Well, it's not up to the defense to decide how the people go about proving the aggravating factors. As long as an aggravating factor remains in dispute, the people can prove it as they see fit, as long as it is within the rules of evidence. So if the defense wants to stipulate to that particular element of the aggravating factor, then my ruling would be different. But as long as there's not a stipulation, the people are entitled to prove that the defendant created a great risk of death to victims who are not victims of the murder counts, or to people who are not victims of the murder counts. The next slide I have is 99. I went back and forth on this one. Use of the term killing zone. This is argument, and I think this is arguably appropriate for the people to use that term. But we're in a sentencing hearing, and this is in a slide. It's in writing. And so given that, I'm going to err on the side of caution and order the people to modify that term. The people don't need that term to make the point they're making. The point they're making here is that the defendant used tear gas in order to modify the environment of the theater, and that this is part of the evidence that supports the people's argument that this was unnecessarily torturous. What is relevant here is not that this was a killing zone. What is relevant is that in this theater, he deployed tear gas, and that deployment of the tear gas made this crime unnecessarily torturous. At least that's the people's argument. So I'm sustaining the objection with respect to that. I know that at the end of the trial, there was a similar objection to Mr. Brockler's use of the term kill box. But at that time, we were dealing with not the aggravator of unnecessarily torturous. We were dealing with all of the charges, all 165 charges, and the people had to prove beyond a reasonable doubt each and every element of those charges. They had to prove beyond a reasonable doubt that the defendant committed the crime, and that all the elements were met. And I thought that was fair, but I think here, given what the people are attempting to do, which is a lot more narrow, and again, I am erring on the side of caution here, so I'll sustain the objection because of that. The next one is 101. This means that the victims would experience extreme discomfort from the tear gas in addition to being shot. The objection that this is opinion by the prosecutor is overruled. This is a logical inference from the evidence. If you have someone who uses tear gas, I think there's a reasonable logical inference from the fact that the person used tear gas that the person would have known that the victims would experience discomfort from the tear gas. Frankly, I think the use of the word discomfort is a pretty mild term and an appropriate term. I'm not encouraging the people to use a different term. I'm just saying discomfort, all things considered, and given what other synonyms or other words could be used, discomfort is actually a pretty mild way to describe what would be reasonable for someone to expect would happen if he used tear gas. So the objection as to 101 is overruled. There is direct evidence that that the victims, some of the victims in this case, experienced extreme discomfort as a result of the tear gas, and I think reasonable inferences can be drawn from that that the use of tear gas would mean that the victims in the theater would experience extreme discomfort. The next one I have is 103. This one says the defendant killed his victims in a crowded movie theater, and I believe the objection is to the word his. I don't have a problem with that. This is argument that people can argue. These are the defendant's victims. The defendant has now been found guilty of all 12 murders. All 12 of these victims are his victims. So I don't have a concern with respect to the use of that word. I don't think that this is an opinion by the prosecutor. This is now fact, given the jury's guilty findings. It is not inflammatory, and I find that under Rule 403, it is appropriate and admissible because the probative value is not substantially outweighed by any of the dangers listed in Rule 403. Again, I'm mindful that this is argument. The next objection is to slide number 104. The victims were trapped by design. The argument in support of the objection is that this is based on evidence that has been excluded from this phase of the sentencing hearing because it is based on the defendant's statements to Dr. Reed. Mr. Orman responded that this is not based on the defendant's statements to Dr. Reed. This is based on other evidence and reasonable inferences that can be drawn from that evidence. I agree with Mr. Orman. I think that excluding and ignoring completely all the statements the defendant made to Dr. Reed, I think the evidence, the physical evidence, allows for reasonable logical inferences that the victims were trapped by design. The defendant went to the theater while a movie was playing in the dark, and then proceeded with the shooting. I think reasonable inferences can be drawn that the victims were trapped by design without getting into any of the statements the defendant made to any psychiatrist or psychologist or mental health expert. Now, the people have to be very careful, though, to make sure that they do not reference any statements by the defendant to Dr. Reed or Dr. Metzner or anyone else, and also be careful not to, and when I say anyone else, I mean anyone else who's a mental health expert, and also to be careful not to rely in their argument on any such statements or any other evidence that has been excluded for purposes of phase one of the sentencing hearing. The next objections have to do with slides 105 through 108. Actually, I think 105 may have been the one that I just addressed about the victims being trapped by design. I'm not sure, but in any event, so the record is clear, I'll go through these one by one. I've addressed the trapped by design slide. The next one is they were unable to flee. And the argument is that this is inflammatory and not based on evidence. The people have to prove beyond a reasonable doubt an element related to especially heinous, cruel, or depraved manner, that the murder, the first-degree murder, was committed in an especially heinous, cruel, or depraved manner. At least with respect to one aggravator, the people have to prove that beyond a reasonable doubt. At the defense's specific request, I included language in the elemental instruction that says that in order to prove beyond a reasonable doubt that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner, the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. So, given what the people have to prove, some of these slides are appropriate. In terms of this particular slide that says they were unable to flee, the concern I have is that some of the victims were actually able to flee. So I don't think it's accurate based on the evidence. If the people want to change it to some of them were unable to flee, that's fine. But saying they were unable to flee, I don't think is completely accurate. So I'm sustaining the objection with respect to that aspect of it. Even though that wasn't really the objection, but that's still something that I consider, and I think that's improper. So that should be either modified or the slide should be deleted. And I agree with the people that the evidence does support the fact that some of the victims were unable to flee, either because they couldn't get out of their row or for whatever other reason, some of them were unable to flee. The next objections, I believe, are to slides 106 through 108, and I believe that last one was 105. So I think the one about the victims being trapped by design was 104. The one about unable to flee was 105. 106 says, knowing that every breath could be their last. I don't like this slide. This slide seems to me to be more for the effect on the jury than anything else. So I'm sustaining the objection with respect to this slide because I think it does have some inflammatory value or some inflammatory risk, And I don't think it's, I don't think it does anything for the people's proof in terms of this being unnecessarily torturous. And by the way, when it says knowing that every breath could be their last, I take that to be referring to what the victims knew. The next one is in the darkness. That one doesn't bother me. It's connected to the last one, but it doesn't bother me. It's supported by the evidence, and there's nothing inflammatory about it. The next one says, and that there was nothing that they could do about it. I think this one is appropriate. It's an inference, a logical, reasonable inference that can be drawn from the evidence. I'm not saying that it's the only inference, but I think it's a logical and reasonable inference to be drawn from the evidence that as the shooting was occurring in the dark while the movie's playing, with people not knowing what was happening, with tear gas having been deployed, that the victims knew that there was nothing they could do about it. The next objection, there's an objection in here at some point to unnecessarily torturous, to the word torturous. I don't understand that objection, given that that's specifically something that I am instructing the jury about at the defense's request. So that objection is overruled. The next objection I have is what I believe is slide number 110. And I think the one that I have as torturous, the objection to the use of the word torturous, although the word torturous is used throughout the slides, I think the objection was made with respect to it on page 111 or slide 111. The objection to slide number 110 is next. The next one I'm going to address. That slide reads as follows. The defendant killed his victims so that at the moments of their death, they would not only be in fear of their own lives, but in fear for their lives, for the lives of their friends and family and loved ones. What I don't like about this slide is that it implies that this was the reason why the victims were killed in this fashion. And so I think that is objectionable, and the objection is sustained. To the extent that people want to modify it, they can modify it to say at the moment of their death, the victims were not only in fear of their own lives, but in fear for the lives of their friends and family and loved ones. I think that's a reasonable inference, not only a reasonable inference from the evidence, but actually directly supported by the evidence. Next is slide number 112, which says the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish. Same ruling, same concern. It implies that this is why this was done in this fashion. And I don't think that's a reasonable inference from the evidence. Again, if the people want to say that the victims died surrounded by screaming and pain and anguish, I think that's a reasonable inference that can be drawn from the evidence, and frankly, that is directly supported by the evidence. But as drafted, I find that it is objectionable. So the objection to the slide as drafted is sustained. The next ones are slides 117 to 120, which have to do with the aggravating factor of while lying in wait or from ambush. And again, this is something that people have to prove beyond a reasonable doubt. So I don't see any problems with any of these slides. The slides are as follows. The victims were unaware of any danger, watching, and then the next point or the next part would say watching a movie. The next part would say helpless. The next part would say the defendant was in a place of concealment. All of that is directly supported by the evidence in this case. So the objections as to all of those slides are overruled. The last one I have is slide number 123, which reads, the victims had no way to know that danger lurked right outside. The people are willing to change lurked to stood, and that would be my order. So that word should be changed. That takes care of all the objections and the responses to the objections. Did the people, did those rulings, were those rulings clear, Mr. Orman?
They are, Your Honor. I've made the changes.
Great, thank you. All right, do you need any time then before I bring the jury in? All right, is the defense ready for the jury? Yes. Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is now back in the courtroom. Good morning, folks. How's everyone doing? Good. I trust that you had a restful few days. I know that the plan was that we would take some days off so that the attorneys and I could work on some things, and then we would be ready to go first thing this morning. And unfortunately, we weren't able to start right away this morning. I want to make sure that you don't hold that against either party. I want to remind you about that. It's not either side's fault. Blame it on me if you must. Blame it on someone. Do not take it out on either side, okay? But I do appreciate your patience. That means a lot to me. You folks have been extremely patient throughout, and I appreciate that. What I'm going to do now is ask my staff to distribute some instructions. So if you would do that, please. These are introductory instructions, and we're going to give each of you a copy so that you can follow along as I read them here in the courtroom. We are going to retrieve these instructions from you once I'm done reading them, and then we will proceed with the sentencing hearing. All right, does everybody have one? Everybody's saying yes and not in their head yes. Okay, let's start sentencing hearing, phase 1, introductory instruction number 1. And please follow along as I read this to you. Members of the jury, now that the trial has been completed, we are starting the sentencing hearing. It is your duty to determine the punishment to be imposed on the defendant for the commission of the crimes of murder in the first degree. You will be solely responsible for determining such punishment. Based upon your earlier verdicts, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are 2 guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued 2 theories of liability as to each deceased victim: murder in the first degree after deliberation and murder in the first degree extreme indifference. The 2 guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's sentencing verdicts alone will determine the sentences for those crimes. You must make 24 separate determinations, one for each count of murder in the first degree, in any phase we go through in this sentencing hearing. Only the 24 counts of murder in the first degree are subject to the sentencing hearing. It is not your responsibility to determine the punishment for the other 141 offenses of which the defendant was found guilty. The law requires that I, as the judge, impose the sentences for those offenses. I will sentence the defendant on those offenses at a later date. In Colorado, the crime of murder in the first degree may be punished by either imprisonment for life without the possibility of parole or death by lethal injection. Therefore, there will be 2 sentencing choices in this sentencing hearing with respect to each count: the penalty of life imprisonment without the possibility of parole or the penalty of death. Under Colorado law, a sentence of life imprisonment without the possibility of parole means just that. The person receiving the sentence must spend the rest of his natural life in prison. A defendant in Colorado who is sentenced to life imprisonment without the possibility of parole cannot ever apply for parole or ever be released on parole. A death sentence is never mandatory or required. The law never requires a death sentence. The fact that the defendant has been found guilty of murder in the first degree does not mean that a death sentence is required or appropriate. The court reminds you that no defendant may ever be sentenced to death based solely on a conviction for murder in the first degree. The sentencing hearing may consist of up to 3 phases. The purpose of the sentencing hearing is to determine the appropriate sentence to be imposed upon the defendant for the crimes of murder in the first degree. You must consider the evidence presented and the arguments of the attorneys with an open mind. I may give you instructions at the beginning of any phase of the sentencing hearing that we may go through. Additionally, I will give you detailed instructions at the close of the evidence and prior to your deliberations at the end of any phase of the sentencing hearing we may go through. Colorado law requires that you carefully follow the instructions I give you as you make any decision during the sentencing hearing. I will now provide an overview as to how this sentencing hearing will be conducted. Please keep in mind that these are just introductory instructions. You will be given more detailed instructions later on during the hearing. Further, you should not infer from these introductory instructions that there will be a phase 2 or a phase 3 in this sentencing hearing. I'm giving you these introductory remarks about all 3 possible phases, even though we may never get to phase 2 or phase 3, because it is important that you have a basic understanding of these phases before we proceed with the sentencing hearing. Phase 1. In phase 1, the prosecution has the burden of proof with respect to each count of murder in the first degree. As to each count, the prosecution is required to prove beyond a reasonable doubt the existence of at least one of the aggravating factors it has alleged in this case. Therefore, you must make 24 separate determinations in phase 1 of the sentencing hearing. As to each of the 24 counts of murder in the first degree, you must decide whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor. Before finding the existence of an alleged aggravating factor with respect to any count, the jury must unanimously agree that the prosecution has proven beyond a reasonable doubt that alleged aggravating factor. To prove an alleged aggravating factor beyond a reasonable doubt, the prosecution must prove beyond a reasonable doubt each of the elements of the aggravating factor. There is a statute in Colorado that lists possible aggravating factors. Consequently, aggravating factors are sometimes referred to as statutory aggravating factors. An aggravating factor is a fact or circumstance that increases the severity or seriousness of the defendant's conduct. In this case, the prosecution has alleged the following 5 statutory aggravating factors. Number 1, the prosecution alleges that the defendant unlawfully and intentionally, knowingly or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. Number 2, the prosecution alleges that the defendant intentionally killed a child who had not yet attained 12 years of age. Number 3, the prosecution alleges that in the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the victim of the offense. Number 4, the prosecution alleges that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And number 5, the prosecution alleges that the defendant committed the offense of murder in the first degree while lying in wait or from ambush. At the end of phase 1, the jury will deliberate. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a sentencing verdict of life imprisonment without the possibility of parole on that count. On the other hand, if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt at least one of these aggravating factors with respect to a count of murder in the first degree, the jury must render a verdict that reflects that finding, and the sentencing hearing will continue to phase 2 on that count. Phase 2. In phase 2, if there is a phase 2, the defendant may, but is not required to, present mitigation, although the jury must consider all evidence of mitigation regardless of who presents it. The law requires the jury to give full consideration and effect to all mitigation presented. A mitigating factor is a fact or circumstance which does not constitute justification or excuse for the offenses in question, but which in fairness or mercy may be considered as extenuating or reducing the degree of the defendant's moral culpability. Thus, mitigation refers to a fact or circumstance that might cause a juror to vote for a life sentence. There is a statute in Colorado that lists possible mitigating factors. Therefore, they are sometimes referred to as statutory mitigating factors. One of the mitigating factors listed in the statute is any evidence which bears on the question of mitigation. In other words, mitigation is any evidence that might cause a juror to vote for a life sentence. If the defendant presents mitigation evidence, the prosecution will have the opportunity to rebut that evidence. At the end of phase 2, the parties will have an opportunity to make closing arguments, with the defense going first and the prosecution going next. The jury will then deliberate. Each juror must individually determine whether one or more mitigating factors exist. The jury need not unanimously agree that mitigating factors exist or that the same mitigating factors exist. Each juror must then weigh the mitigating factors that he or she has determined exist against the aggravating factors proven by the prosecution beyond a reasonable doubt in phase 1. This process is not a mere counting process, Your decision should not be mechanical or mathematical. Rather, the weighing process requires a critical evaluation of any mitigating factors and the aggravating factors proven. Each juror must individually decide whether he or she is convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven aggravating factors. Neither party has the burden to prove anything in phase 2. However, as to each count of murder in the first degree, the sentencing hearing will only continue to phase 3 if the jury unanimously finds beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors. If, with respect to a count, the jury unanimously finds beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors, it must return a verdict that reflects that finding, and the sentencing hearing will continue to phase 3 on that count. Otherwise, the sentencing hearing as to that count ends, and the defendant will be sentenced on that count to life imprisonment without the possibility of parole. In reaching your decisions during phase 2, you must not be influenced by prejudice or bias of any sort against the defendant. You must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. A juror must use his or her individual reasoned moral judgment during this phase of the sentencing hearing. Further, each juror may consider mercy for the defendant during phase 2 of the sentencing hearing. Your exercise of moral judgment and mercy must be based upon evidence and or information that was 1. Presented during the trial and that I tell you may be considered, and or 2. Presented during the sentencing hearing. The law requires that your decisions not be the result of mere passion, bias, prejudice, conjecture, or any other irrational or arbitrary emotional response. Phase 3. In phase 3, if there is a phase 3, both the prosecution and the defense may present additional evidence and information. At the end of phase 3, the parties will have an opportunity to make closing arguments, with the prosecution going first and the defense going next. Each side may also have an opportunity to make a rebuttal closing argument, with the prosecution going first and the defense going last. The jury will then deliberate in order to decide the appropriate sentence on each count of murder in the first degree, life imprisonment without the possibility of parole, or death. During the deliberations at the end of phase 3, each juror must individually determine the appropriate sentence on each count. Neither party has the burden to prove anything in phase 3. However, the jury may only return a verdict of death on account of murder in the first degree if it is unanimously convinced beyond a reasonable doubt that death is the appropriate punishment. If the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must either 1. Return a unanimous verdict of life imprisonment without the possibility of parole, or 2. Notify the court that it is unable to reach a unanimous verdict. If the jury is unable to reach a unanimous verdict on a count, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. In reaching a verdict in phase 3, you must not be influenced by prejudice or bias of any sort against the defendant. You must treat the defendant as a uniquely individual human being, and you must not consider any public opinion or community sentiment for or against him. A juror must use his or her individual reasoned moral judgment during this phase of the sentencing proceedings. Each juror may consider mercy for the defendant during phase 3. Your exercise of moral judgment and mercy must be based upon evidence and or information that was 1. Presented during the trial and that I tell you may be considered, and or 2. Presented during the sentencing hearing. The law requires that your decisions not be the result of mere passion, bias, prejudice, conjecture, or any other irrational or arbitrary emotional response. With regard to each count, each juror must apply his or her reasoned moral judgment in deciding the appropriate sentence in light of the totality of the circumstances present. As to each count, each juror must ultimately make a reasoned moral assessment of whether death or life imprisonment without the possibility of parole is the appropriate punishment for the defendant on that count. The jury's sentencing verdict on each count must be based on a profoundly moral evaluation of the defendant's character and crime. Sentencing hearing phase 1, introductory instruction number 2. In a sentencing hearing, the parties may rely on the evidence introduced during the trial that the court instructs you may be considered. Therefore, the prosecution may opt to proceed in phase 1 solely by presenting argument. Although the defendant does not have a burden of proof in phase 1 or at any other time in a sentencing hearing, he may present evidence and or his attorneys may present argument. Sentencing hearing phase 1, introductory instruction number 3. To the extent that I tell you that you may only consider certain evidence introduced during the trial for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Similarly, to the extent that I tell you that you may only consider certain evidence introduced during the sentencing hearing for a limited purpose, you may only consider such evidence for the limited purpose that I tell you it may be considered. Sentencing hearing phase 1, introductory instruction number 4. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. With respect to each count, the prosecution has the burden to establish that at least one of the 5 aggravating factors alleged has been proven beyond a reasonable doubt. The defendant has no burden of proof in phase 1 or at any point in the sentencing hearing. All right, that concludes the reading of the sentencing hearing phase 1, introductory instructions. So I'm going to have my staff retrieve all of those copies from you at this time. And the record should reflect that Ms. Gerlings is doing just that right now. The record should reflect that Ms. Gerlings has now collected all of the copies of my introductory remarks to this sentencing hearing. All right, at this time, do the people have any evidence to present in phase 1?
No additional evidence, Your Honor.
Does the defense have any evidence it wishes to present in this phase 1?
No, sir.
All right. Members of the jury, since the parties have rested and the evidence has been completed in this phase 1, the next step in the proceedings is for me to give you the final jury instructions. And just like we did with the final jury instructions at the end of the trial, you'll get to keep your copy of these instructions, and those of you who deliberate will get to have them with you during deliberations. And so I'm going to have my staff now distribute to each of you a copy of the final phase 1 jury instructions. And once you each have received a copy, I am going to read them verbatim here in the courtroom and ask you to follow along as I read them to you. After I finish reading the instructions to you, the final instructions to you, the attorneys will have an opportunity to make their closing arguments, and then the jury will deliberate, okay? All right, does everyone have a copy? Yes, everyone has a copy. Okay, let's start. Jury instructions, phase 1 of sentencing hearing, instruction numbers 1 through 18, given by the court this 22nd day of July of 2015. Sentencing hearing, phase 1, instruction number 1. Members of the jury, phase 1 of the sentencing hearing has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your phase 1 sentencing verdicts. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things you need to keep in mind when you are discussing this case in the jury room. In these instructions, I refer to the first part of the proceedings as the trial, and to the present part of the proceedings as the sentencing hearing. Until you have returned your phase 1 sentencing verdicts, you must follow all of the following admonishments. You must reach your phase 1 sentencing verdicts based only on the evidence presented in the courtroom that I tell you may be considered and the instructions of law provided by the court. This includes most, but not all, of the evidence presented during the trial, as I will explain later in these instructions. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not communicate in any way with anyone else about this case or this kind of case. This includes your family, members, and friends. You must not read, review, or accept any communications in any form from anyone regarding this case or a case like this one. All you can tell family members, friends, acquaintances, and strangers is that you're on a jury in Arapahoe County that is anticipated to be completed at the latest by the end of August. If you notice that people are discussing the case, remove yourself from that location immediately. Do not attempt to gather any information on your own about this case. You must not read or conduct any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. Many of us routinely use the internet to research topics of interest, but you may not do that in relation to this case. You may not use Google, Bing, Yahoo, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, court personnel, and me. This applies whether you're here at home or anywhere else. Do not read about this case in the newspaper or on the internet. Do not listen to any radio broadcast about the trial, and do not watch any television news reports regarding the trial. Do not attempt to visit any places mentioned in this case. Do not in any other way, try to learn about this case or this kind of case outside the courtroom. Do not talk to the witnesses, parties, and attorneys about anything. Do not talk to any members of the media about anything. Do not have any contact through any means, including in person, by telephone, text, or email, with any jurors who have been discharged. You also should not have any contact through any means, including in person, by telephone, text, or email, with any of the alternate jurors. Make sure you wear your juror badge whenever you're on the courthouse grounds, and that your juror badge is visible to those around you. If you have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. You will get your electronic devices at the end of the day before you go home. Lastly, although you may start deliberating when I tell you that you may do so, you may discuss this case only when you are all present and only when you are in the jury room. No juror should attempt to discuss this case with another juror or other jurors except when all the jurors are present in the jury room. All deliberations must occur in the jury room when all 12 jurors are present. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. You have received all of the evidence that you may properly consider in reaching your Phase 1 sentencing verdicts. Your Phase 1 sentencing verdicts must be made by applying the rules of law that I give you to the evidence presented during the trial that I tell you may be considered. Remember that you must not be influenced by sympathy, bias, passion, prejudice, or any other arbitrary factor in reaching your Phase 1 sentencing verdicts. At times during the proceedings, the attorneys have made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions that I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the proceedings, you must not consider it in your deliberations. Similarly, if during the trial I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. I asked questions of witnesses during the trial. That did not mean that I had any opinion about the facts in the case. Remarks and rulings I have made during the trial and the sentencing hearing should not be understood by you as suggesting any opinion or feeling on my part as to what has or has not been proven in this case. Further, remarks and rulings I have made during the trial and the sentencing hearing should not be understood by you as suggesting any opinion or feeling on my part as to what Phase 1 sentencing verdicts you should reach. I remind you that I am neutral in these proceedings. Sentencing hearing Phase 1 instruction number 2. You are instructed that in determining whether the prosecution has met its burden of proof in Phase 1 of the sentencing hearing, you are to give separate and individual consideration to each alleged aggravating factor with respect to each count of murder in the first degree. In this phase of the sentencing hearing, the prosecution has the burden of proving beyond a reasonable doubt at least one alleged aggravating factor with respect to each count. The evidence and the law applicable to each alleged aggravating factor should be considered separately and influenced by your decisions as to any other alleged aggravating factors. Likewise, the evidence and the law applicable to each count should be considered separately and influenced by your decisions as to any other count. Regarding each count, the fact that you may or may not find that the prosecution has proven beyond a reasonable doubt the existence of an alleged aggravating factor should not control your decision as to whether the prosecution has proven beyond a reasonable doubt the existence of any other alleged aggravating factor with respect to that count or any alleged aggravating factor with respect to any other count. Based upon your earlier verdicts, the defendant has been found guilty of 24 counts of murder in the first degree. As you know, there are 2 guilty verdicts for murder in the first degree with respect to each deceased victim because the prosecution pursued 2 theories of liability as to each deceased victim: murder in the first degree after deliberation and murder in the first degree extreme indifference. The 2 guilty verdicts for each deceased victim will eventually merge into a single conviction for murder in the first degree, and based solely on the jury's sentencing verdicts, the defendant will receive a single sentence for that conviction. Accordingly, the defendant will stand convicted of 12 murders in the first degree, and the jury's sentencing verdicts alone will determine the sentences for those crimes. You must make 24 separate determinations in Phase 1 of the sentencing hearing. As to each of the 24 counts of murder in the first degree, you must decide whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor. Before finding the existence of an alleged aggravating factor with respect to any count, the jury must unanimously agree that the prosecution has proven beyond a reasonable doubt that alleged aggravating factor. Sentencing hearing Phase 1 instruction number 3. With respect to each count of murder in the first degree, you shall presume that an aggravating factor alleged by the prosecution does not exist unless you unanimously find that the prosecution has proven beyond a reasonable doubt the existence of that alleged aggravating factor. The burden of proof in Phase 1 of the sentencing hearing is upon the prosecution to prove to your satisfaction beyond a reasonable doubt the existence of at least one of the aggravating factors alleged with respect to each count of murder in the first degree. To prove beyond a reasonable doubt the existence of an alleged aggravating factor, the prosecution must prove to your satisfaction beyond a reasonable doubt all the elements of the alleged aggravating factor. The defendant has no burden of proof. Please keep in mind that in reaching your guilty verdicts on the 24 counts of murder in the first degree, you were not asked to determine or even consider whether the prosecution had proven beyond a reasonable doubt the existence of the aggravating factors alleged for purposes of the sentencing hearing. You are now being called to make an independent determination regarding whether the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to each of the 24 counts of murder in the first degree. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the sentencing hearing will end as to that count, and the jury will render a sentencing verdict of life imprisonment without the possibility of parole on that count. If the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the sentencing hearing will continue on that count to phase 2. The jury cannot find that an alleged aggravating factor has been proven with respect to a count unless each juror agrees that each element of the alleged aggravating factor has been proven by the prosecution beyond a reasonable doubt with respect to that count. Sentencing hearing phase 1, instruction number 4. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. Sentencing hearing phase 1, instruction number 5. You are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight whatsoever in your decisions in phase 1 of the sentencing hearing. No juror should allow himself or herself to be influenced or prejudiced against the defendant because of the fact that the prosecution seeks the death penalty. Sentencing hearing phase 1, instruction number 6. The fact that the prosecution asserts that aggravating factors exist in this case is not evidence. You should not consider those assertions as any proof or evidence that the alleged aggravating factors exist. Sentencing hearing phase 1, instruction number 7. In reaching your phase 1 sentencing verdicts, you may consider any evidence that was presented during the trial with one exception. You may not consider any evidence that was admitted during the trial solely for your consideration of the issues raised by the defendant's plea of not guilty by reason of insanity. Additionally, the court reminds you that during the trial it admitted other evidence for a limited purpose. You may consider such evidence in making your decisions in phase 1 of the sentencing hearing only for the limited purpose I told you about when it was admitted. Sentencing hearing phase 1, instruction number 8. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Sentencing hearing, phase 1, instruction number 9. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that the number of witnesses testifying for or against a certain fact during the trial does not, by itself, prove or disprove that fact. Sentencing hearing, phase 1, instruction number 10. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, the court reminds you that you are the sole judges of the credibility of each witness who testified during the trial and the weight to be given to each witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship that the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Sentencing hearing, phase 1, instruction number 11. Regarding the evidence admitted during the trial that you may consider in reaching your phase 1 sentencing verdicts, which does not include evidence admitted solely for your consideration of the issues raised by the defendant's plea of not guilty by reason of insanity, the court reminds you that you are not bound by the testimony of witnesses who testified as experts during the trial. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. Sentencing hearing, phase 1, instruction number 12. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as a negative inference and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. Although the defendant has been found guilty of murder in the first degree, he retains his constitutional right not to testify during the sentencing hearing. The defendant exercised his constitutional right not to testify during the trial and phase 1 of the sentencing hearing. You shall not draw any negative inference from the defendant's exercise of his constitutional right not to testify. The exercise of this constitutional right cannot prejudice the defendant in any way. The defendant's exercise of his constitutional right not to testify cannot be used as a reason to find that the prosecution has proven any alleged aggravating factor. Sentencing hearing, phase 1, instruction number 13. At this phase of the sentencing hearing, for each of the 24 counts of murder in the first degree of which the defendant was found guilty, you must determine whether the prosecution has proven beyond a reasonable doubt the existence of at least one of the aggravating factors it has alleged. On this particular issue, the prosecution has the burden of proof. The defendant has no burden of proof. In order to meet its burden of proof, the prosecution must prove beyond a reasonable doubt all the elements of at least one alleged aggravating factor with respect to each count of murder in the first degree. The elements of alleged aggravating factor number 1, 2 or more people, are A, that the defendant, B, unlawfully, C, intentionally, knowingly, or with universal malice manifesting extreme indifference to the value of human life generally, D, killed 2 or more persons, E, during the commission of the same criminal episode. The elements of alleged aggravating factor number 2, intentionally killed a child under 12 years of age, are A, that the defendant, B, intentionally, C, killed a child who had not yet attained 12 years of age. Note, aggravating factor number 2 is only alleged with respect to counts 9 and 21. The elements of alleged aggravating factor number 3 created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree are A, that the defendant, B, in the commission of the offense of murder in the first degree, C, knowingly, D, created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. The elements of alleged aggravating factor number 4, especially heinous, cruel, or depraved manner are A, that the defendant, B, committed the offense of murder in the first degree, C, in an especially heinous, cruel, or depraved manner. In order to prove beyond a reasonable doubt that the defendant committed the offense of murder in the first degree, in an especially heinous, cruel, or depraved manner, as alleged in this aggravating factor, the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. The elements of alleged aggravating factor number 5, lying in wait or from ambush, are A, that the defendant committed the offense of murder in the first degree, that was B, and C, while lying in wait or from ambush. After considering all the evidence, if you decide that the prosecution has proven beyond a reasonable doubt each of the elements of an alleged aggravating factor with respect to a count of murder in the first degree, you should find that the alleged aggravating factor proven exists with respect to that count. After considering all the evidence, if you decide that the prosecution has failed to prove beyond a reasonable doubt any one or more of the elements of an alleged aggravating factor with respect to a count of murder in the first degree, you should find that the alleged aggravating factor that was not proven does not exist with respect to that count. Sentencing hearing, phase 1, instruction number 14. Certain words and phrases used in the aggravating factors alleged have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in these instructions and in the verdict forms. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. Sentencing hearing, phase 1, instruction number 15. You were permitted to submit written questions to witnesses during the trial. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror was not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express my opinion about the question. My decision whether or not to allow a question was based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that were submitted by yourself or your fellow jurors. in making your decisions, you must consider all of the evidence that has been presented. You should modify that by adding that I tell you may be considered. So that sentence should read, in making your decisions, you must consider all of the evidence that has been presented that I tell you may be considered. Does everyone get that? Anyone need a pen or a pencil to make that change on your copy? For the record, I made the change by hand on the original. I have the original set here, and this set will go back to the jury room during deliberations. Did everyone make that change? I'll repeat it one more time. The last sentence should read as follows. In making your decisions, you must consider all of the evidence that has been presented that I tell you may be considered. So we're adding at the end of that sentence that I tell you may be considered. And the reason I'm doing that is that I gave you an instruction earlier that says that there is certain evidence that was admitted during the trial that you cannot consider during your deliberations after phase one. Does everyone get that? Everyone's saying yes and nodding their head yes. Wonderful. All right. Is everybody finished making that change? Okay, now everyone is. Great. Sentencing hearing phase one, instruction number 16. You have been allowed to take notes. Whether or not you took notes, you should rely on your memory as much as possible. The notes you took are to refresh your own memory. You should not give additional weight to the comments of any juror based upon the quantity or quality of his or her note-taking. Sentencing hearing phase one, instruction number 17. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of the bailiffs who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Sentencing hearing phase one, instruction number 18. Following the attorney's arguments at the end of phase one of the sentencing hearing, the bailiffs will escort you to the jury room so that you may deliberate. It is your duty as jurors to consult with one another and to deliberate. However, each of you must individually decide the issues for yourself after discussion and consideration of the evidence presented during the trial, which I tell you may be considered. Your foreperson will preside over your deliberations and shall sign the part of a sentencing hearing phase one verdict form according to the rules that I am about to explain. Each sentencing hearing phase one verdict must be reflected in Part A of the verdict form and must represent the considered judgment of each juror. Similarly, if you decide you should complete Part B of the verdict form with respect to a count, your response or responses to that part of the verdict form must represent the considered judgment of each juror and must be unanimous. All of you must agree to all parts of each verdict form. You will be given 24 sentencing hearing phase one verdict forms, one for each count of murder in the first degree. Each sentencing hearing phase one verdict form shall be completed in the manner that reflects your decision or decisions and shall be signed by the foreperson as indicated. There are two parts to each verdict form, Part A and Part B. If the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should have the foreperson sign only on the designated line in Section 1 of Part A of the verdict form for that count. In that event, the sentencing hearing on that count will continue to phase 2. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should have the foreperson sign only on the designated line in Section 2 of Part A of the verdict form for that count. In that event, the jury will render a sentencing verdict of life imprisonment without the possibility of parole on that count. Only one sentencing verdict shall be returned signed in Part A of each sentencing hearing Phase 1 verdict form. If the jury does not unanimously find the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury should disregard Part B of the verdict form for that count. If, however, the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to a count of murder in the first degree, the jury must complete Part B of the verdict form for that count by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors that the jury unanimously finds the prosecution has proven beyond a reasonable doubt. The sentencing hearing Phase 1 verdict forms and these instructions shall remain in the possession of your foreperson until I call for them in open court. Upon reaching your sentencing verdicts, you will inform the bailiffs, who in turn will notify me, and you will remain in your jury room until called into the courtroom. I will now read 2 sample sentencing hearing Phase 1 verdict forms. You must not draw any inferences based on the verdict forms I have selected to read to you. And everyone has a copy of the sample verdict forms, is that correct? Great, okay, let's go through those at this time then. And again, these are just 2 sample verdict forms that I randomly chose. Sentencing hearing Phase 1 verdict form. Count 1, murder in the first degree after deliberation, Jonathan Blanc. Part A, 1, we the jury do unanimously find that the prosecution, there's a typo there, so please ignore that. That should read the prosecution, has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. And by the way, it looks like the original verdict forms do not contain that typo, so we don't have to worry about it. And then there is a space there for the foreperson to sign in case that's the jury's sentencing verdict. 2, we the jury do not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. Therefore, we the jury render a sentencing verdict of life imprisonment without the possibility of parole on this count. And there's a space there for the foreperson to sign in case that's the jury's sentencing verdict. The single asterisk reads as follows: if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in Section 1 above. The jury must then complete Part B of this verdict form. The double asterisk reads as follows: if the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in Section 2 above. The jury should then disregard Part B of this verdict form. Part B, if the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury should disregard this Part B. If, however, the jury does unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury must complete this Part B by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors that the jury unanimously finds the prosecution has proven beyond a reasonable doubt. The first bracket reads as follows: alleged aggravating factor number 1, 2 or more persons. The defendant unlawfully and intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. Note, Alleged aggravating factor number 2, intentionally killed a child under 12 years of age, does not apply to this count. The next bracket reads as follows. Alleged aggravating factor number 3, created a grave risk of death to another person in addition to the 12 victims of the crime of murder in the first degree. In the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. The next bracket reads as follows. Alleged aggravating factor number 4, especially heinous, cruel, or depraved manner. The defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And the final bracket reads as follows. Alleged aggravating factor number 5, lying in wait or from ambush. The defendant committed the offense of murder in the first degree while lying in wait or from ambush. And then there's a place there for the foreperson to sign in case the jury determines that he should complete Part B of the verdict form for that count. Sentencing hearing, Phase 1 verdict form, count 9, murder in the first degree after deliberation, Veronica Mosher Sullivan. Part A, Section 1, we the jury do unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. And there's a space there for the foreperson to sign in case that's the jury's verdict. Section 2, we the jury do not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one of the alleged aggravating factors with respect to this count of murder in the first degree. Therefore, we the jury render a sentencing verdict of life imprisonment without the possibility of parole on this count. And there's a space there for the foreperson signature in case that's the jury's verdict. The asterisks read as follows. The single one says, if the jury unanimously finds that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in Section 1 above. The jury must then complete Part B of the verdict form. Double asterisk. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the foreperson should sign only on the designated line in Section 2 above. The jury should then disregard Part B of this verdict form. Part B reads as follows. If the jury does not unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury should disregard this Part B. If, however, the jury does unanimously find that the prosecution has proven beyond a reasonable doubt the existence of at least one alleged aggravating factor with respect to this count, the jury must complete this Part B by having the foreperson mark with an X in ink the bracket or brackets next to the aggravating factor or factors the jury unanimously finds the prosecution has proven beyond a reasonable doubt. The first bracket reads as follows. Alleged aggravating factor number 1, 2 or more persons. The defendant unlawfully and intentionally, knowingly, or with universal malice manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. The second bracket reads as follows. Alleged aggravating factor number 2, intentionally killed a child under 12 years of age. The defendant intentionally killed a child who had not yet attained 12 years of age. The next bracket, the third bracket, reads as follows. Alleged aggravating factor number 3, created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. In the commission of the offense of murder in the first degree, the defendant knowingly created a grave risk of death to another person in addition to the 12 victims of the crimes of murder in the first degree. Fourth bracket reads as follows. Alleged aggravating factor number 4, especially heinous, cruel, or depraved manner. The defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. The fifth and final bracket reads as follows. Alleged aggravating factor number 5, lying in wait or from ambush. The defendant committed the offense of murder in the first degree while lying in wait or from ambush. And then there is a space there for the foreperson to sign in case the jury determines that it should complete Part B of the verdict form for that count. Just a few things. We're going to take a break here in just a moment because we've been at this for over an hour now. And what I propose, if it's okay with everyone, is taking a short 10-minute break or so, 10, 15-minute break, bringing you back in at that point, and have the attorneys do their closing arguments, their arguments. I have limited each side to 40 minutes. And then at that point, we would let you start deliberating, at least those of you who are deliberating jurors. The alternates will be kept separate and the alternates will not be allowed to deliberate. Same rules as before apply. And then we'll bring lunch to you. We'll have lunch brought to you. And lunch will be brought for everyone, even if you're not deliberating. And then the deliberating jurors can deliberate while they're eating lunch if they wish. They don't have to do that, but they can do that if they wish, as long as they follow all my admonishments. We will have all the exhibits available in the jury room where the jury will be deliberating. That's jury room for courtroom 201, with the exception of those exhibits that you're not allowed to consider in phase 1 of the sentencing hearing. Remember that I've given you an instruction that the deliberating jurors during their deliberations cannot consider any evidence that was admitted for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity. So that applies not only to the testimony, but to all evidence, including any exhibits that were admitted for that limited purpose. Does everyone understand that? And everyone's saying yes and not in their head yes. I know that all of you still have your copies of the jury instructions that I gave you at the end of the trial. And I know that some of you may have taken notes on those instructions. And I told you that you could do that. We're not going to ask for those copies back, but what I am going to ask is that you not consult those instructions. Even if you're not a deliberating juror, even if you're an alternate juror, let's have all of you not go back to those instructions and read them or review them for any reason, all right? So I've given you a new set of instructions that applies to phase 1. That's what we just went over right now. The original set of instructions is stamped original, and we'll go back to the deliberations room. And then we have the original verdict forms, and they too will go back to the deliberations room. Please don't make any markings on the original instructions and the original verdict forms. You can mark all you want on your copies of the jury instructions that I just gave you and on your copies of the sample verdict forms that I just read. But no markings should appear on the original set of instructions, and the only markings that should appear on the original verdict forms is where the foreperson indicates the jury's sentencing decisions in phase 1. Does that make sense to everyone? Yes, everyone's saying yes and nodding their head yes. At least some of you are. Next is, there are no limits on deliberation. So the jury takes as little or as long as the jury wants. One thing that's going to be different is there's not going to be a 3-hour delay once the jury reaches its sentencing verdicts. We'll wait 20 minutes. So instead of the 3 hours that we did at the end of the trial, all right? And then the final thing is, and there are 3 things here. Throughout the proceedings, I have been giving you an admonishment that tells you that you cannot be exposed to any news reports in any way related to this case. And so I want to make sure that you understand that to the extent that in the past you have been exposed to any media or news reports related to the case, even if inadvertently, and even if despite your best efforts, then let my bailiffs know that you need to talk to me about something. Similarly, if that happens in the future, same thing, right? Even if inadvertently or despite your best efforts at some point in the future, you're exposed to some information related to the case or anything related to the case from a news report or a media report, please tell one of my bailiffs that you need to talk to me. Another admonishment that I have been giving you is that that you cannot visit any locations that are mentioned in the trial. Same type of admonishment. If at any point in the past you have inadvertently visited a location that has been mentioned in the trial, even despite your best efforts, or if that happens in the future inadvertently, even if inadvertently, and even if despite your best efforts, let one of my bailiffs know that you need to talk to me about something. And that's all you need to tell my staff, my bailiffs, is that you need to talk about something. And finally, if at any point in the past or at any point in the past you have inadvertently seen or received any outside information concerning the case from any source, or if at any point in the future that were to happen, even if despite your best efforts and even if inadvertently, let my bailiffs know that you need to talk to me about something, and then we'll take it up here in the quorum. Does everyone understand all that? And everyone's saying yes and not in their head yes. Great. Okay, with that then, folks, let's go ahead and take a break. It's hard to take 10 minutes with so many of you, but let's do our best to take 15 minutes if we can, and then we'll proceed with closing arguments. I should ask you, is that okay with everyone? It's going to mean that you're going to get lunch a little bit later than usual. Is anybody not okay with that? Is anybody who's not okay with that proposal? No, nobody's raising their hand. Great. I very much appreciate your attitude, folks. Thank you. Please make sure you follow all my admonishments during the break. They all apply. Oh, I was wondering what you were doing. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. Is there anything we need to talk about at this time on behalf of the people, Mr. Orman?
Thank you.
Anything we need to talk about on behalf of the defense, Ms. Brady? Okay, great. We'll be on break. Thank you. I'll see you in 15 minutes. Court will be in recess.
"15 minutes away from finally hearing the closing arguments, which I had been calling opening statements earlier today. There's no evidence being presented to the jury in terms of phase one, the aggravation part of the penalty phase. And just a quick clarification from Rob McCallum, I saw he was tweeting to someone earlier from Colorado Public Radio that technically this is the penalty phase, not the sentencing phase. The penalty phase because the sentence would be imposed by the judge after the jury reaches its conclusion with the penalty phase. The 40 minutes for each side includes the prosecution going first, defense second, and then a rebuttal if there's any time left that had been kept in the bank by the prosecution. And then the jury will go and deliberate whether or not certain criteria were met in this crime that calls for the death penalty to be allowed. And we know that at least two of them were met. One being that the intentional killing of someone who had not attained the age of 12 years old. I guess you could quibble over intentional or not, but based on the verdicts of after deliberation and with extreme indifference, that might already sweep us through to phase two automatically. And the other thing is that multiple people were killed in the event. Only one has to be met in the aggravation phase for us to continue to phase two, and that's the mitigation phase. And then that's when you'll start to hear the character of the defendant, and then the jury would be asked to see, does that outweigh the crime itself, or would we move to phase three? During this shortened break, we want to get with 7 News legal analyst Rick Kornfeld. And Rick, the day has not really moved much. It's 12:27. Court started at 8:40. 3 hours and 45 minutes so far of instructions and objections. The defense I'm not sure who it really was that upset the judge, equally both the prosecution and the defense, but after the defense objected to this PowerPoint presentation, or at least multiple portions of it, the judge basically laid down new ground rules and told both sides, this is ridiculous, we've got a jury waiting. What do you risk by making a judge upset when really it's the jury making all the decisions?
Well, I mean, you know, judges are very, very protective and respectful of the time, of the jurors' time, and they hate, and I'm not talking about in a death penalty case, I'm talking about in every case, judges hate making jurors sit on their hands. So the parties work real hard to make things move efficiently, and unfortunately, there are sometimes last-minute things, and judges get aggravated, and it happens all the time. I am frankly surprised, just given the length of this trial, the emotions of this trial, the stakes, literally the life or death stakes of this trial. I'm surprised it hasn't happened more, and I think that's in part a testament both to the professionalism and the preparation of all the attorneys, and also to the wonderful judicial demeanor and professionalism of the court. So he was aggravated. What side was he aggravated at? It really doesn't matter, and it will be forgotten, and it's probably forgotten at this point. The only time you care as a lawyer, I mean, you don't want to upset a judge, but the only time you really care if you're upsetting the judge is if the judge begins to either overtly or even, a little bit subconsciously starts taking it out on you, and the jury picks up on that. But that's not the case here. So, that's a little interesting seeing people get a little aggravated, but at the end of the day, I think it's much ado about nothing.
Are the objections much ado about nothing? Clearly, at least one of them in this case, by objecting to multiple uses of a photo of Veronica Mosier-Sullivan, that was sustained, and so the prosecution's still allowed to show the photo, but only once. In the closing arguments, they objected to a number of the PowerPoints slides and actually had many of those sustained where George Brockler had to adjust some of the PowerPoint slides. But are these objections really for the jury or really for appeal?
They're really for the Court of Appeals, and in a death penalty case in particular, they are critically important. They're the opposite of much ado about nothing. You are obligated, as we've talked about, and my colleagues have talked about, and your colleagues have talked about, lawyers are obligated to object on a contemporaneous basis. And so the bottom line is when the state is trying to put to death your client and you are on the defense side, you have to make every single possible objection that you believe is well-grounded in the law, and you do that for the Court of Appeals. And what's going on here is this stage one, whether or not the aggravated factors exist, it's a pretty clinical thing. I mean, as you said in the introduction of this segment, basically two of the aggravating factors have already been established in the trial, the number of victims and the young age of one of the victims. So I think what the defense was really objecting to is bleeding into the emotional part of this case, which is of course what you're afraid of on the defense side, letting it bleed into phase one and arguing that it's not relevant and therefore it's not appropriate. I happen to think that's a pretty good argument. The judge has to balance, was one picture enough? How many seconds are you allowed to show the picture? Those kinds of things. But the backdrop of those arguments is that the defense is trying to keep this portion of the penalty phase clinical and trying to keep the prosecution from, basically bleeding the emotions into it in a way that might influence the jury.
Okay, but we're talking about the life or death of someone. How is this not about emotion? Because we've heard that you can take into the deliberation room for the penalty phase your own life experiences and what you believe and feel on your own beyond the testimony that you hear in court. So why is this phase why can't you do any more emotion in this phase than you could in the trial, in the testimony?
It's a great question, and the answer really is it's just how the process is designed. Part two, or phase two, and phase three, if there is a phase three, That's really when those factors come in. But phase one is supposed to be about whether the government has established beyond a reasonable doubt the existence of one or more aggravating factors. But I agree with you. I mean, to say that a death penalty case isn't emotional is a little bit crazy. But on the other hand, the legal system presupposes a clinical approach to events that are, by definition, highly emotional. I mean, any crime is emotional to the victims of the crime, to their families, to witnesses, sometimes to law enforcement officers. This case is that, of course, on steroids, but the law really tries, justice is supposed to be blind, and the one way that you blind Lady Justice is to try to take emotion out of it.
Okay, to emotion, we have already someone who was deposed, a video deposition of a 5th grade teacher of the defendant. That'll be shown to the jury at some point. How is someone like that not going to the emotion of the jury? This person has not had contact with the defendant in could be 2 decades and is supposed to tell them, the jury, about who he is so that they may not consider the death penalty for him. And I assume we're going to hear from other people who have very cursory dealings with the defendant and may have known him at some point, maybe long ago. Is that not dealing with the emotion of the jury?
No, it does, but don't forget that was really part of phase 2. That was just taken out of order to accommodate the 5th grade teacher. So all I'm saying is that phase 1 is supposed to be the more clinical part of the penalty phase, and that's why I think the defense was objecting. But you're right. I mean, the defense, it's hard to have your cake and eat it too. On the one hand, you sort of want the government to put on this clinical approach, and on the other hand, as a defense lawyer, you want to have the latitude to put on as much personal information and therefore, to your point, emotional information as you can in an attempt to humanize your client and to get at least one of the jurors to exercise mercy by not finding that death is the appropriate sentence. So you're right. I mean, this is a classic example of where the limitations of the criminal justice system run up right against the realities of life, and the realities of life and the realities of cases and the realities of this kind of case, in this case in particular. It isn't. I don't think the goal is to take emotion out of it. I think what the judge is trying to do is to strike an appropriate balance, and that's what his concern is. That's what his job is. That's what the lawyers are doing through their objections or through their advocacy. And you're exactly right. We are going to see a lot more of that in the coming days, and in an attempt to strike that balance. What's an appropriate balance? Who knows? And what's an appropriate balance in a death penalty case? That's a really tough question to answer. But despite that, we're going to see a bunch of professionals trying to strike that balance right before the jury's eyes and right before our eyes.
Rick, we had talked over the trial about the involvement of the district attorney in how much he had been involved in the questioning of especially the key witnesses. Here we have a district attorney who said Justice's death on April 1st, 2013, when it was revealed that the Arapahoe County would seek the death penalty against the defendant. And now we have Rich Orman, who has been number 2, the assistant district attorney sitting next to him the whole time, appearing to take the lead with these closing arguments of phase 1 and being the voice of the district attorney's office. Is that anything that the jury will say, oh, what's going on here? Or can we take anything of it? With the district attorney not being the key person in this part of the penalty phase?
No, I don't think so. I think that, when you're on a trial team, regardless of whether you have, in this case, the highest elected official in the county, you want to divide up. You want to divide up the arguments. You're always concerned that a juror, may not like one person's style or may not like that person for whatever reason. So it's a good idea to break it up. It's also a good idea, to divide up the workload. The reality is that the lead attorney generally saves the biggest arguments for himself or herself, and the phase 1 argument's not the biggest argument. We're going to see George Brockler in the phase 2 argument, I would guess, and I would almost bet anything that if there is a phase 3, we're going to see George Brockler arguing phase 3 for the government.
Rick Kornfeld joining us in what's supposed to be an abbreviated lunch hour, I guess it's the afternoon recess, whatever we're going to call this now. It's in between morning recess, afternoon recess, 12:37 right now. Rick, thanks for joining us here. 5-10 minutes, I'm assuming, is when court will be back underway, and that's when we'll hear 40 minutes for both sides in a closing argument of Phase 1. As Rick has said, we've met two criteria to move past Phase 1, but it needs to be decided by the jury. Does the jury believe that certain criteria has been met to move us, based on Colorado law, into the next step of the penalty phase? So what we're going to hear is 40 minutes from the prosecution with some PowerPoints, again, showing the victims, telling their stories, revealing the impact it probably has had. Well, I don't think that may have to wait till Phase 2, but at least going, once again, over the facts of the case. And then you'll hear the defense going as far as saying, don't kill our client, essentially, because they're not going to say that just yet. Just going to fight back on the facts of the case, and then the jury will go deliberate, and we'll likely move on to Phase 2, which is when we'll hear some character witnesses for the defendant. So what we want to do until court gets back underway, because we're just not certain when it's going to be back, again, it's going to be about the victims and who was impacted directly by what happened on July 20th, 2012. So we've put together some clips of those victims taking the stand throughout the testimony part of the trial. So we're going to play that. We'll interrupt it when court is back in session for the closing arguments of Phase 1 of the penalty phase, a 3-part section in this Aurora Theater shooting trial penalty phase.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
I was.
Did that go into the early morning of July 20th, 2012?
It did.
Could you please tell the jury about what you remember about the day of July 19th of 2012, prior to going to the movie theater?
Well, we started off our day a little late, but we were spending time together. I was up here on vacation. We went to the Coors Brewery.
I'm going to stop you for a second. Who's we?
We, Jessica and myself.
And who's Jessica?
Jessica Gowie is my good friend of almost 10 years.
How'd you know Jessica?
I met her in high school back in fall of 2002, and so it began. Gosh, we covered a lot of ground in that time, and great friendship. We dated for a while.
Interject an objection under 403 and 401.
The objection's overruled, but ask your next question, please.
What, were you visiting Jessica from another state?
I was. I'm from Texas.
Right. So when had you arrived to visit Jessica?
I arrived, I believe it was the 17th of July.
Of 2012?
Of 2012, yes.
What do you recall doing with Miss Gowie that day?
That day, as I said, we went to the Coors Brewery. We went on a tour, hung out, and we went back to her residence, and we just played catch-up. We hung out by the pool. We just talked like we hadn't got to talk in a while. She had moved up here the year prior, and...
An objection 403.
Sustained.
Did you and Miss Gowie decide to go to the movie theater that day?
We did. After much persuasion, she twisted my arm, essentially. She's like, I never thought I'd have to twist a guy's arm to go see Batman. But any which way, we decided to go see the midnight release, and turns out they were sold out of tickets as soon as we tried to buy them. She checked again, and turns out there was a 12:05 showing. So we bought the tickets, and eventually made our way to the theater later on that evening.
Do you recall approximately what time you got to the theater that night?
I'm going to go out on approximately, it was probably about 11:40, 11:45.
What'd you do?
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. I have two notes from jurors. The first one is from juror number 737, and it reads as follows: I need to speak with the judge about something. We're going to mark that note, Court Trial Exhibit 96, so C-TR-96. And then I have a note from juror number 640. that we're going to mark as Court Trial Exhibit 97, C-TR-97, that reads as follows. My mom sent me a text saying sentencing was this week, but I have not talked to her about anything. I did before it started that I had jury duty in Arapahoe County. That was all I told her. I also did not respond to her text and deleted it. I don't think we need to take any action with respect to juror number 640, but I think I need to bring in juror number 737 and see what he wishes to talk to me about. Is there any objection to me not taking any action with respect to number 640 on behalf of the people?
No, Your Honor.
On behalf of the defense, Ms. Brady? Okay, so we'll just proceed with 737 by agreement of the parties. Let's bring in juror number 737, please. The record should reflect that juror number 737 is now present in the courtroom. We're still outside the presence of all the other jurors. Good afternoon.
Go with that.
How are you?
I'm good. How are you?
All right, good. Thank you. You sent me a note that reads as follows. I need to speak with the judge about something.
Yes, sir.
And so what's on your mind?
Well, it's funny because I wanted to talk to you about it anyway, and then you said the thing right before we went in. I was really concerned because I got tweeted at over the weekend by someone I don't know with a linked article from Newsweek that mentioned me by name, like first and last name. So I didn't click the link to the article or anything. I didn't read it, but it brought up some concerns for me about media stuff in general. So.
All right, but you didn't read the content of the article at all?
No, there was a little blurb that just said that I was the foreman, and that was about it. But yeah.
Okay, and so you didn't read anything else?
Yeah, it just mentioned me by name.
Okay, all right. Anything about that you think affects your ability to carry out your duties as a juror pursuant to your oath in this trial?
Not at all.
Or in these proceedings?
No.
Not at all? Okay. Anything about that you think would affect you in any way as a juror in this case?
No.
Do you have any other concerns about that?
Well, I do, just in general, about privacy in the media in general. I don't know if there's something you can do as the judge to, it was just weird to see my name there. That was not cool.
And as you know, I issued an order, as I informed you at the beginning of the trial, that prohibited the media from publishing any of the jurors' names. So, okay. I'm going to have you step out for just a moment, okay? Thank you. All right. Any other questions or any other record that people want me to make with respect to Juror 737? And then let's split it up into two. One is what action, if any, the parties think I need to take with Juror number 737, and whether there are any other questions that you want me to ask. And the other one is with respect to Newsweek, and that's a separate issue. So, Mr. Orman?
To take any further action with regard to the juror. With regard to Newsweek, gosh, Judge, I really don't know. I mean, if they violated an order of the court, and I say if because I haven't read this article myself, and I don't know what, if any, information the person that wrote the article would have had about the court's orders beforehand, or how they might have figured this out exactly. It seems like it's up to the court to take any action with regard to violation of that order. And if the court wants to issue a contempt citation to have a hearing, I think that would be for the court to do. I guess that's all I have to say.
All right. Ms. Brady, anything with respect to juror number 737 in terms of whether you think I need to ask additional questions or I should ask any additional questions, or whether you think or are asking me to make any additional record?
Can I speak to the other lawyers for a moment?
Yes.
Thank you. All right, Your Honor.
Ms. Brady, any other record that you want me to make with respect to juror 737 on this particular issue, or are there any other questions that you are requesting that I ask?
If the court would just make sure that he hasn't told any of the other jurors about this, and assuming he has not, instruct him not to mention this to any of the other jurors. And that's all we're requesting regarding the juror. Regarding the Newsweek, we have located very quickly a Newsweek tweet that appears to be consistent with what the juror was describing. We'd like to make further record on that when we get a break. I don't think we need to do that right now, but we would like to make further record on that.
Okay. All right, let's bring in juror number 737 again, please. I think that wait, hold on, sorry. I think that the request by Ms. Brady is an appropriate one. I'm assuming that people don't have any objection.
Not, Your Honor.
All right, let's bring him in. The record should reflect that juror number 737 is back in the courtroom again. One other question that I have is, have you told any other jurors about this?
Oh, no.
No. And will you promise me that you will not tell any other jurors about this?
Of course.
And will you promise me that you will not discuss this with any other jurors?
Yes.
And if at any point you have any other any concerns about this at all, will you promise me that you will indicate to my bailiffs that you need to talk to me?
Yes, of course.
Okay. Anything else that I can address for you?
That's it.
Okay, you did the right thing in letting us know. Thank you.
Thank you.
All right. The records reflect that juror 737 is now has now exited the courtroom. Given the record that was just made, I don't believe there's a request from either party from more questions or for any other record or for any action. Is that correct, Mr. Orman?
That's correct, Your Honor.
Is that correct, Ms. Brady? Yes, sir. All right. I suggest that we bring the jury in at this time so we can proceed with counsel's arguments. And then maybe after the break, if the defense wants to make a record, at that point, the defense can, and we can have further discussion about the issue in terms of Newsweek. All right, let's bring the jury in, please. Thank you. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Welcome back, folks. Thanks for coming back. At this time, we're going to proceed with closing arguments at the end of phase one. And we'll start with the prosecution. Mr. Orman, you may proceed.
Thank you. I'm going to talk to you, ladies and gentlemen, about phase one of the capital sentencing hearing in this case. And I'm going to talk to you about the 5 statutory aggravating factors that the judge just advised you about before the break.
Mr. Orman, is your mic on? There you go. Thank you.
Thank you. Did everybody hear me? Okay, everybody heard me, so I'm not going to repeat what I just said. First, I want to talk about the evidence. Because as the judge advised you, you can consider most of the evidence that was presented to you in the first part of the trial, all 250 or so witnesses that you heard, with some exceptions. The judge told you about some evidence that was admitted solely for the purpose of determining the defendant's sanity. You cannot consider that. But you can consider all the rest of the evidence, and there were some limiting instructions for that you can consider for a limited purpose too. For instance, some statements and emails that you can consider for the purpose of figuring out what the response to the email meant. You can use that evidence in these proceedings, but not the evidence that was admitted solely for the purpose of determining the defendant's sanity. That is not admissible in this phase, and if I'm talking to you about inferences from evidence, I'm not talking to you about that. I'm talking to you about the other evidence. So I want to put in context these 5 statutory aggravating factors and the evidence that you have heard. So let's talk about aggravating factor number 1. And you have that instruction, but I just sort of typed this out from that instruction, that the defendant intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. So intentionally, that was the same culpable mental state with another part of attempted murder, a murder after deliberation. And then you have this knowingly with universal malice. That's the same culpable mental state that you had with murder, extreme indifference. And then killed 2 or more persons during the commission of the same criminal episode. The defendant killed, and you have convicted him of killing Jonathan Blanc. The defendant killed, and you have convicted him of killing A.J. Boyk. The defendant killed, and you have convicted him of killing Gordon Cowden. The defendant killed, and you have convicted him of killing Jesse Childress. The defendant killed, and you have convicted him of killing Jessica Gowie. The defendant killed, and you have convicted him of killing John Larimer. The defendant killed, and you have convicted him of killing Matthew McQuinn. The defendant killed, and you have convicted him of killing Michaela Medic. The defendant killed, and you have convicted him of killing Alex Sullivan. The defendant killed, and you have convicted him of killing Rebecca Wingo. The defendant killed, and you have convicted him of killing Alex Teves. And the defendant killed, and you have convicted him of killing Veronica Mosier Sullivan. The evidence has shown you that the defendant killed 12 people, murdered 12 people in the course of a single criminal episode. We have proven to you, beyond a reasonable doubt, statutory aggravating factor number 1. Statutory aggravating factor number 2. That the defendant intentionally killed a child who had not yet attained 12 years of age. So let's talk about this a little bit. Intentionally means it was his conscious objective to achieve that specific result. His conscious objective to kill a child who had not yet reached 12 years of age. Well, what do we know about that? You remember the testimony of Dr. Learcall that Veronica Mosier Sullivan had 4 separate gunshot wounds to her little body, and that she was 6 years old. She was shot 4 times by the defendant. 4 times. When you shoot someone 4 times, you do it with intent. And you have the conscious objective to kill them. Also, the evidence shows you that the defendant had the conscious objective to kill everyone in the theater, man, woman, and child alike. And why do I say that? You heard about the hundreds of rounds of ammo that the defendant took to that theater. You saw all of those magazines that he had on him, all those magazines filled with bullets that he had on him. That he went in there with 3 weapons. The handgun, the AR-15, and the shotgun. He went in there with enough firepower and enough ammo to kill everybody. And that's what the evidence shows you he intended to do. And how do we know he intended to kill a child? How do we know that? Well, I'm going to ask you to go back a long way. This trial's been a long trial. I'm going to ask you to go back all the way to April 28th. And you heard from a witness named Chi-Chi Sproul. And what did she tell you? She told you that that theater was packed with kids. Not only that, she said she'd never seen a theater with more kids in it. And if she wanted to sit away from kids, she couldn't find a spot. It was hard for her to find a spot away from kids.
Excuse me, object misstatement of the evidence.
Members of the jury, remember that you determine what the evidence is. The attorneys can make arguments and they can disagree on what the evidence was. You need to rely on your own memories of what the evidence was. So the objection is overruled with that cautionary instruction that you're not bound by the arguments of counsel. You need to rely on your own memory of the evidence. All right, you may proceed.
Think about the testimony of Corbin Dates. You all got to remember Corbin Dates. And what did he tell you? He told you that there was a baby, a little baby, in the same row that the defendant was in that theater.
Judge, objection, misstatement of the evidence.
Same ruling, same cautionary instruction.
You heard the testimony about little Mr. Rurs, 3-year-old kid who was in that theater. Again, lots of kids in that theater. The defendant had the intent to kill every single one of them. We have established beyond a reasonable doubt that he intentionally killed a child who had not attained the age of 12 years. Aggravating factor number 3, that the defendant, in the commission of the offense of murder in the first degree, knowingly created a grave risk of death to a person in addition to the 12 victims of the crimes of murder in the first degree. A grave risk of death to someone other than the people that he killed. Well, there's Theater 9. Did the defendant create a grave risk of death to everyone in that theater? I submit to you the evidence shows he did. He brought that gun in there. There he is with that gun, strapped right here. He brought that rifle into the courtroom. And there it is, lying on the ground outside the theater, out back, with the blood of a victim or victims of a gunshot wound right there. He brought in a magazine that could hold 100 rifle rounds. 100. And he used steel penetrator rounds. And there they are. right there on the floor with those green tips to kill as many people as he could. He also used that shotgun found in the theater right there, and he used that handgun found on the top of his car. And there's all his implements together on the bed, the handgun you can see at the bottom, and the shotgun and the rifle at top. And these are the items that he used to knowingly create that risk that someone else might get killed other than one of the victims of murder. And let's talk about what evidence was found in the theater, because that's important too. 65 shells for 223 rounds. 5 shells for 40 caliber handgun rounds. And 6 shells for shotgun rounds that each held 100 pellets. So you add all that up, that's at least 76 shots inside the theater. And if you count those shotgun pellets as individual projectiles, which you should, because you saw all the way that they spread out and the damage that they did, 670 individual projectiles shot in that theater. Here's the shooting incident reconstruction that Mr. Mills, the FBI expert, showed you, and this is every round where they could find a trajectory in Theater 9 and going into Theater 8. Did that create a risk of death to someone other than a homicide victim? I submit to you it did. Here's one of the rounds, went into that metal pole, created that hole. Person shooting that off in a theater, is that creating a grave risk of death to everybody in there? I submit to you it does. This is another diagram. It's kind of hard to see up there, but maybe you can see it here. This is the shooting incident reconstruction for rows 8 and 9 in that green trajectory. And let's take a look at some of the damage to row 8 there. Those are the rods. Those are the rods from the bullet trajectories in row 8. Grave risk of death to everybody in row 8? I submit to you the answer to that is yes. Row 9. Look how low they are there. Grave risk of death to everybody hiding on the floor? I submit to you yes. That is the back of a seat you heard in row 9. Going through the back of the seat. Grave risk of death. Here's another one. This is the seat bottom in row 9. Look at these holes. Look at what that rifle did. Went through that seat like a hot knife through butter. Grave risk of death. There's a diagram for row 10. You can't see it up there very well. It was better on my computer. You have that back there to take a look at. And there are the rods for row 10, and you can see them for row 11 too. Grave risk of death to everybody there? I submit yes. There's a row 11 seat bottom. You can see that bullet hole. Row 19, almost up to the top. Seat bottom. Grave risk of death? I submit yes. Everybody in Theater 9 that wasn't killed was in a grave risk of being killed, and he knowingly did that. Even going into Theater 8, there's that hallway on the side of Theater 9, the wall going into Theater 8, the trajectory rods. And there they are on the other side, in Theater 8. I'm going to have to click this one manually. And there is the diagram in Theater 8. And as you can see, one of those rounds went all the way across, and you heard somebody got shot way on the other side of Theater 8. Well, I think this ran out of batteries, so I'm just going to do this manually over here. Okay, so consider the injuries. Consider the injuries that you heard about to the people in Theater 9 and Theater 8 in determining whether the defendant created a grave risk of death to these people. And I'm just going to show you some of them. Heather Snyder, grave risk of death. Zach Goldich, Grave risk of death. He was in Theater 8. Petra Hogan. Grave risk of death. Jameson Toes. Grave risk of death. Farah Soudani. That's an injury to her legs. Is that a grave risk of death? And you remember the testimony, how her organs were literally pouring out of her body and had to be held in by hand. Grave risk of death. Caleb Medley. He came in here, you saw him. Grave risk of death to him. Dion Rosborough. Grave risk of death. Stephen Moten. Grave risk of death. Adnan Avia Ariando. Grave risk of death, shot in the leg. Yusuf Garbi. Grave risk of death. Lean Young. Grave risk of death. Bonnie Kathleen Poroso Zogby, and you'll remember her, she came in with the flowers in her hair. Grave risk of death. Ashley Mosier. I know you all remember Ashley Mosier. Grave risk of death to her in the theater. I submit to you there is a grave risk of death to any of them and all of them and everybody else in Theater 9 and everybody else in Theater 8, and that we have proven to you that statutory aggravating factor. Here's the next one. Statutory aggravating factor number 4. That the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And the judge gave you an additional instruction on this, that the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. And you got to consider this individually for each person he killed. So let's talk about that. A conscienceless or pitiless manner, which was unnecessarily torturous to the victims. Were these offenses committed in a conscienceless or pitiless manner? I submit to you the evidence shows that they were. They were. How about unnecessarily torturous to the victim? Well, let's talk about what that means. I would ask you to consider the circumstances of these murders and how that shows you that they were committed in an unnecessarily torturous manner. See, not every murder is going to be unnecessarily torturous. You could kill someone, I guess, in a humane fashion. Were these murders committed in a humane fashion? Or were they unnecessarily torturous? Consider, the defendant modified the environment of the theater by deploying tear gas. There's a can of tear gas right there, clear out. There were 2 cans. This is the one that was found outside. This means that, and you can make a reasonable inference based on the evidence, and what you heard happened in that theater from many people, that the victims would experience extreme discomfort from the tear gas in addition to being shot. Is that unnecessarily torturous? I submit to you it is. I submit to you it is. The defendant killed his victims in a crowded movie theater. Now that in and of itself might not be torturous, but think about what that means and the implications of that. They were trapped in there by design. And why do I say by design? Because of the tear gas. And because it's dark. And because it's crowded. They were trapped in there and they couldn't easily protect themselves. And the tear gas made it hard for them to move. Some unable to flee, and you heard lots of testimony about that. Lots of testimony about that. In darkness. In darkness. And they knew, they would have had to know, any human being would know, that there was nothing they could do to protect themselves. Nothing they could do to stop him from killing them, and that death was imminent. so they could think about it. I submit to you that is mental torture. I submit to you that is unnecessarily torturous, in addition to all the images that you saw of how these people died. That is unnecessarily torturous. I would also like you to think about the fact, or the inference you can make from the evidence, that at the moments of their deaths, the victims would not only be in fear for their own lives, but in fear for the lives of their friends and family and loved ones. And I submit to you, that's even worse than being in fear that you're going to die yourself. That you're afraid that your fiance or your child or your mother is going to die there with you. Unnecessarily torturous. They died, and you know this because you've heard the evidence, surrounded by screaming and by pain and by anguish. That is how they died. That is how he killed them. Dying like that is unnecessarily torturous. It is conscienceless. It is pitiless. It satisfies that aggravating factor defined by statute beyond a reasonable doubt. Let's take a look at the last aggravating factor. Aggravating factor number 5, that the defendant committed the offense of murder in the first degree while lying in wait and from ambush. Lying in wait, ambush. So I'd ask you to consider these victims of murder, the 12 victims of murder, before the defendant came into that theater armed with 3 firearms. They were unaware of any danger. How could they be aware of any danger? They were watching a movie in a movie theater, a place of enjoyment and safety. And they were helpless to do anything about what was about to happen to them. And the defendant was in a place of concealment, lying in wait, ambush. That's the place of concealment right there. You heard lots of testimony from lots of people in the theater that the defendant went in through that door. You heard lots of testimony from police that found him outside that door, at his car. You saw this. You actually have this in evidence, this clip that the defendant put on the door to keep it from closing all the way. This place of concealment, of hiding, of lying in wait to kill people who had no idea that anything was coming. They had no way to know. They could not know, unless they were somehow psychic, that danger stood right outside that door. The defendant went through that door, and he came in right there through that door. And then they knew. And then they knew, but they couldn't do anything to protect themselves. And then the killing started. The defendant came from a place of hiding and killed people who had no idea that danger was coming. That is ambush. That is lying in wait. And we have proven to you beyond a reasonable doubt that this aggravating factor is present for each and every count of first-degree murder. We have proven to you that all aggravating factors applicable to each count, because there's one aggravating factor only applies to 2, are present. We have proven that to you. And this is unlike the first phase of the trial where we would ask you to find the defendant guilty. You've already found him guilty. What we're doing here in this phase 1 is asking you to go back there and find that these facts are the truth. That they are the truth.
I'm going to object to the truth. Can we approach?
I'll sustain the objection. Why don't you rephrase, Mr. Orman?
That all of these factors are present beyond a reasonable doubt. I'd ask you to go back there, talk about it, discuss it, but decide that that is the case, fill out those jury verdict forms, and come on back here saying that that is in fact the case. Thank you very much.
All right, thank you, Mr. Orman. All right, Ms. Brady, is there a closing argument on behalf of Mr. Holmes at this time?
Your Honor, the defense has no argument regarding phase one.
Okay, thank you. All right, folks, given that there is no argument by the defense, that also means that there is no rebuttal closing by the prosecution. So with that, I'm going to send the deliberating jurors to deliberate. Please remember all my admonishments. In terms of the alternates, you cannot have any contact with the deliberating jurors at this time until I tell you otherwise. Now, we're not going to send you to the room where you were before during the trial, but you'll be in the other two jury rooms, but there will be no contact between the deliberating jurors and the alternate jurors at this time. Okay? Does everybody understand that? Okay, so I'm going to have the alternate jurors leave the courtroom first so we can escort you, my staff can escort you to your rooms. Folks, please keep in mind all my admonishments and make sure you do not deliberate at all. You cannot deliberate either with each other or even internally about anything related to the case, okay? All right, thank you. And for the record, the deliberating jurors are now exiting the courtroom. Excuse me, the alternate jurors, sorry, thank you. The alternate jurors are now exiting the courtroom with my admonishments in mind. And we'll have lunch brought to them. All right, for the record, the alternate jurors have now left the courtroom, and so let me again address the deliberating jurors. We're going to take you back to the courtroom 201 jury room so you can start deliberating. Remember that you can only deliberate when you're in the jury room and all of you are present, okay? All the exhibits that you're able to consider are back there in the room or already there. My staff took them there during the lunch break or during the closing arguments. We'll have lunch brought to you, and then make sure you follow all my admonishments during deliberations. Do not have any contact with the alternates at all, okay? All right, folks, you may retire now to the jury room for Division 201. The record should reflect that the deliberating jurors have exited the courtroom now. What I propose is that everyone get their lunch break, and then if you want to meet after the lunch break, we can talk at that time, Ms. Brady, okay? All right, let's take, is an hour enough? Let's plan to have counsel back here at 2:30, okay? 2:30. All right, the court will be in recess. Thank you.
Well, that was a lot quicker than we expected. Instead of 40 minutes on both sides, it was about, 20 minutes, maybe a little more than 20 minutes by Rich Orman and his PowerPoint presentation argument, closing phase one of the sentencing. And then Tamara Brady saying that they have no closing argument, thus getting rid of any possible rebuttal and the remainder of the time that Rich Orman had. But he probably knew that that was going to be the case. So right now the jurors are going to go deliberate. We're going to have an hour lunch as it is, but the jurors could deliberate during this lunch hour, and as soon as 2:30 comes around, we may be ready for the verdict from the jury, we heard we'll get a 20-minute notice before they read the verdict. So if they come back from lunch and there's still no verdict, we know we'll get 20 minutes notice prior to hearing what happens. Clearly, with no defense closing argument, it's pretty clear we're going to move to the second phase of this. And you heard Rich Orman go through each of the sections of the Colorado statute that dictate why this could continue on for a death penalty conviction, and describing how Veronica Mosier Sullivan was shot 4 times and that you shoot someone 4 times with intent. What he's getting at is that someone who is younger than 12 had to be intentionally killed for that portion of the statute to be met. And then he went through other factors of the number of people who were killed, how they were killed, how he changed the environment to make sure that they were killed. In the end, it will be up to these 12 jurors to decide if those aggravating factors have been met to continue on in the penalty phase to go to phase number 2. What we're going to do, and Phil Tenser put this together using stuff from yesterday when there was arguments being made in front of the judge. He has spliced together the actual statute, or the portion of the statute, and you'll see that text on the screen, followed by the arguments that the attorneys were making yesterday, at least on the prosecuting side, to support why that was going to be met. It'll make sense as you watch it, but instead of playing back for you what Rich Orman just did, we're going to play for you what led up to today and how it relates to that statute that allows for the death penalty in Colorado. So again, there's going to be an hour break, maybe a little more than an hour. It's 1:24 Denver time. 2:30, I think, is when we're going to be back in court, and we may have a verdict in phase 1 of the sentencing, of the penalty phase in the sentencing hearing, to move to phase 2, which is what we've been talking about being the character of the defendant, and basically that will be the portion to see if the jury could be swayed to keep him alive and not move on to phase 3 when you'll hear from the victims' families. But here's yesterday's arguments in front of the judge and how it relates to the Colorado statute that allows for the death penalty.
Ma'am, so that we can hear you, I'm going to give you this microphone. Can you hold that and still point to stuff if we do that?
Yeah.
Okay, let me give you that. Now, if you could, if you can reach, can you show us where you were sitting that you recall back on the 19th of July before the movie started?
Yeah, I believe it was in this 4th row right here, like in the middle.
Towards the middle, and I'm
Yeah.
pointing where I think the middle is. Am I close to one of the seats?
Yeah.
All right, now from where you were there, and let me ask this. Did you walk into the theater that night?
Yes.
From where I'm pointing, approximately where you were sitting, who was seated to your left?
Jameson was on my left.
Was anyone else to the left of Jameson?
Yeah, but we didn't know who was not with our group.
Yes, thank you. I should have asked a better question. Who was to the right of you?
Veronica.
Who was to the right of Veronica?
Kaylin.
Who was to the right of Kaylin?
Haley.
And again, these are approximations. I may not be touching the right seats. Is that fair?
Right.
Okay. And they're indicated on that people's exhibit that we just talked about?
Yes.
All right, after the arcade, all those kids in Jameson come back?
Yes.
And the movie starts? Yes?
Yes.
Do you have concerns that the movie now is not quite the family-friendly flick you thought it might be?
Yeah, during the previews, I kind of figured it was going to be a little more R-rated than I had thought.
What happened while you were watching the movie?
Well, I had all of a sudden during the previews, I heard something explode like to the back left of me.
And forgive me for saying, if you say back left, I'm pointing in a general area. Do you mean back in this area here?
Yeah.
Okay. And do you know what it was or where it came from?
No, I didn't see where it came from, and I didn't know what it was at the time. I just had heard something explode and then a bunch of gas coming out, and I don't know, I assumed it was a stink bomb from when I was like in high school, but I recognized it didn't have this smell. So.
Then what happened?
And then as soon as because I had turned my head, as soon as I heard it explode, and then right when I went to turn my head forward, I saw a flashing light in the sky, which I thought was or not the sky, in the air. Then I thought it was a firework.
Do you know where in the theater the firework thing seemed to come from?
Yeah, it seemed to come from like upper left.
I would give you the pointer, but are you talking about in this area where I'm pointing here or somewhere else? Tell me where.
Well, I guess a little, like more towards the middle front, like, yeah.
And you thought you saw something that was fireworks?
That looked like fireworks to me.
Now, before all that happened, before the movie starts, without going into any words that were spoken, where was Veronica at first sitting before you moved her?
During the previews, she was sitting on my lap.
Did you move her to that seat that you've indicated?
Yes, I did.
And why?
Just, she was, because I had just found out I was pregnant, and it just kind of hurt my stomach a little, and she was a very tall, bony child, so I had her move to the seat next to me.
Okay. So you hear that thing hit behind you and explode, the gas. You talked about the fireworks thing that you think up here. By the way, at that point, do you have any idea that it's gunfire?
No. I had no idea.
What did you do?
Well, I assumed it was just kids playing pranks. So my first thought was to leave the theater, but I went to stand up to reach for her hand to try to exit.
When you say her hand, you mean Veronica?
Veronica's hand, yeah.
Okay. Did her hand reach back?
No, I couldn't feel it. Like, it slipped through my hand.
Were you able to stand up?
As soon as I stood up, I just remember getting a hit in my chest. And I remember falling, then landing on top of her.
Do you know what hit you in the chest?
No, I thought it was a firework at the time.
When you fell on top of her, could you feel her moving?
No.
Could you feel her breathing?
No.
Could you get off of her?
No. I tried, but I couldn't move.
Do you hear anything going on around you?
Yeah, I hear the movie still playing and people crying and screaming and yeah.
Were you scared?
Yes.
What happened?
Well, the next thing I know is I was getting carried out, which I vaguely remember, out of the theater.
Do you know who carried you out?
No.
Do you know which direction they carried you out?
I mean, I kind of felt like it was down that way and out.
Out the aisle this way, and I'm using my finger.
Yeah.
And down as you're facing the screen, the right steps, and out the door that I'm pointing to towards the parking thingy?
Yes.
Did you see your daughter get carried out?
No.
When you got to the hospital, and you know what, ma'am, let's do this. We don't need to talk about this part anymore. Do you want to go back?
Yeah.
Let me take that.
Okay, so down that hallway, if you were to take a right, on the right side of that hallway is where the office is. So I exited the office and was standing right outside. Directly across from me is the employee break room. To the left is Theater 14. To the right is Theater 15. Anyway, so I exited the office, and at that point I saw some employees standing around in the hallway.
And then what?
At that point, people started coming out of Theater 15, and those people, as we discussed earlier, there's glass exit doors right next to 15. Those people were not heading that way. They were actually heading back towards, this picture, towards the lobby, towards the box office.
Is that weird?
No, it's not uncommon, right? If you're going to exit if something's happening, I think typically people's thought process is to go to the box office where they know there's people and kind of figure out what's going on.
So then what happened?
So at that point, I stopped those people from coming down the hallway because I knew that I had been told, or whatnot, that something was happening in Theater 9. So the problem is if they walk up to the box office, they would be walking past Theater 9, which we obviously didn't want. So I then directed those people out those glass exit doors.
After you start directing those people out into the parking lot, what happens?
At that point, I'm going to, run over to 9, and then I see, we had a dark night in auditorium number 10, which you can actually see that auditorium in this picture. It is right behind the women's restroom there. People started to come out of that auditorium, and same situation. They wanted to come towards the box office.
Towards where this picture is taken?
Towards where the picture is taken, correct. So I did the same thing there. I directed all those people to those glass exit doors down that hallway.
Now, you say, and I started making my way towards Theater 9, like given the information you had, that made any sense. Why were you doing that?
To investigate, I guess. I mean, right, I work there. I was curious.
Okay. So you stop the people from 10 going, you direct them again. What's next?
So at that point, I turned around from directing the people to head, towards 9, and I see people and smoke pouring out of the auditorium. And at that point, there was at least 3 police officers standing there.
Is it pouring out of that door that's in People's Exhibit 26? Which one is that?
Yeah, 2061.
2061. Is this the door that smoke's coming out of?
That's correct.
And what else is coming out of that door?
People.
And how are they coming out?
Quickly?
I'm going to interject with an objection. This is cumulative to a prior testimony of various first responders.
Overruled. Go ahead, sir.
So about to the left there, you see there's doors. That leads to the kitchen of the concession stand. So that's a little behind that is where the police officers were standing. And again, coming out of that door was the smoke and the customers.
Okay. Was there one specific individual that you remember or that you helped more than another?
Yeah, so it was kind of crazy, right? And I see this gentleman kind of stumble out, so he's not running like everybody else. And he actually kind of stumbles into those doors.
Object with an objection. Can we approach?
Yes. All right, the objection is overruled, but you must proceed with consistent with my instructions.
Yes, sir. Thank you. First off, do us a favor. Would you describe the characteristics of this person? What did he look like?
A little under 6 foot, maybe, African American gentleman, kind of heavy set.
And what did his injuries appear to you to be that you helped him with?
Well, at the point when he came out of the auditorium, I honestly didn't think he was injured. The way that he was stumbling around, I thought he was drunk. So I kind of thought, like, right, that's all we need right now is a drunk guy about to get trampled by all these people coming out. So I was about to approach him, but then he actually got himself up off of the wall and started to walk back out. So I said, okay, clear and exit. He then kind of stumbled over to the concession stand area and stopped again. So at this point, I approached him. I realized he needed some assistance. So I go up to him. I actually, put my hand on him. I said, "Sir, are you okay?" At that point, he looked over at me, and he had blood coming from his mouth and a wound in his shoulder where I had touched him. And I knew that because I had blood on my hand at that point. So as I told you before, there was cops standing right outside of Auditorium 9, and I started yelling at them like, "Hey, this guy needs help, this guy needs help." And a cop then did come over at that point and escort the gentleman out of the front door.
Sir, I should ask you this. During the time that all this stuff is happening, after you realize something's going on in Theater 9, are there alarms in the theater that have been activated?
Yes.
What do they look and sound like?
They're flashing white, and just kind of a siren, going off. Inside, it was a constant sound, if I remember correctly.
It's not an intermittent kind of siren, like a intermittent siren?
I guess it's the first and only time I've heard that, so I can't tell you specifically. I don't remember if it was a constant sound, or an intermittent sound. I unfortunately don't remember.
And once it was on through pretty much your entire time in the building?
Yes, for the rest of the time that I was in the building, those lights were flashing and that alarm was going off.
What did you and Mr. Boxer do after you were crawling on the ground?
Someone had yelled to go to the exit at the top of the stairs. And so we had started that way to the left.
And where was the last place you saw the shooter in the theater?
He had disappeared behind the partition of the theater entrance.
And is that on the right side of the theater or the left side of the theater?
On the right side.
And is that the hallway that goes back to the lobby area of the theater?
Yes.
That was the last place that you recall seeing the shooter?
Yes.
So after you heard someone say to go run to that exit, could you still hear shots at that time?
Yes, I could.
Right? Tell the jury about how you were able to get out of the theater.
We had reached the edge of the seats and begun up the stairs. Something had spilled into my shoes, and I lose Dylan's hand at one point. And somebody picked me up and threw me into the seats.
And what did you think was happening at that point in time when you got picked up?
Action relevance. Overruled.
That means you can answer the question, Ms. Bone.
I wasn't sure that we were going to make it out at that point until Dylan grabbed my hand and we began up the stairs again.
So did Mr. Boxer find you in those other seats you had been thrown into?
Yes.
Could you describe for the jury what happened to your body as you were thrown into those other seats?
My upper back slammed down on the arms of the seats, and I reached out and Dylan was there, and he grabbed my hand and the strap of my purse and pulled me up.
Tell the jury about how you and Mr. Boxer got out of the theater.
We reached the top of the stairs and I tried to dial 911, and it was busy.
Do you recall seeing anything as you were walking up the stairs of the theater?
As I look back up from my phone and hanging up, by the trash can and the exit door. Somebody had not made it by the trash can.
Objection, Judge.
And did you observe anything else on the floors of the theater that evening?
I kept tripping on the stairs because there were shoes and flip-flops of people that had just left them behind.
Were you and Mr. Boxer able to get out of the theater that evening?
Yes, we were.
What happened when you got outside the theater?
We were looking for any signs of danger in the parking lot. And when we got to our car, we exited the parking lot and passed several police cars on the way out.
Were you able to make it home that evening?
Yes, I was.
Were you able to observe your body when you got home?
We inspected ourselves for injury and found that we were covered in blood that was not our own.
Did you specifically describe what you noticed about your arms?
I had bloody handprints that I suspect is from the person that threw me into the seats.
Did you have any bruises to your legs?
Yes, I did.
I'm going to have you come stand kind of right next to me right here. And if you could point on this diagram where you and Mr. Boxer were seated that evening.
We were sitting right about here.
All right. And where do you recall you sitting approximately? And where was Mr. Boxer?
I was sitting in this left seat, and he was sitting more towards the right.
All right. And could you describe for the jury where the shooter was when you first saw the shooter enter the theater?
He was right about here.
All right. And could you describe for the jury where that canister went that you saw the shooter throw?
The canister came up to about here and rolled down.
Could you describe for the jury where the shooter was when the shooter was holding the shotgun?
He came up about here, parallel with the first row of seats.
All right. And did the shooter move anywhere in the theater while he was using the shotgun? You
Yes.
could show the jury where that was.
He took a few steps up to about the third row.
All right. Where was the shooter when the shooter was using the rifle?
Approximately the same space.
Okay. And could you just show on the diagram for the jury where the shooter walked with the rifle?
Up to about here.
All right. And could you describe for the jury where was the last place that you saw the shooter?
Right about here.
All right. So is this the hallway you were talking about earlier about where you believe the shooter disappeared to?
Yes, it is.
Okay. And could you describe for the jury where it was that you exited the theater?
We exited through this exit here.
Right. And where was it that you got thrown into the chairs?
I'd say between these two rows. I can't remember exactly.
And do you recall where in the seats that you landed? Approximately.
Somewhere within the first seat or so.
Right. Thank you very much, Ms. Bowen. You can take your seat.
Ms. Bowen, the jury has submitted some questions that I have determined are appropriate under the rules of law and other applicable rules of evidence. The first question is, do you remember at what point in your story the shooting stopped completely?
I don't recall.
The next question is, did the shooting resume after the shooter entered the right theater entrance, if you know?
Coming down the stairs of the lobby, there were more sounds of gunshot.
All right, Ms. Tish McGuire, any follow-up questions based on those questions?
Yes, Your Honor, briefly. So Ms. Bowen, when you went out this top exit door at the very top of the theater, is there a balcony area when you get to the top of that area?
Yes, there is.
And then did you have to go downstairs to get to the lobby area?
Yes.
Is that the location where you were when you heard more gunshots?
Yes, it is.
Thank you. No further questions.
Is there a follow-up question, or are there follow-up questions based on those questions, Mr. King?
No, Your Honor.
All right, may this witness be released from her subpoena, Ms. Tisch-McGuire?
Yes, please.
Without objection.
All right, Ms. Bowen, thank you.
There are a number of markers on these seats. Do you know what those are?
Yes, these are markings when they went through and were marking any kind of potential bullet evidence. Impacts, perforations, penetrations.
Now, did you also retrieve evidence from these seats?
Yes.
And what did you get out of the seats?
We removed, well, I personally removed a spent bullet and a quarter that the bullet impacted inside the seat.
I'm going to hand you what has been marked as People's Exhibit 646, sorry. And do you recognize this item?
Yes. This is the quarter that was in seat 18. It was in the seat bottom down here, inside.
Your Honor, I'd move for the admittance of People's Exhibit 646.
Is there any objection? Without objection, it is admitted.
Your Honor, could I, well, I would like to publish my exhibits ultimately, but in the meantime, I guess could you explain what you observe about this quarter?
So the quarter has an impact mark in it, and when I lined up the bullet next to the quarter, they fit together.
Could I have 3098, please? What are we looking at in this photograph?
In this photograph, it's a seat located in row 8, seat 12, and we're looking at an impact in a soda cup that was in one of the cup holders.
3099, please.
This is a close-up of that cup, as well as a hole in the cup.
3095, please.
This is the front of the seat, impact 9-6, located in row 8, seat 12. I believe that says correct. Row 8, seat 12.
And 3096.
This is a close-up of that area on the front of the seat in row 8, seat 12.
And I see a number of little black circles in the seat on the front of the cushion. What do those reflect?
Agent Dufran circled the smaller holes, which were consistent with the pellet holes.
And could you then please approach the model and note where row 8, seat 12 is?
I'm going to object to this procedure. May we approach?
Yes. All right, the objection is sustained in part and overruled in part, and Ms. Pearson, you may proceed consistent with my instructions.
And Ms. Petalina, would you step down to the model, and I'm going to ask you to mark row 8, seat 12.
Okay, so once again, row 8 is going to be the first row in the stadium seating. Row 12, starting from the first seat. Would be located right here. 12 rows in from the north.
And to be clear, when you're marking the seat, you're not marking a particular hole or impact or anything like that. Is that right?
Correct. I'm just marking the seat and the row.
Thank you.
I remember more gunshots every few seconds. The projector room glass shattered. And I remember thinking I might get glass in my hands by being on the floor. And then I heard a very loud crack, which sounded almost like a seat had exploded upon impact. And then at that time, I heard Amanda scream Alex's name.
What do you remember after that?
There was a period of more gunfire. I stayed on the ground as long as I could. I didn't want to make myself a target. I didn't know if people were coming up the stairs on either side.
Now, after you heard Amanda scream Alex's name, did you look over and see Amanda and Alex?
I couldn't turn my body at that point in time without making myself known.
So you weren't able to see what was going on with Craig, Amanda, or Alex at that point in time?
No.
Okay. What do you remember after that?
There was a period of a lack of gunfire, and at that time, I counted slowly to 5 Mississippi to give myself enough realization that time had passed, and then I slowly went into a crawl, and then when I continued to not hear gunfire, into a run towards the end of the aisle.
What happened when you got into that run?
I saw more people coming up the left side of the theater towards the emergency exit, joined the crowd up into the emergency exit and back down a series of stairs and directly out the front doors of the theater.
At any point in time, did you realize if you had been injured?
I wasn't feeling much of anything physically at that point.
Was there at any point in time after the shooting, did you realize if you had been injured?
In the days after, I realized that I had bruises on my legs, on my thighs, on my knees, some scratches on my hands, but nothing that would necessitate having gone to an emergency room.
What happened when you got outside the theater?
As I got through the front glass doors, I realized that I was no longer with my group. But I ran to directly left out of the doors, through the parking lot, about halfway down the parking lot, ducked behind a car, and waited.
Were you able to meet up with your friends, Craig, Amanda, and Alex?
I waited for several minutes behind a car. There were groups of people that passed me that were getting into their cars and leaving, but everyone looked calmer than I felt. So I looked over the top of one of the cars, saw that people were gathering outside of the theater, and approached. And at that time, I began calling out my friends' names one by one until I was approached by Craig.
What did you observe when you saw Craig?
When I saw him, he was wearing a light-colored shirt, and it was splattered red with blood. He looked very dazed. And I saw a couple paces behind him was Amanda. She also looked dazed. I asked him where Alex was, and he shook his head.
Shook his head yes, shook his head no?
Shook his head no, and then looked at the ground.
What did you take that to mean at the time?
I took it to mean he was either seriously injured or dead.
What happened during the movie that night?
After the previews and everything, there were a couple scenes, and then Catwoman was stealing pearls, and I think the next scene was just about to begin at that point.
What do you recall happening during that scene in the movie?
During the Catwoman scene?
In your theater. What happened in your theater during that scene?
In the right-hand corner, there just kind of appeared a figure, and it seemed like he was in a doorway because there was just light all behind him. And it was a very broad, large figure completely in black, and it seemed like his limbs and his chest and that everything was almost blocky or like just broadened a lot.
What do you recall after seeing that figure?
A canister of gas was thrown like towards the left, like exit behind us, kind of in that direction. And its like tail of gas was lit up by the theater screen.
What do you recall happening after that?
There was a very loud bang, and I don't remember it all getting onto the floor, but I was laying with my stomach flat, with my right arm close to my body and my left around my head. And my head was closer to the left aisle and my feet were kind of behind.
What do you remember while you were on the ground happening in the theater?
Listening to these loud bangs, and that's not a good enough description for the force and the volume that they were. And at one point, I turned my head up to see these like sparks kind of towards the projector, but above my head, and they were like red or orange. And I started to feel like a stinging or some sort of something like obstructing my airway. And I was wearing a black and gold scarf, so I put it to my mouth.
What do you recall after putting that scarf to your mouth?
After that, I just started getting this very calm, kind of serene sensation that I was going to die.
Your Honor, 403, 401.
Overruled?
Sorry, could you say that last part again?
Yeah, I was lying there, just everything was still going on, but within my own body, I felt like it was very calm. If I was going to shut down, I was going to be done, and I was under the impression that I would be shot through my chest. I didn't.
Same objection, Your Honor, 401, 403.
All right, move on, Mr. McGuire.
How old were you that night in the theater on July 19th, 2012?
I was 17 years old.
How old was your sister, Sierra?
Sierra was 16.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 4716.
Yes.
Ms. Cowden, do you recognize the person in that photograph?
That is my dad.
Your Honor, at this time, I would move to admit People's Exhibit 4716.
Any objection?
No objection.
With that objection, it is admitted.
If I could please have 4716. Is this a picture of your dad?
I think I may have actually taken this on the hike that my sisters and my dad and I went on.
Thank you very much. So, Ms. Cowden, you were telling the jury about how you were on the ground, what you were hearing. What do you remember after that?
Still lying on the ground while I was expecting either the gas or a bullet, my attention turned to my dad saying, "I love you."
Objection, Your Honor, hearsay, 401, 403.
Sustained.
And then there
Move to
was a
strike, excuse
pause
me.
in the bullet. Sorry.
I sustain the objection. I've given the jury an instruction about my rulings when I sustain objections. The jury understands that. Move on.
After you remember hearing that, what do you remember happening next in the theater?
I was saying Dad, but I stood up because there was a pause in the bullets, and just moving towards that left aisle and abandoning my dad, just leaving him and going to the stairs.
What do you recall doing when you went down the stairs?
Down the stairs, Sierra was close to my left at this point, and we started down. And the stairs are longer, wider ones, and then shorter. And upon one of these longer ones was what I thought a female body, like her torso, coming out from the aisle, and her face was bloodied, and I couldn't really distinguish any of her features because she was so bloody.
Object at this point to 401 and 403.
Overruled.
You may continue, Ms. Cowden.
So this woman was on the stairs, and Sierra tried to pause. She didn't want to step over her, and I just commanded her to go. And so we kept going down and around the left exit and just got to the lobby where I realized she wasn't right next to me, and I looked back and called her name. And then we bolted through doors that were being held open at that point.
What do you remember after Ashley collapsing on top of Veronica?
I remember she kept screaming Veronica's name, and I kept telling her that she was okay, and I knew she was okay because I had my hand on her stomach to see if she was breathing, and she was. So I kept telling Ashley that Veronica was okay. And so then Ashley stopped yelling her name when I told her that Veronica was okay.
What do you remember after Ashley finally stopped screaming her name?
I remember asking Haley for her phone to call 911, and Haley gave it to me, and I called 911, and I took my hand away for just a moment, and then when I put my hand back on her stomach, it wasn't moving, and she wasn't breathing anymore, and then when the 911 operator answered, she was asking me like what was happening, and I told her that there was a shooting at Century 16, and she asked me if anyone was injured, and I told them yes, we had an injured child, and then she told me to give Veronica CPR, and I told her that I couldn't because Ashley, her mom, was on top of her, and I couldn't reach her chest, and she just kept telling me to give her CPR, and I kept telling her that I couldn't because I couldn't get to her chest. And the next thing I remember was giving Haley her phone, and she was talking to the 911 operator after that, but I don't know what they were discussing.
Good morning. Morning. Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes, I was.
Did that go into the early morning hours of July 20th of 2012?
Yes, it did.
Could you please tell the jury a little bit about what you remember from the day of July 19th?
I was working at Red Robin in Aurora. I had worked a double, and it was my friend Alex Sullivan's birthday, and a couple of my friends, my coworkers from Red Robin, were going to go to the movies that night to see the Batman movie, and I had no plans of going. I hadn't bought a ticket, and I was working a lot. And then one of my friends, my coworkers, convinced me to go, and they had an extra ticket for me, so I decided to go to the movie. I remember. I'm sorry.
Sorry, go ahead.
No.
Who did you go to the movie with that night?
I drove in a car with Chelsea Soblik and with Heather.
And what's Heather's last name, if you know it?
Snyder.
What time did you get to the movie theater that night?
I want to say around 10:30, maybe. 10. I don't honestly even know what time the movie started. So, but we got there a little bit later than the rest of our coworkers.
What do you remember doing when you got to the movie theater that night?
I went in. They had already sat down. There was a couple of seat switches. I remember originally sitting in one spot and then switching seats with my friend Alex Sullivan. I'm sorry, excuse me. I remember going outside to smoke cigarettes. It was just a normal night, you know. And then I do remember when the previews for the movie started, we were all sitting down, and my friend Alex was really excited for the movie, and he did kind of a countdown. And I kind of remember being, now, not really realizing that what we were counting down to. And that's basically it.
What happened during the movie that night?
I remember the scene on the screen. Anne Hathaway had just stolen something, and I heard this hissing noise like an aerosol can, and from where I was sitting, it was coming from the bottom left corner
of the movie theater. I remember hearing somebody, because I never saw it. I just heard it. And I remember somebody from that area scream or yell, "What the F?" We're trying to watch a movie. And then the next thing I know, I heard this very loud bang, and I immediately was hit in the legs. And my friend Heather, sitting next to me, was also, I assume, hit by the same round because she yelled out. And then I got down on the ground.
What happened as you got down on the ground?
As I got down on the ground, somewhere between sitting and getting down on the ground, I was hit in the face with another round, and I don't really remember. I do remember laying on the ground and spitting out teeth and blood, and my 4 front teeth were shattered. And I was laying on the ground, and it kind of went, we were all just kind of mangled up on the floor. And sorry. And I remember kind of laying on my side, and I was laying on my legs, which were in a lot of pain, so I tried to sit up to fix them, and when I sat up, I saw flashes from the gun go off, and it was then that I realized that it wasn't fireworks, and it was a gun. I remember Chelsea pulling me back down and telling me to be quiet, and she was on the phone with the police, and she was trying to tie something around my legs to stop the bleeding, and then I remember laying on my side, and a bullet came through the seats, and it skimmed my back, and I was laying like on my stomach, and it came through, so I switched over, and I laid on my side.
And can you describe for the jury what your body position was like at that point in time when you had moved?
Yeah, I was laying kind of facing the screen on my side, and my legs were closer to the aisle seat, actually this aisle, and my head was facing that way.
So your head was closer to the left aisle if you're facing the screen, and
yes,
your legs. And who were your legs closest to?
My legs were closest to Heather Snyder, and I remember kicking her in the hand when I was trying to like get comfortable, and my head was like laying on top of Chelsea and on top of my friend Sully's legs.
Could you hear anything in the theater?
Yeah, when we first laid down on the ground, it was really loud. There was a lot of loud bangs. Gunshots, and there was a lot of screaming. People running out, and then within a couple seconds, it got kind of quiet, and the only thing you could really hear were the gunshots.
Could you smell anything in the theater that night?
Yeah, I smelt my own skin, like the burning from the gunshots. I smelled blood and sulfur and smoke. It was pretty prominent.
What were you thinking?
That we were gonna die. It was kind of overwhelming. It kind of still is. And I just kind of remember thinking that those were the last.
Objection, Judge. 403 at this point.
Sustained. Next question, please.
What do you remember after lying on the floor, hearing the gunshots?
Eventually the lights did come on. I'm not sure at what point. There was like a faint alarm sound in the background. I'm not sure at what point that went on either. And my friend's Chelsea was standing up, and she was yelling that we needed help. And there were officers in the theater. And they came running up the stairs. There was an overwhelming amount of like change in what was happening. my friend Chelsea and Edgar were ushered out of the theater. They were not as badly injured. Chelsea wasn't hit, and Edgar just had a small wound. And then I remember being placed from the floor onto the chair, and they wanted me to leave, and I didn't want to leave yet. I kind of was a little too overwhelmed to leave.
What could you observe about your friend's injuries while you were sitting in that chair?
In the front of me there were two girls, both lying presumably dead in their own in blood in a pool of blood, and then to my left was to my left was I'm sorry. My friend Alex Sullivan, and he wasn't moving, and his chest wasn't moving either.
Yesterday we talked about a word that some people use to describe you inside as angry. Right. Okay. As you were thinking about these things, buying a Glock, ordering a tear gas, are you angry, or what's the thought inside you at that time?
Kind of that I have a mission to complete.
Mission to complete? Yeah. That doesn't sound angry, but maybe it is. Is angry in there anyway?
No, there's no anger.
Okay. Tell me more about the mission to complete thought.
Just that it was something I had to do.
Did the word mission come out of you or come from somewhere else?
From me.
From me. From you. Okay. Did the having to do it come from inside you or from somewhere else?
Inside me.
What do you make of that? What's the something you had to do? Tell me more about what that is.
It's like I was obligated to do it.
In what way obligated?
That there was no other alternative to doing something else compared to it.
And what creates a situation where there's no other alternative?
A depressed situation where I transfer my feelings from suicide to homicide.
What brings you to that explanation that the obligation came from, in your words, a depressed situation where you transferred your feelings from suicide to homicide? Where does that explanation or interpretation come from?
I just made it up, imagined it.
Is that what you were thinking or imagining at the time, or you just made it up just now with me?
No, at the time.
That's interesting to me, a little confusing to me. You just made it up and imagined it, that it was a transfer from the suicidal to the homicidal.
Yeah, so I take my suicidal thoughts and make them go away by having homicidal thoughts.
Had anyone or anything taught you that was a possibility, or what brought you to that conclusion? That my suicidal thoughts will go away if I have homicidal thoughts, or do homicidal things?
That's just what I figured would happen.
What you figured would happen?
Yeah.
So a little earlier we talked about suicidal thoughts. What were the suicidal thoughts like, if you remember?
Well, I didn't catatonic.
What do you mean by catatonic?
Like didn't have the drive to do anything other than the mission I made.
What else how else is catatonic kind of defined in your mind at that time? Or now for that matter?
You have lack of energy, just not willing to get up or do things that I normally do.
And that's the way you felt?
Yep.
In May, June, I think we're talking about, 2012.
Yeah.
Were you still going to classes at that time?
Yeah.
He still had some ambivalence about committing the crime, assuming it's judged to be a crime. There was a part of him that still wanted to be stopped, I believe, and a larger part, as he has said it, that didn't want to be stopped. It was one of the, I think he said, or I said, last resort efforts to see if someone would stop him.
How does that affect your assessment of his capacity to know right from wrong based on societal standards of morality?
He's aware that what he's doing is a bad thing, a wrong thing, and that if he contacts someone else or someone else is aware he's doing it, they will try to stop him because that person, the person he contacts, believes it's a wrong thing and he should not do it.
Despite what you've described as ambivalence and perhaps this conflict about should I, shouldn't I, is there anything about that that tells you that the defendant was still not in control of his decision-making when he made the decision to go in there and pull the trigger?
He was apparently wrestling with things a bit, but there's nothing that says he wasn't in control of his decision-making, and he had certainly carried out his plan up to the time he made the call and was prepared to go further, so far as I know.
Now, up to this point, we have heard about the planning and the execution of this crime. Is there anything about that that impacts your assessment of whether or not the defendant perhaps was suffering an acute psychosis of some kind?
You've said several times that the mission and the concept came from within you and not from outside you. You've never used a phrase like an outside power or a master power or a God talking to you or anything like that.
No, there wasn't command voices.
Okay. No command voices.
No.
How about just a feeling that there was some master of you that was moving you in a particular direction to do certain things?
No, I'd say I was my own authority.
We probably have another 10 minutes or so before court's back in session, and for all we know, the jury has already made come to a verdict on phase one of the penalty phase. What we want to do is get a second visit right now. It's an unusual day in terms of timing, but we want to get a second visit from 7 News legal analyst Rick Kornfeld. And Rick, the idea that the prosecution only took about half of its time, 20 minutes, and that we didn't hear anything from the defense for closing arguments in phase one, is there any surprise that the defense didn't say a thing?
No surprise at all. This was a loser. They know the government had met its burden. Phase one is not where the battle lines are being drawn. They still have to go through phase one. I don't think you can just concede it in terms of not make the prosecution make its argument and not go through the process. But I think that the defense did the wise thing. They're not wasting their time on something that they have no chance of convincing one juror on, number one. And number two, as a lawyer, everything you do in a courtroom is being assessed and judged. And one of your key attributes as a trial lawyer is your credibility. So I think that the defense, was enhancing its credibility by not wasting time on something that, although a critical phase in the penalty process, was, strictly speaking and frankly speaking, a formality, and everybody knew that.
So, Rick, when it's the prosecution giving 20 minutes instead of 40 minutes, are they leaving anything out there? Because when it comes to phase 2, the jury is essentially being asked to outweigh what the prosecution just did in phase 1 versus what the defense is doing in phase 2. So do you run the risk on the prosecution side of going too quickly or too lenient, knowing that you don't need to bore the jury because you've already proven it throughout the trial, versus what, if the defense goes 2 weeks in the mitigation phase, I mean, that could almost be like, oh, well, we've heard this much, so it kind of weighs this way. How do you balance that? And I don't know if your personal experience of this or from anecdotally what you can tell us, how do you balance how much to give in phase 1 knowing that it has to outweigh what you're about to hear in phase 2?
Well, it's a great question, but the reality is that the government's been trying phase 1 for about the last 7 weeks. I mean, strictly speaking, that's not true. But practically speaking, the government made a very concerted decision to have victim after victim after victim get up and testify. And you'll recall weeks and weeks and weeks of witnesses getting off the stand and walking over to the little model of the theater and pointing out what seat they were sitting in. And, part of that was going to the methodical nature and sort of the overall dynamics of the crime, but really a lot of that was going to the heinousness. Some of the things that Rich Orman spoke of today. You're in a dark theater, you're in a crowded theater, you're in a theater full of tear gas, there's panic, you have no route of escape, the number of victims, the nature of their injuries, the age of some of the victims, the presence of children. What Rich Orman really did this afternoon was essentially synopsize 7 weeks of testimony, much of it going directly to establishing the aggravation. So, I had commented, and some of my colleagues had commented in the past during the guilt-innocence phase, that we really felt that the government was over-trying the case for purposes of securing its verdict. But, it can be looked at another way, and part of what they were doing was setting up not only phase 1, but some of the subsequent phases as well. So I think the government was smart. They also don't want to insult the jury's intelligence. As Rich Orman said when he went through the names on the first aggravating factor, they said basically James Holmes killed, and you found that he killed. I mean, those weren't Orman's exact words. This victim and this victim and this victim. So I mean, the jury, in essence, already made the findings of aggravation. And Rich Orman did what he needed to do, which was simply to put it into the phase 1 penalty context so that the jury can get, this part of its deliberations over with, and so that they can really get to, and all the parties can really get to, the heart of the penalty phase, which is the mitigation, and then weighing the mitigation against the aggravation.
Now, are you allowed to show evidence that you haven't shown previously in the trial? I was looking at some of the photos, and maybe it's just my memory escaping me, but some of those photos did not look familiar to me, to something that we had at least seen on the screen during the testimony part of the trial. So are there rules for that?
Well, you can introduce new evidence because there is evidence that wouldn't be relevant for guilt-innocence that is going to be deemed relevant in the penalty phase. So the answer to that question is yes. But typically you have to do so, through the rules of evidence, and although the rules can get a little more lax. So I am assuming that those photos were in evidence by virtue of the fact that they were shown, but you could be right and I could be wrong, and if I'm wrong, I think the defense was very smart not to get up on its feet and start objecting to the introduction of those photos, which were simply, basic photos of the victims. They would have looked very callous had they done so.
Now, help me understand with the jury that how difficult is it that these alternate jurors continue to join the deliberating jurors, and then they split up again every time it comes to having to deliberate for a verdict, and now they're going to come back together again? I mean, does this happen often in cases, or is this just strictly to cases like a death penalty case or ones that require so many alternates?
It's more because of the death penalty case, they're being kept together, and they are essentially being sequestered but not allowed to deliberate. I mean, talk about the worst of everything. You're on the jury. You've been on the jury for weeks. You continue to serve on the jury, but now you're Miss Kansas, and I mean, unless you're called on to take the role of the sitting Miss America, to torture the metaphor, you're just sitting around waiting. Typically, judges will not release jurors, but they don't have them sitting at the courthouse. They have them on call, and they have the same admonishments not to talk about the case, not to read the newspaper, to be available in case they're needed. They're not typically sitting at the courthouse. So I think that is a function of this case, and of in this case now the capital phase. It's still theoretically possible that we could lose a juror or two, and the reason that these alternates need to be present is they need to be seeing the evidence in case they need to jump in. Otherwise, you'd have to start all over again.
We had two juror issues, one with a family member texting one of the jurors saying the sentencing phase is going to begin next week. That's confusing to me, although if you listen to the judge's admonition, they're never supposed to admit what case they were at, but if the family member doesn't know, I guess after being gone for 3 months basically, that this happens to be the case they're on, then fine, I guess that text is okay, but I can't understand why a family member would text a juror that. And then I got some information over the weekend that just got confirmed with the jury foreman saying he got a random tweet sent to him with an article from Newsweek that named him. My information told me that over the weekend, on Friday, the judge found out about this and had banned Newsweek from the rest of the trial. Of those two instances, is that anything the defense would be concerned with to bring up to the judge on the idea that they're going to appeal something later on?
No, I don't think so. I mean, in the first instance with the family member tweeting or texting or whatever it was, the juror is not breaking the rules. The juror, in fact, is reporting it in a timely fashion to the judge. So I mean, in the society in which we live, that doesn't surprise me, and I think you're exactly right. I mean, I'm sure every family member of this particular juror figured out pretty quickly what trial their family member was serving on. As to the Newsweek thing, that's an interesting question.
Sorry about that, Rick. That you're getting to the good point about the jury foreman, but court is back in session, and we'll try to touch on that a little bit later, but let's get you back into the courtroom.
And the prosecutors are present. We are outside the presence of the jury. Ms. Brady, did you want to, actually before I turn it over to you to discuss the issue that came up in terms of the media before the lunch break. In ruling on the objections to the people's PowerPoint presentation, I think I forgot to rule on one of the objections, which was slide number 49, that I think indicated at least 76 shots and at least 670 individual projectiles. And I think the objection was related to these statements being a misstatement of the evidence. Mr. Orman provided an explanation that satisfies me that it was an appropriate slide. I gave the jury an instruction that says ultimately they decide what the evidence is. The parties can disagree, but ultimately they determine what evidence was admitted. But I think given the explanation by Mr. Orman, I felt comfortable that this was not an inaccurate slide. So I wanted to supplement the record with that. All right, now let me turn it over to Ms. Brady.
We're going to have Ms. Nelson make this argument to the court.
Okay, Ms. Nelson.
Yes, Your Honor. We were able to obtain capture a copy of the tweet itself, as well as a copy of the tweet along with some other tweets from other news organizations tweeting about the tweet. If I may approach your staff with the two exhibits that I've marked as CTR 98 and CTR 99?
Yes, actually, why don't you give them to me first so that I can see
May I
them?
approach?
Yes.
Oh, sure.
Yes.
No objection to the court receiving these, Your Honor.
Okay, thank you. Thank you. Sorry. Ms. Nelson?
Your Honor, this is obviously a violation of Order C-197 that was issued on April 20th of this year that prohibits members of the media from publicly identifying any juror or publicly providing any information that was not disclosed in court, and that could reasonably lead to the identification of a juror. That was an an order that was issued by the court sua sponte. The juror's privacy in this case is obviously an important issue for the court, and it's also important to the parties. And the court has taken many steps to protect the jurors and the jurors' identities in this case. As I stated, it's a concern that is shared by the parties. Ultimately, however, it is the court's responsibility to determine the sanction for this conduct by the media and how to proceed. The defense has several options that it thinks that the court should consider taking. The first would be to ban Newsweek from being present in the courtroom, which is the sanction that the court indicated it would impose for a violation of C-197. A violation of this order will result in the violator and any organizations with which he or she is affiliated being immediately barred from the courthouse and courthouse premises during the remainder of this trial. The court should also consider whether any of the other media organizations that tweeted information about this tweet should be subject to the same sanction. In addition, we think it would be appropriate for the court to consider issuing an indirect contempt citation under Colorado Rule of Civil Procedure 107, and either as part of that contempt proceeding or in addition to that contempt proceeding, consider appointing a special investigator, a special counsel to investigate this issue and how it came to pass that the media got a hold of this juror's information and published it on Twitter. It's ultimately up to the court. It's our position that the court should act swiftly and send a strong and important message to the media that this is a very serious violation. It will not be tolerated, and if the media violates a court order, that there will be severe and serious consequences.
All right, thank you. Anything from the people, Mr. Orman?
Yeah, I'm just trying to think this through, and I don't disagree with what Ms. Nelson said in any particular way. I'm just, and you know, I guess I took con law a long time ago when I was in law school, and I guess I know a little bit about freedom of the press and whatnot, but certainly I'm no expert on that. But so I'm just trying to sort of think through this just legally, step by step. The court, I think, has the power to regulate the people that are in the courtroom, and I would assume that Newsweek was in the courtroom. I believe that is the case. I don't know how they got the name of this juror. It could be that they recognized him. You know, stranger things that happen. It could be that they took information from voir dire and put two and two together and figured it out that way. It could be that somebody told them. There could be a bunch of different ways that they got that information. The court obviously is limited in its power. I see a note being brought in. Do you want me to wait to continue, Your Honor?
No, you can continue.
So, and I don't know what those limitations are. I don't know what those limitations are. So, and I don't know what the court should do.
Clearly, we're having some technical difficulties. Rich Orman right now still making his argument to the judge about what he thinks should happen. And I think we've got the court feedback. Is that what that? Yep, we'll take you back to the courtroom.
And as soon as he became aware of it, he contacted the reporter and had the reporter take it down after he showed the reporter my order, or forwarded to the reporter my order. He was not aware of the tweet, but the information was taken down. The tweet wasn't, and maybe it hasn't been taken down yet, because Ms. Nelson was able to print C-TR, C-TR-98 and C-TR-99. But Mr. McCollum, who's the public information officer for the judicial branch, once he became aware that there was this information out there with the juror 737's name publicly displayed, made contact with that reporter, forwarded a copy of my order C-197. It's my understanding that the reporter and Newsweek have agreed or have indicated to Mr. McCollum that they're not intending to cover any part of the proceedings from here on out. I still think it's appropriate, even notwithstanding that apparent agreement, for me to issue an order banning not only the reporter but Newsweek from being in the courthouse, not just the courtroom, but the courthouse premises, as long as these proceedings are ongoing. In terms of whether any other media organization should be sanctioned, I'm not aware of any other media organization that published the same information or that republished the same information. If the parties are aware of that, I would like to know about it, because that too would be improper. I don't know how Newsweek or this reporter from Newsweek found out about Juror 737's name, but frankly, Newsweek should know better. And it is really disappointing that something like this happened, especially given my order. And, you know, the record should be clear that this case has received a lot of media coverage, a lot of media attention. There have been members of the media sitting here for months, and a lot of them, and they all have been professional. They all have complied with my rules. I think the only incident that I'm aware of that has taken place happened with respect to the contact between someone from Yahoo News and Marcus Weaver, and that was pretty mild too. And so everyone has complied with my orders. Everyone has done what they're supposed to do. And then here's someone who apparently thinks she's special, and she's not subject to my rules, and she's not subject to orders, and she can do apparently whatever she wants. So I'm going to issue an order not only prohibiting her from being on the courthouse premises while the proceedings are ongoing, but prohibiting Newsweek from being on the courthouse premises while the proceedings are ongoing. In terms of any other media organizations, if counsel become aware or are aware of any of them, I would like to know about that. In terms of the request for direct contempt, I actually think it would be indirect contempt, because direct contempt would be if it happened in the courtroom.
No, Your Honor, and if I misspoke, I meant to say indirect. I thought I did, but that's what I meant. Yes.
I may have misheard you. I thought you said direct, and I don't think this would be a direct contempt situation, and Ms. Nelson agrees. So to the extent that you said direct, then to the extent that you said direct, it sounds like that was inadvertent. But I don't think any further action is necessary. I think that issuing an order preventing Newsweek from being in the courthouse or being on courthouse premises while the proceedings are continuing is sufficient. Mr. Orman.
Your Honor, and I am not asking the court to take any additional action, but since I know this, I just thought I would mention to the court. My understanding is that Newsweek actually, Newsweek publishes websites and stuff under different names, and I don't know if Your Honor is referring to a corporation or just that title, Newsweek. I'm pretty sure there's a website called the Daily Beast which I think is owned and run by Newsweek. I mean, that could have changed. They may have sold them. So I just thought I would mention that to the court. It's a strange name, but that is my understanding. So, and I'm not asking the court to do anything. I just thought I would mention that.
Okay, I'm going based on the information that I've been presented, and what I've been told is that it was somebody from Newsweek, and the two exhibits that were submitted by Ms. Nelson, which are C-TR-98 and C-TR-99, have the Newsweek logo on them. So, all right. By the way, the jury has a question. Since I have you here, we'll mark this as question number 1 during deliberations, during phase 1 deliberations. And the question is, the jury requests a TV/DVD player to view evidence, and then it appears to be signed by the foreperson. Do the people have a position with respect to that request?
Well, I think that they should be able to view whatever evidence they want that's been admitted, and I don't remember exactly what procedure the court wanted to follow, and I don't know what the court had in mind about just giving them a DVD player or having them watch it in the courtroom. Different judges I've seen do it different ways. This is the first time this has come up. I have a feeling I know what they want to watch.
All right. Does the defense need a little time before we proceed on this?
That we would like a little time, Your Honor, if you don't mind.
I don't mind at all. I think that's appropriate. Is it okay if I give you about 15 minutes? Does that give you enough time, you think?
Yes, it does.
Okay.
And I just have just a brief further record to make on the issue of Newsweek.
Yes.
Based on what we could tell, just so the record is clear, Newsweek itself has taken down the tweet. However, because of the nature of how this stuff works, there are still secondary websites, including a website called inagist.com that apparently is a website that algorithmically curates tweets based on popularity in real time. And if you Google some terms that are pretty easy to figure out, you can still pull that tweet up on that website. In addition, Mr. King pointed out to me that there's now an article in USA Today already discussing the issue of Newsweek being banned from the courtroom from publishing a juror's name on Twitter. And in addition, as the court exhibit that I provided to the court just a few moments ago indicates, there have been some other news media organizations, including 7 News and Colorado Public Radio, that have also tweeted about this incident. And then if people Google terms that are related to this incident, it would be very easy to still pull up this tweet. So it's a very serious problem, and we think the court should take some further action.
With respect to Newsweek, is what you're saying?
Or anyone who has retweeted this information.
Well, in terms of Newsweek, I continue to be satisfied that the punishment that I have imposed is sufficient. In terms of anyone else who has retweeted it or has republished it, it has to be the juror's name. I mean, if agencies are reporting on the discussion that we're having and what has been brought to light today, I don't think they're in violation of my order. If agencies are publishing any jurors' names, whether they're just retweeting or republishing it, then I think that's a concern. So again, if I hear that there are other organizations that have done that, then that may be a different story in terms of whether I take action as to those other news agencies. But if a news agency is just reporting on what's happening here today in terms of the discussion without mentioning the juror's name, then that's not in violation of my order. So we'll take a break. We'll take 15 minutes, and then I'll give you folks a chance to think about the request from the jury. Mr. Brockler?
Your Honor, may I, just to give the court something to consider in light of where we're at, and if this isn't timed well, please let me know. Just after we broke for lunch, Ms. Higgs was nice enough to bring over a PowerPoint presentation that they'd like to use presumptively for the second phase. And I would make a record about that when the court's prepared, but I have a copy for the court if it would like it in advance of this break.
Okay, yes, please. Any objection to me having that? No? Okay, thank you. Yes. All right, thank you. By the way, the other question, going back to the issue of the juror's name, juror 737's name being published, is whether I should tell him anything in terms of I've addressed the issue or something along those lines. I know that he was concerned and he seemed unhappy with the fact that he was aware that there was an order in place preventing the publication of any jurors' names, and he was also aware that apparently his name was published by Newsweek. So I think it would be appropriate, not while deliberations are going on, but if the proceeding continues, to bring him in at some point and just say, I've taken care of it, and leave it at that. Is that okay with the people?
That's fine with us.
Is that okay with the defense?
Your Honor, we think he should be informed of something. I'm not sure if I'm taking care of it is sufficient, but, or maybe the court has taken appropriate action. But yes, I think he should be informed.
Okay, the court's taking appropriate action is fine too. It sounds like the same thing, but I'll say the court's taking appropriate action. That's fine. Okay, we'll be on break for about 15 minutes. The court's in recess. Thank you.
All rise.
Well, I had information Friday afternoon that this had happened. Early on Friday, one of the spokesmen for the Colorado courts put out an email reminding the media that the jurors were still involved in the case with the sentencing phase coming up, the penalty phase, and to make sure that we're not, that the same rules apply. No identifying anyone involved in the case as a juror until after the jury is complete with all of its service, including the penalty phase. And when I read that email, I said to myself, I wonder if something had happened, but I hadn't heard anything. Later that afternoon, I got information that said Newsweek had published an article and then had retracted it with the name of the jury foreman involved, which made sense because that email got sent out earlier in the day saying, hey, just a reminder, don't do these things. You guys have been good so far. Now, as we're hearing in court, that is accurate. Newsweek did write an article and print an article, posted it, published it online, and tweeted that article link that identified the jury foreman by name. And now they're in trouble for it. Although this trial is being streamed online, so being banned from the courthouse just means that they can't see something in person that they probably were only there once or twice for opening statements and closing statements, or closing arguments. But the judge getting firm with this, not just banning the reporter and the organization from the courtroom, but banning them from the courthouse altogether. Where we're at right now, the jury has a question about evidence that they want to know if they can use in this phase 1 deliberation. And right now we want to show you the argument that took place prior to deliberation. It's Rich Orman telling the jurors essentially why they should move past phase 1 and how the prosecution has proved all of these aggravating factors. So here is Rich Orman from earlier today.
First, I want to talk about the evidence, because as the judge advised you, you can consider most of the evidence that was presented to you in the first part of the trial, all 250 or so witnesses that you heard, with some exceptions. The judge told you about some evidence that was admitted solely for the purpose of determining the defendant's sanity. You cannot consider that. But you can consider all the rest of the evidence, and there were some limiting instructions for that you can consider for a limited purpose too. For instance, some statements and emails that you can consider for the purpose of figuring out what the response to the email meant. You can use that evidence in these proceedings, but not the evidence that was admitted solely for the purpose of determining the defendant's sanity. That is not admissible in this phase, and if I'm talking to you about inferences from evidence, I'm not talking to you about that. I'm talking to you about the other evidence. So I want to put in context these 5 statutory aggravating factors and the evidence that you have heard. So let's talk about aggravating factor number 1. And you have that instruction, but I just sort of typed this out from that instruction, that the defendant intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. So intentionally, that was the same culpable mental state with another part of attempted murder, a murder after deliberation. And then you have this knowingly with universal malice, that's the same culpable mental state that you had with murder, extreme indifference. And then killed 2 or more persons during the commission of the same criminal episode. The defendant killed, and you have convicted him of killing Jonathan Blunk. The defendant killed, and you have convicted him of killing A.J. Boyk. The defendant killed, and you have convicted him of killing Gordon Cowden. The defendant killed, and you have convicted him of killing Jesse Childress. The defendant killed, and you have convicted him of killing Jessica Gowie. The defendant killed, and you have convicted him of killing John Larimer. The defendant killed, and you have convicted him of killing Matthew McQuinn. The defendant killed, and you have convicted him of killing Michaela Medic. The defendant killed, and you have convicted him of killing Alex Sullivan. The defendant killed, and you have convicted him of killing Rebecca Wingo. The defendant killed, and you have convicted him of killing Alex Teves. And the defendant killed, and you have convicted him of killing Veronica Mosier Sullivan. The evidence has shown you that the defendant killed 12 people, murdered 12 people in the course of a single criminal episode. We have proven to you, beyond a reasonable doubt, statutory aggravating factor number 1. Statutory aggravating factor number 2, that the defendant intentionally killed a child who had not yet attained 12 years of age. So let's talk about this a little bit. Intentionally means it was his conscious objective to achieve that specific result. His conscious objective to kill a child who had not yet reached 12 years of age. Well, what do we know about that? You remember the testimony of Dr. Learcall that Veronica Mosier Sullivan had 4 separate gunshot wounds to her little body, and that she was 6 years old. She was shot 4 times by the defendant. 4 times. When you shoot someone 4 times, you do it with intent. And you have the conscious objective to kill them. Also, the evidence shows you that the defendant had the conscious objective to kill everyone in the theater, man, woman, and child alike. And why do I say that? You heard about the hundreds of rounds of ammo that the defendant took to that theater. You saw all of those magazines that he had on him, all those magazines filled with bullets that he had on him. That he went in there with 3 weapons. The handgun, the AR-15, and the shotgun. He went in there with enough firepower and enough ammo to kill everybody. And that's what the evidence shows you he intended to do. And how do we know he intended to kill a child? How do we know that? Well, I'm going to ask you to go back a long way. This trial's been a long trial. I'm going to ask you to go back all the way to April 28th. And you heard from a witness named Chi-Chi Sproul. And what did she tell you? She told you that that theater was packed with kids. Not only that, she said she'd never seen a theater with more kids in it. And if she wanted to sit away from kids, she couldn't find a spot. It was hard for her to find a spot
Judge, I'm gonna-
away from kids.
Excuse me, object, misstatement of the evidence.
Members of the jury, remember that you determine what the evidence is. The attorneys can make arguments and they can disagree on what the evidence was. You need to rely on your own memories of what the evidence was. So the objection is overruled with that cautionary instruction that you're not bound by the arguments of counsel. You need to rely on your own memory of the evidence. All right, you may proceed.
Think about the testimony of Corbin Dates. You all got to remember Corbin Dates. And what did he tell you? He told you that there was a baby, a little baby, in the same row that the defendant was in that theater.
Judge, objection, misstatement of the evidence.
Same ruling, same cautionary instruction.
You heard the testimony about little Mr. Rurs, 3-year-old kid who was in that theater. Again, lots of kids in that theater. The defendant had the intent to kill every single one of them. We have established beyond a reasonable doubt that he intentionally killed a child who had not attained the age of 12 years. Aggravating factor number 3, that the defendant, in the commission of the offense of murder in the first degree knowingly, created a grave risk of death to a person in addition to the 12 victims of the crimes of murder in the first degree. A grave risk of death to someone other than the people that he killed. Well, there's Theater 9. Did the defendant create a grave risk of death to everyone in that theater? I submit to you the evidence shows he did. He brought that gun in there. There he is with that gun, strapped right here. He brought that rifle into the courtroom. And there it is, lying on the ground outside the theater, out back, with the blood of a victim or victims of a gunshot wound right there. He brought in a magazine that could hold 100 rifle rounds. 100. And he used steel penetrator rounds. And there they are, right there on the floor with those green tips, to kill as many people as he could. He also used that shotgun found in the theater right there, and he used that handgun found on the top of his car. And there's all his implements together on the bed, the handgun you can see at the bottom, and the shotgun and the rifle at top. And these are the items that he used to knowingly create that risk that someone else might get killed other than one of the victims of murder. And let's talk evidence was found in the theater, because that's important too. 65 shells for 223 rounds. 5 shells for 40 caliber handgun rounds. And 6 shells for shotgun rounds that each held 100 pellets. So you add all that up, that's at least 76 shots inside the theater. And if you count those shotgun pellets as individual projectiles, which you should, because you saw the way that they spread out and the damage that they did, 670 individual projectiles shot in that theater. Here's the shooting incident reconstruction that Mr. Mills, the FBI expert, showed you, and this is every round where they could find a trajectory in Theater 9 and going into Theater 8. Did that create a risk of death to someone other than a homicide victim? I submit to you it did. Here's one of the rounds, went into that metal pole, created that hole. Person shooting that off in a theater, is that creating a grave risk of death to everybody in there? I submit to you it does. This is another diagram. It's kind of hard to see up there, but maybe you can see it here. This is the shooting incident reconstruction for rows 8 and 9 in that green trajectory. And let's take a look at some of the damage to row 8 there. Those are the rods. Those are the rods from the bullet trajectories in row 8. Grave risk of death to everybody in row 8. I submit to you the answer to that is yes. Row 9. Look how low they are there. Grave risk of death to everybody hiding on the floor. I submit to you yes. That is the back of a seat you heard in row 9. Going through the back of the seat. Grave risk of death. Here's another one. This is the seat bottom in row 9. Look at these holes. Look at what that rifle did. Went through that seat like a hot knife through butter. Grave risk of death. There's a diagram for row 10. You can't see it up there very well. It was better on my computer. You have that back there to take a look at. And there are the rods for row 10, and you can see them for row 11 too. Grave risk of death to everybody there? I submit yes. There's a row 11 seat bottom. You can see that bullet hole. Row 19, almost up to the top. Seat bottom. Grave risk of death? I submit yes. Everybody in Theater 9 that wasn't killed was in a grave risk of being killed, and he knowingly did that. Even going into Theater 8, there's that hallway on the side of Theater 9, the wall going into Theater 8, the trajectory rods. And there they are on the other side, in Theater 8. I'm going to have to click this one manually. And there is the diagram in Theater 8. And as you can see, one of those rounds went all the way across, and you heard somebody got shot way on the other side of Theater 8. Well, I think this ran out of batteries, so I'm just going to do this manually over here. Okay, so consider the injuries. Consider the injuries that you heard about to the people in Theater 9 and Theater 8 in determining whether the defendant created a grave risk of death to these people. And I'm just going to show you some of them. Heather Snyder, grave risk of death. Zach Goldich, grave risk of death. He was in Theater 8. Petra Hogan, grave risk of death. Jamison Toes, grave risk of death. Farah Soudani, that's an injury to her legs. Is that a grave risk of death? And you remember the testimony, how her organs were literally pouring out of her body and had to be held in by hand. Grave risk of death. Caleb Medley, he came in here, you saw him. Grave risk of death to him. Dion Rosborough, grave risk of death. Stephen Moten, grave risk of death. Aden Avia Ariando, grave risk of death, shot in the leg. Yusuf Garbi, grave risk of death. Lean Young, grave risk of death. Bonnie Kathleen Poroso Zogby, and you'll remember her, she came in with the flowers in her hair. Grave risk of death. Ashley Mosier. I know you all remember Ashley Mosier. Grave risk of death to her in the theater. I submit to you there is a grave risk of death to any of them and all of them and everybody else in Theater 9 and everybody else in Theater 8, and that we have proven to you that statutory aggravating factor. Here's the next one. Statutory aggravating factor number 4. That the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And the judge gave you an additional instruction on this, that the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. And you got to consider this individually for each person he killed. So let's talk about that. A conscienceless or pitiless manner, which was unnecessarily torturous to the victims. Were these offenses committed in a conscienceless or pitiless manner? I submit to you the evidence shows that they were. They were. How about unnecessarily torturous to the victim? Well, let's talk about what that means. I would ask you to consider the circumstances of these murders and how that shows you that they were committed in an unnecessarily torturous manner. See, not every murder is going to be unnecessarily torturous. You could kill someone, I guess, in a humane fashion. Were these murders committed in a humane fashion? Or were they unnecessarily torturous? Consider, the defendant modified the environment of the theater by deploying tear gas. There's a can of tear gas right there, clear out. There were 2 cans. This is the one that was found outside. This means that, and you can make a reasonable inference based on the evidence and what you heard happened in that theater from many people, that the victims would experience extreme discomfort from the tear gas in addition to being shot. Is that unnecessarily torturous? I submit to you it is. I submit to you it is. The defendant killed his victims in a crowded movie theater. Now that in and of itself might not be torturous, but think about what that means and the implications of that. They were trapped in there by design. And why do I say by design? Because of the tear gas. And because it's dark. And because it's crowded. They were trapped in there and they couldn't easily protect themselves. And the tear gas made it hard for them to move. Some unable to flee, and you heard lots of testimony about that. Lots of testimony about that. In darkness. In darkness. And they knew, they would have had to know, any human being would know, that there was nothing they could do to protect themselves. Nothing they could do to stop him from killing them, and that death was imminent. So they could think about it. I submit to you that is mental torture. I submit to you that is unnecessarily torturous. In addition to all the images that you saw of how these people died. That is unnecessarily torturous. I would also like you to think about the fact or the inference you can make from the evidence that at the moments of their deaths, the victims would not only be in fear for their own lives, but in fear for the lives of their friends and family and loved ones. And I submit to you, that's even worse than being in fear that you're going to die yourself. That you're afraid that your fiance or your child or your mother.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. My staff has distributed to the attorneys a copy of the request from the jury. I have marked it as jury question number 1 during deliberations in phase 1 of the sentencing hearing. What's the people's position on the jury's request? I think you said already that you don't have any objection to me sending a TV and DVD player to them?
Your Honor, we've looked at some cases on this, and it appears that the court has discretion. But the case I think is, well, it's a Colorado Supreme Court case. It sort of describes the process the court should go to. DeBella, D-E-B-E-L-L-A, versus the people, 233 Pacific 3rd, 664, with the pinpoint site of 666, Colorado Supreme Court 2010. There's a case this year from the Court of Appeals, People versus Riley, R-I-L-E-Y, 2015 Court of Appeals, COA 79. That's that new citation format they have. And it's numbered paragraph 38. And I think what DeBella would say is the court should exercise its discretion, consider whether it would aid the jury and whether it would be unfairly prejudicial for the jury to use it. So I think actually we need to know what they want to look at.
That's what I was looking at in terms of the standard that I'm supposed to apply. I looked at Jefferson, but I'm familiar with DiBella from the Supreme Court, People versus DiBella, which is I think 212 Pacific 3rd, I believe, 666. And I'm also familiar with Frasco, 165 Pacific 3rd at pages 704 and 705. But Jefferson is People versus Jefferson. This is a Colorado Court of Appeals case from 2014. It's 2014 Westlaw 2769104. And it says, generally, a jury is permitted to take into the jury room all exhibits received into evidence, subject to the trial court's discretion to order otherwise. The trial court, however, has an obligation to ensure that evidence is not so selected nor used in such a manner that there is a likelihood of it being given undue weight or emphasis by the jury. This obligation is particularly pronounced with respect to jury access during deliberations to portions of trial testimony and to exhibits substituting for trial testimony. Now, I don't think we have any exhibits right now in the deliberations room that contain trial testimony or substitutes for trial testimony, but the rule doesn't apply only to trial testimony or exhibits that would substitute for trial testimony. It is more pronounced in those situations, but it applies to all exhibits. And in Jefferson, the court said that a trial court must oversee with caution the jury's use of exhibits of a testimonial character, including video recorded interviews of witnesses. Again, I don't think we have any such exhibits back in the jury room right now. Then the court said that the trial court must exercise its discretion to permit, deny, or limit the jury's use of a testimonial exhibit by assessing, one, whether the exhibit will aid the jury in its proper consideration of the case, and even if it would, two, whether a party will nevertheless be unfairly prejudiced, by the jury's use of the exhibit. Ultimately, the court has an obligation to assure that juries are not permitted to use exhibits in a manner that is unfairly prejudicial to a party. So even though that part of the opinion that discusses the two-prong analysis is specifically referring to a testimonial exhibit, and we don't have testimonial exhibits, I don't believe, in the jury room right now, I still think that the most prudent course of action is to apply the analysis now to the jury's request. But my question is, similar to the issue that was raised by Mr. Orman, how can I do the analysis if we don't know which exhibit the jury wants to see? And as much as I am disinclined to want to ask the jury for specific information during its deliberations, it seems like that may be the way that we have to go. But I'll hear from Ms. Nelson. Ms. Nelson, what do you think? What are your thoughts?
We agree.
And so, is it okay with both of you then if I send back a question asking which exhibit or exhibits the jury is interested in viewing?
Yes.
Okay, I will do that. I will state it just like that. And then we will send it back to the jury room, and then I'll give you a copy of that question. And then as soon as we get an answer, I'll let you know, and then we'll have a discussion, okay? All right, the court will be in recess again. Thank you.
We're going to try something different here. I know you're still looking at the slate, but we're going to bring up some more of the survivors that had testified throughout the trial. We're putting stuff together for the 4, 5, and 6 newscasts on 7 News. And so while we wait for the jury verdict on Phase 1, here is more from survivor testimony throughout the trial.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
I was.
Did that go into the early morning of July 20th, 2012?
It did.
Could you please tell the jury about what you remember about the day of July 19th of 2012, prior to going to the movie theater?
Well, we started off our day a little late, but we were spending time together. I was up here on vacation. We went to the Coors Brewery.
I'm going to stop you for a second. Who's we?
We, Jessica and myself.
Who's Jessica?
Jessica Gowie is my good friend of almost 10 years.
How'd you know Jessica?
I met her in high school back in fall of 2002, and so it began. Gosh, we covered a lot of ground in that time, and great friendship. We dated for a while.
Interject an objection under 403 and 401.
The objection is overruled, but ask your next question, please.
What, were you visiting Jessica from another state?
I was. I'm from Texas.
Right. So when had you arrived to visit Jessica?
I arrived, I believe it was the 17th of July.
Of 2012?
Of 2012, yes.
What do you recall doing with Miss Gowie that day?
That day, as I said, we went to the Coors Brewery. We went on a tour, hung out, and we went back to her residence, and we just played catch-up. We hung out by the pool. We just talked like we hadn't got to talk in a while. She had moved up here the year prior, and
An objection 403.
Sustained.
Did you and Miss Gowie decide to go to the movie theater that day?
we did. After much persuasion, she twisted my arm, essentially. She's like, I never thought I'd have to twist a guy's arm to go see Batman. But any which way, we decided to go see the midnight release, and turns out they were sold out of tickets as soon as we tried to buy them. She checked again, and turns out there was a 12:05 showing. So we bought the tickets and eventually made our way to the theater later on that evening.
Do you recall approximately what time you got to the theater that night?
I'm going to go out on approximately, it was probably about 11:40, 11:45.
What'd you do when you got to the movie theater?
We went through the motions. We got our tickets. She had this obsession with this weird popcorn salt stuff, so she got her fix there. We made our way into the theater, and we just sat down and watched the previews. We were walking in as the auditorium was darkening for the previews.
Were you able to tell how full the movie theater was at that time?
It was packed. It was the midnight release, or the premiere night, so it was a very, very full theater.
Where did you find your seats that night?
It was the 12th row, offset to the right of the auditorium, probably 6 to 8 seats in.
So if you're facing the movie theater screen and this is the movie theater screen, were you closer to the right side of the theater or the left side?
Closer to the right side.
What do you recall of doing prior to the movie starting?
We were watching the previews. I remember there was that new Superman movie that was supposed to be coming out. I remember one of the gentlemen in the audience was wearing a Superman shirt, and he struck his little pose, and we all laughed. We were just, cutting up and having a good time, just getting ready for the movie, getting geared up. And, yeah.
What happened during the movie?
We're probably guesstimating 20, 30 minutes in. And I remember hearing a hissing noise coming from the front right of the theater by the emergency exit. And it drew my attention over there, but being that it was dark, I couldn't see anything. Shortly thereafter, I saw what was making the hissing noise being hurled across the theater, and it was going up theater, probably somewhere a row or so in front of us, but off to the opposite side, to the left side of the theater. And I remember there was this brief pause as soon as it hit the area of people, and then this surreal effect happened. It's like a drop of water hitting, and this wave of people just erupted away from where the object had been thrown. And I was kind of puzzled at first, and then the first shot rang out, and I was like, oh, this is actually happening.
What do you recall after that first shot rang out?
Of course, mass panic, chaos, people screaming. We stood up and we started to make our way to the right to exit our row. We got about 1 seat length down the way, and I realized that people aren't moving out of the way fast enough, and I pushed us to the ground.
When you say us?
Jessica and myself.
All right, what happened when you pushed her to the ground?
It was to get cover. The whole time she was saying, call 911, call 911. She was in a kind of a laying down position for cover. I was kind of in a low profile crawling position.
And could you describe for the jury how your bodies were at that point?
She was laying prone, which is stomach down, just flat on her stomach basically, taking cover, saying call 911. Myself, I was kind of in a curled up ball, but like in a crawling type position.
Were your heads closer to the right aisle or closer to the left aisle?
We're both facing the right exit. So, so at that point, I started to feel the spray of popcorn and soda just all around. I noticed her tone changed entirely, transitioned from call 911 to screaming, and I looked down to see that she'd been shot in her right leg. I believe it was right above the knee. As an EMT, I just finished my course, my training, and my first step from there was just to control the bleeding, so I applied pressure to her gunshot wound. Again, there was a continued spray of popcorn and soda or whatever was going on. I felt, I tried to reach for my phone in my pocket, and given my position, I wasn't able to do that, so I straightened out my leg. I kneeled up a little bit to gain access to my pocket to get my phone, and that was when I sustained a shot to my left buttocks.
Are you hearing anything in the background while all this is going on?
Shots continued to ring out. My perception of time was adrenaline slowed things down a lot, but I do recall shots being fired.
Now, describe for the jury the shots that you heard in the theater that night.
Well, as soon as the first shot rang out, it was just a loud bang, and then a pause, and then a bang, and it just continued. As soon as I saw that Jessie had been shot, my focus transitioned to taking care of her. So the shots continued, and I at that point had gotten out my phone, and I fumbled around to call 911 as soon as I could, as quick as I could, but I got some weird busy message on my phone. And so I stuck it back in my pocket. I had noticed at this point that the screaming had stopped, and Jessie had sustained a shot to the head, in which case brain matter was exposed. It was at that point I crawled a little closer to her, and I prayed over her.
I move to strike 403.
Overruled.
You can continue, Mr. Loa.
I didn't really know what to do. It just felt right. I just gave her the best send-off I could. And at that point, my medical technician back, the training had kicked in, and we would count a patient like that in the EMS world as a black tag triage, which means they have injuries that are incompatible with life. At that point, I felt that my own survival was my next priority, and I made my way all the way across the aisle that I was in to the small section of seating that was right above the entrance tunnel to the right of the theater. My strategy was that if the shooter had come back, actually, I skipped a part. While I was laying there with Jesse, I looked up theater, the upper rows, and I saw someone stand up and run out, and I heard no shots fired out. So I figured at that point, if I'm gonna move, now is my chance. So that's when I made my way to the end of the aisle. I sat there thinking if the shooter did come back, I could throw myself over the wall and land down in the tunnel and scurry off, and hopefully I'd have a chance. But the shooter never returned. Somebody cried out, "Somebody please help, please." And at this point, my leg had started to stiffen up a little bit. My adrenaline was wearing off. I remember hollering out and saying, "Just put pressure on it, help is coming." Not very long after, I saw personnel in uniform enter the auditorium, and one of them worked his way up my aisleway and found me there, and I said, "Are you all right?" And I was like, "I've been shot. I think I'll be okay." And he's like, "All right, stay put." And I was like, "Actually, this gas is really irritating me. Is there any way that I could get out of here?" And he said, "Absolutely, let's get you out." So that particular officer and one other helped carry me out of the theater, and they took me down and out that right front emergency exit, where I remember seeing bullet casings all over the floor. I remember seeing a few banana clips. I saw an assault rifle sitting on the ground as I walked out the emergency exit. They carried me out the door and around the corner and laid me on my stomach.
I'm going to stop you right there for a second, Mr. Locke. Did you know what had happened to Jesse at that point in time?
Your Honor asked and answered.
Sustained.
Did you see Ms. Gowie being carried out of the theater?
I did not.
Your Honor, with this court's permission, I would ask Mr. Locke to join me up at the 3D model.
Yes.
All right, Mr. Locke, if you can grab that cordless microphone that's up at your desk there. All right, and if you could turn that on, good. If you could please show the jury where you and Ms. Gowie were seated and tell them which seat's yours and which seat is hers.
Well, she was to my right. This was the row right here, and we were probably between 6 to 8 seats in, so I suspect it was approximation in this particular area. I was sitting to her left, right there. That's where she was. When shots stood up and started to work our way over, it was at that point I pushed us down, so we were down in this particular aisle, and we'd been shot at, and after she received the head shot, and I suspected that the theater was cleared up a little bit, I made my way directly across right here into this little nook, and I was sitting up against this wall, thinking that I could go over the edge if I needed to. And then I was carried out down the stairs and through the emergency exit out the front.
Could you show the jury where you saw that object being hurled across the theater?
It was a few feet in front of the emergency exit itself.
Were you ever able to see any gunshots?
No, I saw a muzzle flash and silhouette.
Could you show the jury where you saw that muzzle flash and silhouette?
In the same area, close by the emergency exit.
Could you describe for the jury where it was that you saw the casings that you remember seeing in the clips?
Pretty much the whole floor, I want to say probably 3 rows or so, all the way to the actual emergency exit itself.
Now, when you exited through there, there's a parking lot that's right behind. Can you show for the jury where you were placed when you got outside the theater?
So there was a wall right here, and I was placed pretty much about right here, up against the wall, laying on my stomach.
All right, I'm going to stop you right there. You can go take your seat. Thank you very much, Mr. Luck. Mr. Locke, without stating what you said or that evening, did you make any phone calls?
Yes, I did.
Where were you when you made those phone calls?
Upon being escorted out of the theater, I called Sandy Phillips, Jessica's mother, and informed her that her daughter had been shot.
Honor, hearsay 403, 401.
Sustained.
Did you call anyone else after you called Miss Phillips?
I called my own mother.
So what happened after you were escorted out of the theater to the back?
I remember seeing there was a lady who had a finger shot off. I remember seeing someone laying on the ground close by my...
Interjection with an objection to 403.
I'll allow brief testimony. So you can answer this question. Actually, I think he answered it.
You saw more than just one victim, Your Honor.
All right. Go ahead, ask another question.
After you observed other injured people behind the theater, did you receive any medical attention eventually?
Eventually I did. They tried to take me to the hospital, and I did assist with triage because I felt somebody was in worse condition than myself. I was probably the third or fourth to last person to leave. I remember hearing one of the officers say, "We're out of ambulances."
Honor, calls for hearsay.
You cannot talk about what other people said outside the courtroom. Okay, all right. You may proceed.
Were you placed in a vehicle to be transported?
I was.
Please describe for the jury what that vehicle was.
The vehicle that was available was a van. I believe it was a supply van. 4 officers carried me, stomach down, over to this van. They opened the back doors where there was permanent fixed shelving. They realized that wasn't an option. Took me to the side, opened up the 2 side doors, and one of the shelves extended halfway into that. I told them at that point, I'm partially ambulatory. Set me down, I'll crawl in. And that's exactly what happened. There was a lady who held pressure on my wound the whole trip to the hospital. I was taken to Children's Hospital where I was admitted.
What happened when you got to Children's Hospital?
The same issues getting me in as getting me out. They were trying to figure out how to get me out, and I told them, yeah, this leg, don't touch this leg, just pull me out, with the other one, grab me and pull me out. They loaded me onto a stretcher and took me into a trauma room where they assessed my wound. They applied direct pressure and tried to stop the bleeding.
Were you taken into surgery?
I was. They realized that direct pressure was not going to stop the bleed, so they put me into emergency surgery where they performed abdominal surgery. They opened me up and repaired the damaged blood vessels, removed a few of the shrapnel fragments, and sewed me up, and went to recovery from there.
Could you please describe for the jury all the locations you were injured?
So I was shot in the left buttocks. I sustained a shrapnel burn to my right bicep. The shot to the buttocks internally hit the wing of my hip, sending shrapnel throughout my abdomen.
Objection, Your Honor.
Overruled.
You can continue, Mr. Locke.
So, as I said, they patched the blood vessels.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes and his attorneys are present and the prosecutors are present as well. I sent back a note in letter format indicating as follows: Dear members of the jury, this is in response to your request for a TV/DVD player to view evidence. Which exhibit or exhibits are you interested in viewing? And then I said sincerely, and then I signed it. The jury responded as follows: in response to which exhibits we wish to watch on DVD, People's 789, which is well, let me read it and then I'll tell you what each one is. People's 789, People's 1023A, People's 400, People's 401, People's 1103. And then it is signed by the foreperson. I have marked that response as jury question number 2 during deliberations in phase 1 of the sentencing hearing, 12 CR 1522. Could you folks please give the attorneys a copy of that? 789 is the video interview of the defendant from July 20, 2012. 1023A is the audio interview of the defendant by Agent Gombiner and Detective Apple. 400 is a theater surveillance lobby video, as is 401 and 1103. All three of those, I believe, are surveillance lobby videos. And just so the record is clear, these are all people's exhibits, so P-TR-789, 1023A, 400, 401, and 1103. To the best of my recollection, 789 is about 10 minutes long. It's short. That's the interview by Detective Mel and Detective Apple that happened shortly after the defendant's arrest. 1023A is about 40 minutes long, I believe. That's an audio taped interview. 400 is a surveillance lobby video, and I don't know how long exactly 400 is. Some of the surveillance videos are longer than others, but I would estimate that the 3 surveillance videos that the jury has asked for amount to approximately 15 minutes at the most. Those are my best estimates. So, based on that, how do the people want to proceed? Mr. Orman, do you want to make a record in terms of the analysis and the standard that I spoke about earlier?
These are admitted items of evidence. I think the jury should be able to listen and watch them, listen to 1023A, watch the rest of them. I think the question becomes how the court wants to do that. I don't think there's any analysis that the court can go through that the jury doesn't get to see this evidence. They want to see it. It's been admitted. It seems to me to be, certainly 789, I think is relevant because the defendant makes a statement about a child in that video. 1023, I don't think there's any questions about the theater at all in that. It's all about the apartment, but so I don't know exactly why the jury wants to listen to that, but maybe they're curious as to whether maybe there was something about the theater in it. I'm not sure. 400, 401, and 1103 are all going to show the people coming in and out of the theater. 400, I believe, would show the defendant walking in and the various people there. I think 401 is the defendant, is all the people fleeing from the theater. And 1103, I believe, is the very brief portion that shows Veronica Mosier Sullivan. So I think all of those are relevant, and the court in its discretion should allow the jury to watch them. The question becomes how, and I would just submit to the court's discretion on that.
All right, and before I get to Ms. Nelson, let me correct what I said earlier. I said that I couldn't remember that the jury had any testimonial exhibits. The jury has a couple of them, at least a couple of them. 789 is a testimonial exhibit. That's the videotaped interview of the defendant shortly after the arrest. And 1023A is also of a testimonial nature, and that is an audio-taped interview of the defendant by Agent Gombiner and Detective Apple. All right, Ms. Nelson?
Your Honor, our request under DiBella, which does grant the trial court discretion to craft the right procedure to assure that the jury does not use these exhibits in a manner that's unfairly prejudicial to a party, would be to have the exhibits at issue played either in the deliberations room or in open court in the presence of the bailiff. that the court instruct the bailiff on the record that the bailiff is to play the exhibits for the jury once, not to speak to the jurors or answer any other questions, and to report back to the court what happened and to put that on the record.
Okay, thank you. First of all, let me go through the analysis that the case law talks about. First, I have to assess whether the exhibits will aid the jury in its proper consideration of the case. And I find that these exhibits will aid the jury in its proper consideration of the case. There's been no argument to the contrary, and much less showing to the contrary. And I believe that all of them would be helpful. The one that's the closest call is the audio taped interview of the defendant, because that interview was limited to the apartment and did not have to do with the theater. But it's possible that the jury is being thorough and trying to review the exhibits, including that one, the one that I just mentioned, 1023A. In fact, that would be the most reasonable inference from the record. And the most logical inference from the record is that that's what the jury's doing. Clearly, the other ones are directly relevant to the determinations that the jury is attempting to make at this time in terms of the alleged aggravators. The videotaped interview makes mention of a sign that refers to children, and the defendant asking a question about that sign. And then the other three videos, 400, 401, and 1103, show they are surveillance videos, and they show the lobby, and they show the people who were in attendance at the theaters at the time, either immediately before the shooting, or immediately after the shooting, or actually during the shooting. And it would be relevant, I think, in terms of seeing whether there were children there, how many people were there, that kind of thing. But specifically, I think it would be to assess how many children appear in one or more of those surveillance videos. The second part of the question of the analysis is whether a party will nevertheless be unfairly prejudiced by the jury's use of the exhibit. I agree with Ms. Nelson that there should be limitations placed. And with those limitations, I am confident that neither party will be prejudiced unfairly, much less unfairly prejudiced. There has been no showing to the contrary, and or even an argument to the contrary by either side. What I propose doing is as follows, and there are different ways to go about this in terms of what limitations to place. Here is the type of response that I would propose, to the parties. Dear members of the jury, this is in response to your request for a TV/DVD player to view exhibits P-TR-789, P-TR-1023A, P-TR-400, P-TR-401, and P-TR-1103. The request is granted. However, the court instructs you that you are not to give any exhibit undue weight or emphasis. Consistent with this instruction, you may only play each exhibit one time. Further, you will only have the TV/DVD player, the TV/DVD player, approximately 75 minutes, which is approximately the length of all the exhibits you are interested in viewing. Finally, you may not play any other exhibits without authorization from the court. If you need additional time, please let the court know. Sincerely, and then you would have my signature. Do the people have a position on that proposal?
Your Honor, I don't. Would you like me to get with my paralegal and sort of add up the times?
You
for that,
can.
so we can get the court a real total number?
Yes, please. My best estimate is that the total will not exceed 75 minutes, but that's just my estimate. And while he's doing that, let me just say that my preference is to not have the bailiff supervise the jury while the jury is watching exhibits for a couple of reasons. Number one, sometimes jurors want to have discussions as they're watching a video or listening to an audio tape, and they would not be able to do that if my bailiffs are present. Number two, I don't think bailiffs should be present while the jury is watching a particular video or listening to a particular audio, and should be part of any of the proceedings where the jury is figuring out what evidence to view and how much time to spend on a particular exhibit. I'm giving them instructions, and I trust them that they will follow my instructions. And my preference is to place limitations and to not have the bailiffs present while they're viewing the exhibits. I think that the better practice, in my view, is to have them do it on their own, but to have limitations placed on them. The truth is that we're relying on them to follow the court's admonishments in other regards, and it doesn't make sense to trust them in that way, but not trust them with respect to these exhibits. And if I limit the time that they have the equipment available to play the exhibits, then I think it forces them to view them only one time, to not be going, to not replay any particular video, and to comply with all the instructions that I'm giving them. Ms. Nelson, I'm sorry, were you going to say something? By the way, you did say indirect when you were talking about contempt, so it was my mistake, not yours. Go ahead.
Thank you, Your Honor. I apologize. We had there was a long list of exhibits that the court read out, and after I made my record, we were thinking some more about them, and it occurred to us that 1023A, which is the audio taped interview, was the subject of motion D-127, and it was our position, and continues to be our position, that interview with Mr. Holmes violated his Fifth and Sixth Amendment rights, and that was the issue that the court ruled came in under the public safety exception to the Miranda doctrine. And so we would object to the jury viewing or listening to that audio tape because we believe we continue to maintain that it was a Fifth and Sixth Amendment violation, and that that would be used in support of aggravation. And so we would also cite to Estelle versus Smith, Satterwhite versus Texas, and Powell versus Texas, as well as the Eighth Amendment in Colorado Constitution, Article 2, Section 20.
Okay.
We also continue to maintain our position that the bailiff should be present.
Yes. Mr. Orman?
Your Honor, thank you. Going through our records, I think the 1103 is the shortest. I think it's like 45 seconds.
Okay.
That one, that's just from memory, but I remember it being very brief. 401, I'm just going to go backwards sort of. 401 is a theater surveillance video. It is 2 minutes, 56 seconds long.
Okay.
400 is another theater surveillance movie, and that is 7:30. 1023A, which is the audio of the interview with Detective Apple and Special Agent Gumbiner, is 32 minutes and 8 seconds. And 789, which is the video interview with Detective Apple and Detective Mel, is 4 minutes and 14 seconds long. I didn't add all them up because I just got the information straight from the paralegal, so if you want me to do that, I can endeavor to figure out how many minutes that is.
That's okay. It's about 50 minutes total, so it's a little less than what I thought. Let me ask you about 1023A. I don't know if you heard the objection from Ms. Nelson. Ms. Nelson is right. This was the exhibit that was subject to Order D-127, which was an issue that was litigated thoroughly and that I issued a lengthy and thorough order on. My concern about 1023A is that it's, of all the exhibits, it's the one that has that is the least valuable, as far as I can tell, for the jury's consideration of the case, at least at this phase of the proceedings.
Your Honor, I can't disagree with that, because there is nothing on that audio that pertains to the theater. So, but, the question is, Your Honor, and the issue I see is, the jury is obviously wanting to be thorough and listen to everything. And I can see a juror saying, I just really need to listen to 1023A to be sure that what's on there, if there's any information that is relevant to any of the issues. I mean, we're assuming that it's for the aggravator number 2. Yeah, we don't know though, right? They haven't said, we wouldn't ask them. We don't know exactly what aggravating factor it is. We're just making that assumption. And I think it's a reasonable conclusion based on the 5 items that they want to watch and listen to, but we don't know that for sure. So I don't believe the court limited the admissibility of that evidence of 1023A. So I hear what the court is saying on that, and I understand the objection counsel's making. I mean, the court has found it is admissible in general. So I would say that the jury should be able to listen to that if they want to, and watch the other things if they want to watch them. I have a response to the question about the bailiff, if you want me to talk about that now, Your Honor.
Sure.
My position is, I was thinking this through. I understand what the court is saying, and I agree with the court that the jury should watch this stuff alone, and if we time it right, they won't be able to do all of the different things that people are worried about of, repeating the same thing over and over again, and pausing and then talking and then going on. The issue of having someone in there, though, is, I was thinking about it, let's say I've had some judges say, if you want to watch a video, you're going to come into the courtroom with the lawyers, you're going to sit in the jury box, we're going to play it in court. And I was sort of thinking through how that would work. Well, we would all sort of be able to see their reactions. The gallery would be able to see their reactions if we were going to do it that way. And the court's not talking about doing it that way. But that's sort of the first part of the way I was thinking this through. So I was thinking through then, okay, what if it's just the bailiff? And the bailiffs then would be able to sort of see their reactions and what their facial expressions were, or their body language or something like that. And I know your bailiffs aren't going to share that with anybody. I don't think they'd share it with you, Your Honor. But they would then have that information later on about sort of the way the jury was interacting with themselves almost, thinking about stuff. And I don't know that that's really appropriate for anybody except those 12 citizens to know. So I agree with the court that the bailiff shouldn't be there. I think that if we time this right and give them an adequate amount of time, they're just going to watch this stuff and they'll be done. So that's my thought on it, Your Honor.
Well, and there's also a risk that a juror might also, the jurors might inadvertently say something in front of the bailiffs. I've always taken the view that deliberations are sacred in a way, and nobody should be part of that. Nobody should see any of the deliberations at any point. I know that the case law allows for that to be a particular method that can be used if the jury wants to watch a video or view certain audio evidence, but I think the better course of action is the one that I have outlined, so I'm gonna stick with that. Let me think about the objection that was made to 1023A in terms of motion D127 and my order D127. Let me think about that for a couple of minutes, a few minutes, okay?
Your Honor, if I can just say one more thing.
Yes.
Regarding 1023A, I just want to put it out there that it's possible, and I'm not saying I believe this to be the case or I don't believe it to be the case, I just think it's possible that the jury wants to listen to that to know about the effort the defendant made to delay the police or other people from getting to that theater, because he talks about that in the conversation with Detective Apple and Detective Gumbinet. One of the aggravating factors is that grave risk of death to others. And it could be the reason the jury wants to listen to that is because some of them may be considering or thinking about whether the effort to divert the police or others to the apartment, which he talks about in that audio, is relevant to the aggravating factor of a grave risk of death to others by potentially delaying law enforcement response and treatment by paramedics, firemen, and so forth. So I just thought I should say that, Your Honor.
All right, give me a few minutes, and then we'll make a decision. Okay, the court will be in recess.
All rise.
All right, please be seated. Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Going back to the Jefferson case, and Jefferson relied on Frasco and DiBella, both which are Colorado Supreme Court cases. The two-prong analysis that I've gone through stands, and there's been no argument by either party that two-prong test has not been satisfied here. And when I look at the aggravating factors that have been alleged, one reasonable possibility as to why the jury wants to listen to the audio recording is to determine whether there was mention of a child in that recording or in a different recording. Another reasonable possibility is that the argument Mr. Orman made, which is that the jury may be focusing on a different alleged aggravating factor, and that is that whether it goes to the defendant knowingly creating a grave risk of death to another person in addition to the victims of the first-degree murders. And there is some conversation in the audio recording about diversion. Another reasonable possibility is that the jury could be assessing the alleged aggravating, the aggravating factor that alleges that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. Again, the discussion on what the purpose of the setup in the apartment may go to whether the shooting was, and the murders at the shooting, during the shooting, were done in an especially heinous, cruel, or depraved manner, and specifically, it may go to the issue of whether there was unnecessary torture. And so given that there's no disagreement, no dispute in terms of that two-pronged test, I continue to find that the two-pronged test has been satisfied. The objection is with respect to motion D-127, and Ms. Nelson is right that that motion was filed, and I ruled on that motion, and as I indicated in my order D-127, it was a close call for me. But the reality is, I ruled that the audio recording was admissible. The audio recording was admitted into evidence and was played for the jury here in the courtroom. So given all that, at this point, the record is made with respect to the defense's objection, but it's an item of evidence that has been admitted, and I will treat it the same way as any other item of evidence that was admitted, as long as the two-prong analysis or the two-prong test in Jefferson and Frasco and DiBella is satisfied. So for those reasons, I will overrule the objection in terms of Exhibit P-TR-1023A. Here is the response that I have drafted. Dear members of the jury, this is in response to your request for a TV/DVD player to view Exhibits P-TR-789, P-TR-1023A, P-TR-400, P-TR-401, and P-TR-1103. The request is granted. However, the court instructs you that you are not to give any exhibit undue weight or emphasis. Consistent with this instruction, you may only play each exhibit one time. Further, you will only have the TV/DVD player for approximately 60 minutes, which is consistent with the length of all the exhibits you are interested in viewing. Finally, you may not play any other exhibits without authorization from the court. If you need additional time, please let the court know. And one time is in bold. So the part where I say that you may only play each exhibit one time, that is in bold font to provide some emphasis to it. I'm going to make a copy of the letter for each party, And then each party will have a copy. Is there anything else at this time on behalf of the people? Mr. Orman? Anything else at this time on behalf of the defense? Okay, thank you. All right, the court will be in recess. Thank you.
And when he came in my visual, he just kind of waved to me, keep going. And I ran out of the theater, and I could see people just sitting outside of the theater, just kind of waiting around. The fire alarm was going off, but I don't remember a sound, just a flash.
When you left the theater, could you still hear gunfire?
No.
Gunfire had stopped by the time you left
Yes.
the theater. Were you ever able to notice anything about your body from that evening?
I remember feeling like warm liquid on me, but I didn't feel any pain. I don't think it was from me. And then I felt something falling on my legs when I was laying down in the aisle, but didn't know what it was.
Did you have any marks on your legs?
A couple of little specks.
Did you need to seek any medical treatment for that?
No.
I have no further questions of this witness. Thank you, Your Honor.
All right. Mr. King, do you have any cross-examination?
I do not, Judge.
All right.
Were you at the Century 16 movie theater on July 19th, 2012?
Yes.
Did that go into the early morning of July 20th, 2012?
Yes.
Now, was that in Aurora, Colorado?
Yes.
What could you tell a jury about what you remember from the day of July 19th prior to going to the movie theater that day?
We had a dog date with one of my buddies.
What's dog day?
No, a dog date.
Okay. A dog date. Okay,
yeah.
What's a dog date?
We just got a dog, and so we were introducing them and stuff. Had dinner with a buddy, and asked him if he wanted to go see a movie with us. He declined, and after there, we proceeded home to drop the pup off.
Who's we?
Me and my wife.
Who's your wife?
Daber Thomas Kazar.
What'd you do after you dropped the dog at home?
Proceeded to the movie theater, and then we had bought our tickets before we dropped the dog off, and then came back and went to the theater and sat down.
What theater number did you go into?
Theater 9.
What'd you do when you got into the theater that night?
We did some people watching, and just kind of was looking around and just seeing who was coming in and stuff like that.
Anything unusual happened before the movie started?
No.
What happened during the movie that night?
Could you ask again?
Sure. What do you recall happening during the movie that night?
So we were sitting there, and we were watching the film, and I saw a figure come through the exit door or into the auditorium. A canister had went into the air from the right side over to the left.
That's if you're facing the movie theater screen?
Yes. And
how would you describe that figure for the jury?
it was black. It kind of, to me, it kind of looked like somebody in a costume, if, from just kind of a glance, I guess. And then,
what do you recall happening after that canister went across the theater?
I kind of chuckled a little bit because I thought that this was, this is the final Batman movie, kind of go out with a bang. And so I saw the canister and I kind of laughed, and I was kind of, pretty stoked about it. And then I saw a pistol come and a flash came out, and was kind of, still kind of riding it a little bit, kind of had some excited adrenaline coming, and then chaos kind of broke in front of me. So So I hit the floor.
Did you smell anything in the theater at that time?
Not at the point that I hit the ground, no. I just heard a lot of gunshots going off. And then from there, I felt some kind of some stinging, some needle like in my calves. Don't really know what it was. And then from there, I smelled tear gas. And I noticed it was tear gas because of basic training in the Army. So it was a pretty quick reference after that of what it was. And it was pretty distinct of the smell that it was.
So what are you hearing at this point in time when you're on the ground in the theater?
I'm hearing a lot of screaming and stuff, and a lot of shots, and then my wife tells me that.
Objection, Judge. Hearsay.
And you can just talk about what you observed. I apologize, Your Honor.
That's okay. The objection is sustained. Go ahead, Ms. Tishman. Go ahead.
You can just talk about what you observed your wife doing without her saying.
She had her hands on my feet, and then, like I said, the shots were just continuing, and so I was pretty much like, the weapon's gonna jam, because the experience of the shooter was not as qualified that I'm used to from the weapons from the military that I've trained in.
So let's tell the jury a little bit about that. So what weapons have you trained in?
Objection, relevance.
Sustained.
Somebody in the section said, "Let's get out of here," and then we crawled. Everyone crawled to the end of the section, and then we ran up the stairs out the upper exit.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1139.
Yes.
Do you recognize that document?
Yeah.
Does it fairly and accurately represent where you recall sitting in the theater on July 20th of 2012?
Yes.
Right, Your Honor, at this time I'd move for the admission of People's Exhibit 1139.
Is there any objection, Mr. King?
No.
Without objection, P-TR-1139 is admitted and may be published.
And Your Honor, actually, this time I would ask for the court's permission for Mr. Kazar to approach the 3D diagram with me with the cordless microphone.
Okay.
All right, Mr. Kazar, there's a cordless microphone up there. You could grab that and come meet me down here. All right, now if you could stay up here with me so that the jury can see. Could you please show the jury on here where you and your wife were seated that evening?
Probably somewhere in this section, one of these 3 rows.
All right, one of these.
No, probably one of these 2 rows.
Okay, and approximately where in here do you think we just pick a row approximately?
Probably about right here.
Okay, and where were you and where was your wife?
I was sitting here, and she was sitting here.
And just for the record, that would be Miss Thomas Kazar?
Yes.
Okay.
And this is myself.
You. Okay. And where was it in this diagram that you saw that canister?
Over in the corner over here, and it came up and landed, I'd say somewhere probably around in this section, maybe up in the handicap, just somewhere around here.
Where was it that you saw the figure of the shooter in the theater?
In this section right over here.
Okay, and if you need to go around a little bit to point exactly where you were?
Probably right in this area.
Okay, is that the only location you saw the shooter in the theater?
Yes.
Okay, and where was the shooter when you saw the shooter with a gun?
He probably kind of approached a little bit into this section.
Okay. Now could you describe for the jury about your exit path as you left the theater?
So we had crawled out over here and then came up the stairs and then exited through the top area around here.
Did you have to stop at any point as you came up the stairs?
Yes, I got caught up probably maybe right in the next section as I was exiting. A woman had screamed, "Help me, I'm gonna die." So I picked her up and put her on her feet and kind of continued to move because I lost sight of my wife and I needed to maintain visual contact with her.
Okay. And then you guys exited through this door?
Yes.
Now when you get to the top here, is there a balcony behind here?
Yeah, it's an upper level.
The upper level? And where was it that you were finally able to see your wife?
Right out the exit door. So, yeah, out. She was like probably on the other side of the wall.
All right, you can go up and take your seat again. Thank you very much, Mr. Sorry, and you could turn off that microphone. What happened when you got to the other side of that doorway and you saw your wife again? If you could tell the jury about how'd you got out of the theater that night?
Well, I was in a different mental state at that point. So a lot of that's kind of fuzzy, but I know I did some motionings and I was just thinking I need to get out of the kill zone. So that was pretty much what I was running off of. I was kind of in a whole different area at that point. I was not in the theater.
You were trying to get yourself to safety.
Yes.
Do you recall having an opportunity afterwards to observe any injuries on your body?
Yeah. When I got to a safe location, I was able to. I saw that my wife's dress was kind of with blood, so panicked a little bit, and I had sustained a little bit of injuries on my calves. And I'm not sure if it was from pellets, maybe the plastic in the seating, or possibly shrapnel. But it got looked at. Everything was fine. So.
And where could you tell the jury where on your legs that was?
It was on the back of my calves.
Is that both your right and left calf?
Yes.
I have no further questions for this witness. Thank you, Your Honor.
Is there any cross-examination, Mr. King?
No, thank you.
Were you at the Century 16 movie theater on July 19th, 2012 in Aurora, Colorado?
Yes.
All right, and did that go into the early morning of July 20th of 2012?
Yes.
Could you please tell the jury about what you remember from the day of July 19th prior to going to the movie theater that night?
Before going to the movies, my best friend, Kaylin, asked me to come over to her house and help babysit Veronica.
Did you guys spend the day with Veronica?
Yeah, we spent the day.
All right. At what point in time did you guys decide to go to the movies?
It was when Veronica's mom, Ashley, and Kaylin's cousin, Jameson, returned to pick Veronica up. And Jameson was the one who suggested going to the movie.
What time did you go to the movie theater that night?
We went to the movies and bought our tickets before, and then we left again to do a few errands. And I don't really know what time that was.
All right. What did you do when you got back to the movie theater that night?
We first, found seats, and then me, Kaylin, and Veronica went to the arcade for a while.
What did you do in the arcade?
We just played some games.
What else did you do while you were waiting for the movie to begin that night?
Me and Kaylin went to the bathroom, and we saw someone we knew from our middle school, so we ran into her.
Do you know that name of that person?
Her name was Peyton Brown.
What else do you remember about that evening?
After that, we went back to the theater and saw someone else we knew, but we didn't know if he knew us. So we kind of tried to get him to recognize us, but he didn't.
Where did you find seats that night in the theater?
It was the third row of the stadium seating, 2 seats in from the right side.
Do you recall the order in which you were seated?
Yeah, it was me, Kaylin, Veronica, Ashley, Jameson.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1133.
Yes.
Haley, do you recognize that document?
Yes.
All right. And does that fairly and accurately represent where you were seated in the movie theater on July 20th of 2012?
Yes.
Your Honor, at this time I would ask for the admittance of People's Exhibit 1133.
Is there any objection?
No objection.
Without objection, P-TR-1133 is admitted and may be published.
Thank you. Could I please have 1133? All right, now there's a mouse in front of you, in front of that computer. Let's see if it moves well. Okay, perfect. All right, if you could point out on your diagram there where exactly you were seated and let the jury know the order of your seats. It's a little sensitive.
Yeah.
There you go.
Okay, this is where I was sat, and then Kaylin is here. Veronica, Ashley, Jameson.
All right. Thank you very much. How old were you on the night of July 19th, 2012?
13 years old.
All right. What happened during the movie that night, Miss Hensley?
Well, the movie began, and I don't exactly know how far into the movie, but the first thing I remember was seeing a canister of some sort go across the theater diagonally.
Now, if this is a movie theater screen, where did that canister start and where did it land?
It began like in the front corner area, and then it came that way to the back corner.
Right, so is that the right front corner?
Yeah, the right, and then it ended in the left.
What happened what did you do when that canister went across the theater?
It was just kind of confusing. At first, it didn't like register as a danger to me, and I don't think it did to too many other people.
What do you remember after that canister going across the theater?
After that, Kaylin pulled me down to the ground of the theater.
At this point, are you starting to wonder if there's some danger in the theater?
Yeah. At this point, I was a little skeptical.
What do you remember after Kaylin pulled you down?
I remember a distinct smell of smoke or some kind of gas. I wasn't very sure. And then I remember loud popping sounds that sounded like gunshots.
Could you describe for the jury how your bodies were on the ground?
I was partially laying on top of Kaylin, and I was kind of diagonally, so I could see kind of very obscuredly through the seats in front of me.
How much of a space did you have for the seats that were in front of you to see through?
Not very much. I would say that much.
I don't know if the record could reflect that the witness is holding up her hands for about 3 to 4 inches apart.
Okay.
What could you see through the seats at that time?
I could see a portion of the screen and the exit door that was in the front right of the theater.
Did you notice anything near that exit door at the front right of the theater?
I believe that I saw a figure come in through that door, or was standing near the door, I should say.
How would you describe that figure to the jury?
Dressed in all black, really, probably wearing a helmet of some sort.
Anything else that you remember about that figure?
Not too much, no.
Did you see that figure actually shooting anyone?
No.
Okay. Anything else you remember about that figure at all? No. So you're on the ground.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We continue to be outside the presence of the jury. The jury, as my bailiffs were about to bring in the TV/DVD equipment, indicated that they were about to send another note, and here is the note. We're going to mark this one as question number 3 during jury deliberations of phase 1 of the sentencing hearing. Our hours will be 8:30 to 4:30, 8:30 a.m. to 4:30 p.m. each day for the remainder of deliberations. And then in parentheses, it says, in all phases. And then it's signed by the foreperson. So they asked my staff that they bring the equipment back tomorrow. So they're on their way. They're about to go home here. We're about to release them, and we're going to release the alternates as well. Let me just make one other record. In terms of the discussion that we had related to DiBella, related to Frasco, related to Jefferson, and that line of cases, the law in Colorado as it stands now is that the rule that I've talked about that is explained in all those cases does not apply to a defendant's videotape statement. And that case is People versus Ferrero, Ferrero, 874 Pacific 2nd, 468. That's a Colorado Court of Appeals case from 1993. So the rule doesn't apply to, and when I say the rule, I'm referring to the rule that I'm relying on to order supervised not supervised, but limited viewing of certain videotapes and CDs. The rule does not apply to either the videotape statement of the defendant to Agent Apple and Agent Mel, and it doesn't apply either to the audio tape statement by the defendant to Detective Apple and Agent Gombiner. Having said that, I still think the most prudent course of action is to proceed as I am. And so I stand by the answer that I said I was going to send back to the jury, and that answer has been sent back, and I think that is the appropriate way to proceed. All right, is there anything else that we need to talk about at this time on behalf of the people? Mr. Brockler.
Up the PowerPoint in anticipation of what we may do tomorrow.
Yes. Thank you. Yes, please. Thanks for reminding me about that. I have reviewed the PowerPoint presentation, and because Ms. Higgs was not aware of the rule that I passed today, I'm going to say that it is exempt from my rule. So it would be unfair for me to apply the rule to her when I just passed the new rule today. So go ahead, Mr. Brockler, what are your objections? And has this been marked yet? We should probably mark it so that there is a record of it.
Yes, sir.
What is the next court trial exhibit? 100. Okay, it will be marked as C-TR-100. Mr. Brockler, you may proceed.
Your Honor, and unaware of the rule too, with the court's indulgence, I may have a small 200-300 slide presentation for tomorrow. I'm kidding, I don't have any. But I do have a question about clarification about that moving forward before I address Ms. Higgs. One is, as the court may recall from what I did in the closing statement, once the jury instructions get finalized, I like to take them and highlight certain aspects of them, whether it's elements or words, and put them into the PowerPoint. With the court schedule and with that rule in place, I guess I would ask for some flexibility with the court in terms of slides that deal specifically with the addition of finalized instructions as they appear on those documents, if the court would be willing to permit me at least that. The other parts, of course, I'll get to the defense.
Yes. I don't think I've heard a single objection by anyone to a slide that contains either an instruction in its entirety or part of an instruction. I don't think that's ever a concern for either party, so I don't have a problem with that. And that rule applies now to, that exception, I should say, applied to both sides, obviously. Ms. Robinson, someone lost something, a juror lost something? Okay.
I'm not seeing it.
All right. If they left it here, it belongs to the courtroom now, as far as I'm concerned. All right, Mr. Brockler, go ahead.
Your Honor, this is a presentation that looks like it is comprised of 8 slides. I have no objection to the first slide or the 8th slide. Slide number 2, Your Honor, appears to be straight-up argument. It looks like, I'm not aware of an exhibit that's going to be admitted during the mitigation phase that contains this. It looks like a motivational poster that has the sun appearing over some clouds with the words "rise above" written across from it. That seems to me to be inappropriate for the 2-minute opening statement that the court has provided us. The next slide also appears equally to be argumentative and contains images and a color scheme that I don't know if it's going to be admitted or not, Your Honor, through any witness, but it seems to contain a previously unadmitted exhibit, and it seems to me to be argument as well, especially given the highlighting with the line of one particular square amidst, it looks like a kind of a bathroom style of tiles across there, Your Honor, and then the arrows. The following slide, again, Your Honor, appears to be argument, but maybe they'll have an explanation for how that exact set of words will come into evidence. The next slide, Your Honor, appears to be a truncated and therefore inaccurate statement of the law. It appears to be that they have taken that poster that the court permitted us to use during voir dire, and that they have highlighted one small portion of it which is not an accurate reflection of the law that the court is going to give. And in that way, it also appears to be argumentative. And I think because the court allowed the defense to use this during voir dire, it becomes somewhat misleading about the authority for it. The next picture appears to be collage may not be the right word, but 5 separate family photos covering it looks like a good chunk of the portion of the defendant's life. I think to the extent that these photos are going to be admitted, and they likely have a good faith basis to believe they are, I do not have an objection to that slide. The following slide contains 3 words. The last word is mercy. I believe the court will instruct the jury on the appropriate use of mercy. I think it will do that even in its introductory instructions. The other 2 words do not appear, I believe, in any instructions that the court intends to give, and they therefore appear to be argument in advance, not what the evidence will show, but in advance of the presentation. And those are my objections to those slides, Your Honor.
All right, thank you. Ms. Higgs?
Thank you, Your Honor. With regard to these slides, I will note that with the exception of the slide with the family photos, these are demonstrative slides. We anticipate that the photos will be coming into evidence. The court is aware that the opening statement, we are allowed to use demonstratives to sort of show the jury what it is that we are talking about. With regard to the last slide, I think that these are all things that the jury is allowed to bring into the courtroom in consideration of the mitigation that we present. So this is not argument, this is part of what the jury will be doing in this phase of the trial. With regard to slide number 5, my preference actually would be to use the board to have your staff bring in the actual board that we use during the course of jury selection to point this out to the jury. And this slide actually shows the full board, but then just sort of brings out step 2, because part of what I am allowed to do in the opening statement is talk to them about how we're presenting mitigation, what that mitigation is. As far as slide 4 goes, this is based on evidence we anticipate will be admitted during the course of the trial. And slides 2 and 3, again, are demonstrative in nature. And these are issues, with regard to slide 2, issues that we discussed with the jury in jury selection. I anticipate this testimony with regard to the difference between serious mental illness and the narrow definition of insanity. That's what this slide represents. We anticipate that testimony to come out during the mitigation phase of the trial, and so I think that this is representative of evidence that we have a good faith belief will be presented during this course of the trial, and there's a significant reason to believe that, because that was also part of the testimony that was discussed by the experts in the merits phase of the case, because the shift now is away from the insanity concept, and that's something we discussed at length with the jurors about someone being able to be sane but seriously mentally ill in the jury selection phase of the case, and that they can still consider mental illness as mitigation even in light of those findings. And so I think it is important for the jury to be reminded of that, and that we will be discussing mental illness now in the context of mitigation. I don't believe I have any other points to make with regard to that PowerPoint, except for this note that I'm getting from Ms. Nelson. Oh, and Your Honor, Ms. Nelson is correct. With regard to slide 2, which is sort of the theme, that was part of the theme that we presented in the opening and the merits phase of the trial. It's part of the theme that we are pulling throughout this whole trial. It's not argument. It is basically us being able to present a theme of our case, which we are allowed to do in opening statement. It is not discussing law. It is not an appropriate legal argument. And I would note that it wasn't objected to in the merits phase opening as well.
What does that refer to, rise above? It says rise above.
Correct.
And it shows, it's a picture taken from above the clouds. It shows the sun. What does that refer to?
So one of Mr. King's themes in his opening of the merits phase of the case was this idea of reaching higher ground, rising above, to be able to separate oneself from sort of the emotion, the inappropriate emotion and attachment that we've talked to the jury about that they're not supposed to have. And so this demonstrative represents that theme. Does the court have any additional questions?
Yes, the slide that says serious mental illness, you said one of your experts is going to say that this is an accurate representation of insanity as it relates to serious mental illness, an accurate graph, is that right?
No, what I'm saying is this is a demonstrative of the concept that insanity is a narrow part of mental illness. That was something that was discussed in the merits phase of the case by several doctors, that insanity is just a narrow focus, whereas serious mental illness can be much larger than that. It's actually also something that the prosecution noted, and it's something that we discussed with the jury at length in individual voir dire. So this is just a graphic representation of that concept, and we are allowed to use demonstrative slides to represent concepts without them actually being able to be introduced into evidence.
All right, is there anything else? Mr. Brockler, it's your objection. I'll let you have the last word.
Thank you, Your Honor. I think it sounds like in the discussion that this is really just a theme that they want to replicate. One, I don't remember any clouds in Mr. King's opening statement. And I don't know if rise above was something he said or if it appeared in his opening, but that's neither here nor there. The court will recall that it made us, on a victim impact video, remove things like rainbows and clouds and stuff like that because of the potential prejudice here. And this feels like more than thematic. This feels like an argument, and I think Ms. Higgs concedes that when she says what we want to remind the jury is to rise above and to separate themselves. That's not what the evidence is going to show. That's not what the court instructs them to do when it's giving this instruction. That feels like, at best, it may be available to them in argument, but not in an opening statement that the court has described. This idea, too, with the third slide, that a demonstrative exhibit, because it demonstrates something, therefore they're allowed to publish it to the jury in the form of an opening. Judge, I think what the court was struggling to get from them was the idea of, is someone going to lay the foundation for this demonstrative exhibit? Simply announcing something as demonstrative doesn't make it so. And it sounds like no witness is going to provide any foundation for this to be presented to the jury as an exhibit. We're just going to say this highlights what we believe the argument to be. And the problem is, this, the way they've displayed it, is it appears to quantify what insanity is in the scheme of serious mental illness. And in the absence of testimony to provide further foundation, it's not only misleading, but it is argumentative, and it would not likely be displayed to the jury at any time as demonstrative. Judge, I don't think that, and I've skipped over the slide that says but for. They've said that they think a witness is going to testify to that, and they have a good faith basis to believe that. That is what it is, I guess, Your Honor. In terms of the next slide, which deals with step 2 mitigation and the request to bring out to the jury the instructional, for purposes of voir dire poster, Judge, that's not appropriate. This court has moved past the general concepts that would be described to the jury for purposes of determining who could sit on this case and to facilitate questions about them so that they have an understanding of the process. We are now instructing them on specifics of the law, and this isn't it. This isn't what the court's going to instruct them, and it's not appropriate, I think, Judge, to bring it back out and to allow them to reference it either on the slide or with the poster board. And then I didn't understand Ms. Higgs' argument, respectfully, Judge, about jurors get to bring compassion and understanding with them into the jury box. That's been true, I suppose, without being spoken in every phase of everything ever, but that's not what the court's going to instruct them on. The court is going to instruct them on one of those words, and that word is mercy. And to the extent that they think that this slide with the word mercy will help them to describe for the jury what evidence they will see, that's one thing. But they're not allowed to argue to them how to view the evidence, what weight to give the evidence, or any of these emotional words that they want to bring to them before they start to hear the evidence, Judge. Other than those things, Your Honor, it still feels like slides 1, 8, the but-for slide, which I believe is slide 4, and slide 6 are the only ones that remain that are not objectionable, Your Honor. Thank you.
All right, thank you. In terms of the first slide, I agree with Mr. Brockler that this is an inappropriate slide. This is not appropriate for opening statement. It may be a theme that the defense wants to pursue, but this is a picture that, as I said, appears to be taken above the clouds with the sun shining in the background, and it says rise above. And and then apparently the defense plans to tell the jury that they need to rise above any emotions that they may feel and things to that effect. My recollection is that counsel wanted opening statements or an opening statement in phase 2 because they wanted an opportunity to introduce to the jury what mitigation they were going to be hearing about. And I felt that that would be helpful, that it would be helpful for the jury to know what mitigating factors to expect evidence on. It would be helpful, frankly, for the court, and frankly, I think it would be helpful for the parties to hear that in advance. That's why I granted 2 minutes to each side for an opening statement. It wasn't so that a slide that says rise above could be shown. In terms of the next slide, the problem I have with this, the concern I have with it, and this is the one that has insanity, and insanity is one tile, and then the rest of the tiles in this large circle appear to be serious mental illness. I think that this gets into the law to some extent, and it gets into the definition of insanity, and it gets into the role that mental illness plays in relation to insanity. And I don't know that this is an accurate statement of the law. And given that apparently there's not going to be an expert who is going to say that this is an accurate diagram and an accurate representation of insanity within the world of serious mental illness, I have some concerns about this confusing the jury or misleading the jury. And I also have concerns that this is part of the province of the court. It is the court's duty to instruct the jury on the law, so I will sustain the objection with respect to that. The next slide, but for serious mental illness, this would not have occurred. This has been a theme throughout for the defense, and I think it's appropriate, and I will allow that. The next slide, in terms of the request to have the board here, I don't think it's appropriate for the opening statement in phase 2 because the opening statement for phase 2 should focus on phase 2, not on the entire sentencing hearing process. That's number one. Number two, to the extent that the jury is going to be shown anything related to the process or the law that applies in a sentencing hearing, it should be consistent with my instructions. It should be the words that I'm using in the instructions. The part that says step 2, mitigation, any reason for a life sentence over a death sentence, I'm not sure if that's exactly how I'm saying it in my introductory instructions, but it's fairly close. But what I would request is that whatever words I'm using in my instructions is what counsel used so that we don't confuse the jury. So in general, I don't have a problem with a slide that even shows phase two in the context of all the phases, just to show where phase two fits in. I don't have a problem with that, but use the words that I'm using in my instructions. And specifically, for example, this says step 4. There is no step 4 in the instructions that I'm giving the jury, so that should be avoided, again, so that the jury doesn't get confused about there being a step 4. But to the extent that it can be modified, consistent with the comments that I just made, I don't have a problem with a slide that shows, look, here's phase 2, here's where it fits in relation to the entire process, and here's what phase 2 is about. And obviously, the comment should be related mostly to phase 2. It should be focused on phase 2, but it can be placed in context of the entire 3-step process or possible 3-phase process, just so the jury gets the picture. The next one is one that says James Eagan Holmes, and it has 5 pictures. Ms. Higgs is representing that these are going to be introduced, and I don't have a problem with those being shown in opening statement. And the final one says compassion, understanding, and mercy. It seems to me that compassion and understanding is part of mercy. And what I don't like about this particular slide is it makes it seem like these are 3 separate concepts. I don't believe that any of my introductory instructions talk about compassion or understanding. I don't believe that the law refers to compassion and understanding. And again, I worry that we're going to confuse the jury, and so we should be consistent with my instructions. If you want to include mercy, and if you want to say that compassion and understanding are part of mercy, I think that's fair. But to set them apart as though they're 3 different concepts, and these are 3 concepts that the jury can consider in making decisions, I think is problematic, because I don't think it's entirely consistent with the instructions that I'm going to be giving the jury in terms of the law that applies. So those are my rulings with respect to C-TR-100. Is there anything else at this time on behalf of the prosecution, Mr. Rockler?
No, sir, thank you.
Is there anything else on behalf of the defense, Ms. Higgs?
Yes, Your Honor, I'd asked the court to give the prosecution a deadline. We were able to give them our PowerPoint, and they were able to have it for most of the afternoon. I don't want to get theirs at 8:30 tomorrow morning and have to be arguing it at 8:31, so I'd like to have some time frame for that, please.
Are you using a PowerPoint presentation tomorrow?
No, sir.
Or for your opening statement, if there is a phase 2?
No, Your Honor.
Okay, all right, so there's no PowerPoint presentation. Great.
Thank you.
All right, thank you.
I think Ms. Nelson has.
Oh, one more thing. Ms. Nelson and Mr. Orman, remind me that when deliberations are over with respect to phase 1, I need to bring in juror 737 just to finalize the discussion we had about the Newsweek issue. And I just want to make sure he knows that I've taken appropriate action. I'm going to leave it general because I think that's appropriate, but I want to make sure you remind me to do that, okay? Ms. Nelson.
Yes, Your Honor. Just along the same note, I wanted to submit the printout of the website InAGist from inagist.com that had captured the Newsweek tweet as a court trial exhibit. I've marked it CTR 101, and I will provide that to your staff.
Okay, thank you. Anything else, Ms. Nelson?
Not from the defense.
Okay, great. Have a good evening, folks. I'll see you tomorrow morning. The court will be in recess. Thank you.
Good evening. I'm Anika Padilla. Thanks for joining us for our continued live coverage of the Aurora Theater shooting trial. We are now in the sentencing phase. Today was a little bit of an unusual day, some interesting developments, not quite what we expected. We thought by now we would certainly hear from the jury on their decision on the first phase, whether to continue and move on to phase two. Instead, we had a lot of different issues, one involving a juror 737, a former Columbine student and shooting survivor, gave a note to the judge saying that someone had brought to his attention that Newsweek had tweeted his name and identified him as the foreman of the jury. We left that issue alone for a little while. When we came back from lunch, the defense team brought that up again, said they wanted Newsweek, the entire organization, banned from the trial, from the courthouse grounds premises for the length of the trial, the rest of the proceedings. And they also wanted the reporter held in contempt and wanted an investigation started. Judge Samore said he was not going to hold the reporter in contempt, excuse me, but he did agree to ban Newsweek from the courthouse grounds for the rest of the proceedings. And Newsweek's managing editor did respond to that on Twitter and owned up to it, said it was just a huge, embarrassing mistake, and they deserved the ban. So now we have our legal expert, Rick Kornfield, on the line, and we just wanted to get some input from you on what you thought of today's proceedings.
Well, I think today was an interesting day. I mean, first, I was very surprised that the jury did not return a verdict on phase one for a couple reasons. Number one, it's really uncontested. I mean, the defense didn't literally confess it. They still made the government make its argument, but by putting on no evidence, they essentially confessed it. And the government, as I talked about at the last break earlier in the afternoon when I was on, the government essentially spent a bunch of the last 7 weeks putting on evidence of these aggravating factors. So why the jury is taking as long as it is in coming to this surprises me. That said, I don't think any trial lawyer is ever critical of a jury that is thoughtful, that takes its time, that takes its job seriously, that goes through all of the instructions. So I am not at all faulting the jury. It's just surprising to me, sort of given that this is, for lack of a better phrase, the gimme part of the sentencing phase. That surprised me. In terms of the Newsweek thing, very kind of interesting. A bit of a sideshow. The defense is doing what it needs to do in terms of ensuring that its client is getting a fair trial by trying to make the media adhere to Judge Samore's various rules and various admonishments. So the court really did all that it could do with respect to punishing Newsweek by taking it out of the courtroom and out of the courthouse. Should they or shouldn't they? Should the court or shouldn't the court have instituted an investigation? I think Newsweek owned up to it, and the fact that they found out the name. You know better than I about the strength of the First Amendment in this country, and so that probably would have been a waste of time and money. But Newsweek, to its credit, owned up to it. The court, punished it for its misdeeds, and the defense did what it needed to do in terms of making its record and voicing its concerns. So, those were probably the two biggest things, in my opinion, today. And I think what's going on now is that the lawyers are anticipating a phase two, and they are getting ready to put on. The defense is getting ready to lining up its witnesses, and will be ready to go, I'm assuming, as soon as tomorrow.
Rick, were you surprised at all that the defense chose not to make an opening argument after the prosecution, after Richard Orman presented his argument? Not
really. They didn't really have a lot to say. And so I think that they are saving their powder, so to speak, for the next two phases. And I think, as I said the last time I was on earlier today, everything you do in a courtroom as a trial lawyer goes to your credibility. You are being judged every single minute. People are looking at you. I mean, in this case, you're being looked at on television, but I'm talking about the jury. The jury is always looking at you. The jury is interpreting what you're doing and the decisions that you make. So I think the defense is really concerned about the credibility of its arguments. And as a litigator, you want to litigate over things that you have a chance of prevailing on. Finding one juror who will not find one aggravating factor beyond a reasonable doubt is a complete waste of time. So I think the defense did the smart thing, and that is basically, not alienate the jury by trying to argue something that they really don't have a good argument based on the state of the evidence, and instead maintaining its credibility and focusing on the mitigation. And that's where they can hopefully, from their perspective, do some good work for Mr. Holmes, their client.
All right, thank you very much, Rick. And we are going to go ahead and wrap up for today. Court will resume again tomorrow at the regular time, 8:40, and hopefully then we will hear from the jury and get their decision on phase 1 of the sentencing hearing and potentially move on to phase 2. I'm here in the 7 News studios in Denver with Phil Tenser and Andrew Altenburn, and thanks again for joining us today. We'll see you tomorrow.